No, that's just Rob. He's just making it, starting the live stream. You're fine.
Yes, that would be nice.
He's been logging on and off, trying to get his camera to work.
Oh, okay, well, if he, his topic, we should start with here.
Okay.
It's a weird position.
Good morning. Thank you.
Yeah.
How are you? I'm good. I know, huh? Thank you for coming.
I mean, certainly I will try.
I was just thinking, I was hoping more yes. I have to choose for you. Oh, that's okay. Here, we can, yeah, you can take it.
Sure.
No, well, Jim might sit there eventually, but he's going to be down there for a while, so this is our home.
Never mind, I was wrong. Wrong? It's virtual, so of course, I can't.
Got it. Okay.
The volume up a little bit for the people in the room. Yeah, we have so much to talk about. We're here.
Yeah.
We have so much to talk about.
I know, we're just gonna get it done, turn something
We'll
in.
talk. We
Okay.
gotta talk.
Oh, yeah.
We already got so much to do.
Good.
Nice.
I didn't quite understand.
I don't either. Oh, I
Go
guess,
ahead.
I was just saying you go by.
I'll tell you that too.
I will call you. Yeah, I wouldn't respond to either.
But thank you for, I mean, it's important, of course, but there's more, so I'll tell you more.
Gregory Parks, if you're able to hear me, can you start your video, please? I see you're logged on, but we're not. You need to start your video so we can actually hear you.
Yeah, I'm only slightly panicked. I was pretty panicked yesterday. I called Maddie last night. So I did work on it.
Is he back or not? Can't see him? Okay. Oh, okay. That's fine, well, we can, I mean.
They're trying to figure out. They're trying to do something.
Are you moderating this?
And it's really hard to schedule this time and say you're next to like a dinner.
Good morning, John.
So I was able to live, but I had to do it.
Is it time?
No, Amy did. But I feel like I didn't know I would need somebody to drown until yesterday.
Brian's actually picking us all up.
And so then it's
He's going to start talking and
so
then
after
switch it out.
then I'll run that.
Sure.
Procedure
Just, over the microphone.
class that just graduated last year, which I miss, but they don't need me.
Yeah, Andrew.
You got Mike to do
Yeah, I'm
it.
gonna watch you next time.
Oh, sure, well, we'll see how we can.
Couldn't have anyone better. I'll tell you,
Otherwise, I don't know.
to be teaching,
You just go to whoever raises their hand.
which I enjoy, but it's not the same,
So,
especially having been involved in lots of
show up. Oh, yeah.
That's coming to an end with the new commission.
Uh-huh.
Be a resident of the city. Which I think makes sense too.
Maybe it's the Russians conducting a cyber attack.
I was
good, but you're.
For interesting times.
Fortunately, I think there wasn't a lot left to do
Okay, good.
necessarily between second and third, but enough that Sunday would be very long. If I'm being honest, I was in 2 days leading up to the second draft deadline, so I really haven't put the amount of time I would like to put into it.
Yeah, but this is.
No, well, don't say that. No, yes, you certainly can. I think the issue may be that you're concerned about writing a good quality note that's accurate, well, sourced, and I was concerned about. Sentence.
Yeah, because you have to go.
Sources later.
Right, yeah.
Not so for law. So hyper specific for every sentence, I will forget.
Yeah.
But I feel like a great sense of anxiety every time I write a sentence without a footnote.
Yeah.
I'm like, is this enough of an argument to get by? We could tone it down a little bit.
Yeah, I know. I think like we should.
X is true, and I say because of X.
All text gone? We're all good? All right. Okay, great.
And Y is an argument. Like,
Good morning, everyone. Good morning. I'd like to welcome you to this wonderful symposium and to invite our guests who are here virtually and to welcome also our panelists who are here in person as well as virtually. We were really proud to put together this panel, and we were really proud to have you here with us. I want to thank first and foremost Professor Hardaway for her wonderful efforts at putting together, conceiving, and executing this wonderful symposium. We're looking forward to. I would also like to thank the Law Review and its members for their work and help in assisting us today, also in their efforts to work with the presenters and the panelists to publish their works in the journal. We're really proud to present this program to you because this issue regarding policing, particularly as it regards policing within our communities and communities of color, has been an issue, a burning issue for decades, if not centuries. Since the early 70s, some law enforcement scholars, politicians, and reformists have presupposed that increasing the number of Black officers, for example, in police forces could be an important tool in improving relations between police departments and communities of color. We all witnessed and were a part of the racial reckoning of 2020, which ignited a national conversation about the myriad structural flaws in our policing systems. And then in the few prior years, the mass sustained social uprisings in response to the killings of George Floyd, Breonna Taylor, and so many others, too many others, feature several examples of officers of color in enforcement roles. Now, in addition, the continued advocacy around reform of policing systems revealed the persistent instances of racial discrimination endured by Black and brown police officers inside and outside of the departments. To be sure, inter-department discrimination has long been a feature of the departments. And while affinity law enforcement associations began in the mid-1900s in their efforts to support and empower officers from underrepresented racial groups, those groups today still lack collective bargaining rights or power by which to support the interests of the members to implement structural reforms. So the themes of Black officers, brown officers, and minority and minoritized officers in police departments, and the structural and systemic barriers that they face will be the topics that we'll be addressing today. I just want to thank you for being here, to welcome you to Case Western School of Law, Case Western Reserve University School of Law. And now I will turn it over to Aisha Hardaway, who will make further remarks and open up the panel.
Thank you, Dean Adamson. It's truly been a pleasure to work with you in planning this event, as well as many other exciting developments that are happening within our law school, so thank you. Good morning. We're small, but we're mighty. At least we're small in person, but we're mighty. I'm not surprised it's early on a Friday. I imagine that we will fill out as the day goes on. Thank you for joining us. As director of the Social Justice Law Center, I am delighted that you have all decided to be here for today's symposium, Black and Blue. The aim of today's discussion is to explore the many roles that race plays in American policing. And I'm certain that we're primed for a thought-provoking conversation that will hopefully stimulate and feed all of us who are interested in understanding American policing and the many ways in which it has missed the mark when it comes to the lives of Black, Native, and Brown communities. Of course, we know that race alone is not the only factor present in problematic policing and policymaking. Instead, in the words of the brilliant writers of the Combahee River Collective Statement, there are interlocking oppressions. And so our discussion today also includes presentations about the role of gender and citizenship status. I'm also delighted that in addition to the academics who are present to participate in today's symposium, we will have practitioners, if you will, who have been officers and also academics as officers to talk about their experiences as police officers. We have 2 members of Cleveland's Black Shield Police Association. And as Dean Adamson was mentioning earlier, we know that Black police associations have existed since the late 1800s with 2 goals in mind. One, to protect their communities from the terrors of white violence, and 2, to protect and try to get access to jobs inside of police departments in order to protect themselves from discrimination and the like from their colleagues. And so we are grateful that you're going to hear from both academics and practitioners, if you will. I think that's really important when we have any of these conversations. And then also this keynote. We are in for a treat during our lunch keynote. I'm going to leave it at that. We have Ms. Carrie O'Horn, a former officer with the Buffalo Police. She's going to share with us her story and also her advocacy towards the passage of, that led to the passage of Carriel's Law. And with that, we will start with our first panel. And I think I'm in charge of doing the introduction, so I will stay here. And I'm going to do the bios of the panelists in the order in which I anticipate you guys will present. My hope is that Dr. Parks is online. Are we able to confirm that?
I am online.
Oh, wonderful. Dr. Gregory Parks is Associate Dean for Strategic Initiatives and a professor of law at Wake Forest University, where his research focuses on both race and law issues, as well as social science and law issues. While generally interested in the application of cognitive and social psychology to law, his work to date has specifically focused on what implicit attitudes and biases portend for the law. Professor Parks' scholarship also focuses on Black fraternal networks and their relation to the law, e.g. biographies of prominent African-American lawyers and judges who were or are lifelong members of these associations, the role of these organizations in African-Americans' quest for social justice and civil rights, and legal issues around violent hazing within these organizations. Dr. Parks has authored or edited nearly 10 scholarly books, And he's currently working on a book with Cornell Law professor Jeffrey Rashlinsky on unconscious race bias in law under contract with Oxford University Press. Dr. Parks has also authored more than half a dozen law review articles. He's been a visiting fellow at Cornell Law School and a law clerk on both the United States Courts of Appeal for the 4th District and the District of Columbia Court of Appeals. Our next presenter will be Professor Kike Stark, who is an associate professor at the Alexander Blewett III School of Law at the University of Montana. Professor Stark is a former president of the Minnesota American Indian Bar Association, a Bush Foundation Leadership Fellow, and an alumnus of Hamline University School of Law. A Turtle Mountain Obweze, member of the Bijou clan, and a practitioner of indigenous law, Professor Stark has a firsthand experience in training students in how to work productively with indigenous principles and procedures. He has built institutions grounded in Anishinaabe law and helped students and communities forge better relations between indigenous and non-indigenous institutions and peoples. My tongue worked before I stood under the lights, I promise. Professor Stark worked as an adjunct faculty member at several institutions and an assistant professor with the American Indian Studies Department at the University of Minnesota Duluth. He taught courses in federal Indian law, natural resources, tribal government, tribal sovereignty, treaty rights, and American Indian diplomacy, focusing upon the law and policy underlying indigenous legal orders. Next, we have Professor Delgado. Professor Richard Delgado received his AB from the University of Washington and his JD from the University of California, Berkeley, where he was a notes and comments editor for the California Law Review. Before coming to Alabama in 2013, he taught at the University of Pittsburgh, Colorado, and UCLA. He's the author of over 200 journal articles and 20 books. Professor Delgado's work has been praised or reviewed in The Nation, The New Republic, The New York Times, Washington Post, and The Wall Street Journal. His books have won 8 National Book Prizes, including 6 Gustavus Myers Award for Outstanding Book on Human Rights in North America, the American Library Association's Outstanding Academic Book, and a Pulitzer Prize nomination. Professor Delgado's teaching and writing focus on race, the legal profession, and social change. And if you were a student with me in Dean Itten's classes, you learned that Professor Delgado is also one of the leaders of critical race theory. So we are really, really honored to have Professor Delgado with us. Along with Professor Delgado, a co-author on his piece that will be published in the Law Review Symposium is Alan Slater. Alan Slater is a law clerk for the Honorable Rebecca Fryer at the Colorado Court of Appeals. He graduated from the University of Alabama in May of 2021. In law school, he worked as a student attorney in the Criminal Defense Clinic and completed several internships with organizations focused on civil rights, privacy issues, and criminal justice reform. His scholarship has been published in the Maryland Law Review, UC Davis Social Justice Law Review, and the Berkeley Journal for African American Law and Policy. Before law school, he had a 7-year public safety career, serving as a correction officer, a police officer, and emergency manager. His academic interests lie in the intersections of policing, immigration, and privacy. Please join me in welcoming all of our panelists for our first conversation. Thank you.
Good morning. My video is not working, but should I ask to share my screen if possible? I do have slides.
I think we got it. Should have access, Dr. Parks.
Or if not, yes. Not readable, that's okay. There you go.
Gregory and Alicia, would you like for Ellen and me to go first, and that way we'll give Gregory a little time to try to get his.
There we go.
Okay, you got it.
Thank you for volunteering for Professor O'Connor. Hi, my name is Gregory Park, and first and foremost, let me thank Professor Hardaway, Dean Anderson, Mr. Tyler, Kate Weston Reserve Law Review, most importantly, the students who work on the law review. I know it's a demanding job, and it's often a thankless job, and I thank you. It's a privilege to be on a panel with such distinguished scholars, especially Professor Delgado's work has inspired me and my own work for many years. I want to offer my perspective and hopefully some insight with respect to a topic I've been thinking about for many months, even prior to law reviews, a proposed symposium for today, and which has resonated even more with me on the anniversary of January 6th. As an aside, but I think importantly, I do a lot of martial arts, and I teach martial arts, and quite often I have a lot of students who are former military or current law enforcement, and the one thing that came to mind as we led up to January 6, 2022 was the question of would they acknowledge the dead? And to a person they didn't, which surprised me because they all believe that blue lives matter. So it underscored my thinking as I'll articulated in this in my remarks today. I want to talk about the idea that white supremacy, more than black lives, and even more than blue lives, matter, and what lessons can be drawn from the insurrection on January 6th. The origins of the Black Lives Matter movement can be traced to its roots in social media, specifically to a Facebook post by Alicia Garza in 2013. The phrase itself originated from her post titled "A Love Letter to Black People," which served as a message of unification and strength following the acquittal of George Zimmerman and the murder of Trayvon Martin. At the end of her message, Ms. Garza wrote, "Our lives matter," which later transformed the renowned social justice movement. In the same year, organizers Opal Tometi and Patrice Cullors joined Garza in starting the movement, forming the hashtag Black Lives Matter to accompany the national discourse surrounding police killings of blacks. After coining the hashtag, the group set out with the goal of promoting a movement seeking to build a social media platform on Facebook and Twitter as a space in which activists could connect with one another. Though the movement began in 2013, its audience was small, and it was not until 2014 that its use began to increase, following the police murders of Michael Brown and Eric Garner. Later in 2014, after the acquittal of a police officer in the shooting of Mike Brown and the murder of Tamir Rice, social media mentions of Black Lives Matter, the hashtag, spiked to more than 170,000, according to a Pew Research Center assessment. Following the recurrence of law enforcement's murder of blacks and their acquittals, Black Lives Matter hashtag soared popularity. While the civil rights movement was a quest for democracy led by organizations that failed to function democratically, critics argue that it focused too heavily on the movement's leaders, that being Black Lives Matter, something that the BLM aims to change. Three founders implemented a horizontal method of organization favoring democratic inclusion at the grassroots level. In December of 2014, NYPD officers Rafael Ramos and Gandu were killed in Brooklyn, New York. As such, Blue Lives Matter was formed as a counter-movement to Black Lives Matter, advocating that those who are prosecuted and convicted killing law enforcement officers should be sentenced under hate crime statutes. Critics of the Blue Lives Matter movement state that a person's job cannot be analogized to the type of resonance that racial identity has for a person. They add that while Black identity, culture, and history are constantly under attack in the United States, see, for example, attacks on critical race theory and teaching factual American history in schools, law enforcement doesn't face similar threats. In fact, and even more importantly, so-called blue lives are not even under wholesale threat in the United States. For example, according to an FBI data from 2016 and 2017, violence against police officers has been decreasing without these proposed laws, calling into question their necessity. Finally, some critics of the Blue Lives Matter movement underscore that Blue Lives Matter supporters intentionally or unintentionally support or accept a system of racially discriminatory policing. Now, I wrote an article a year ago, sort of a tee up in a discussion about the racist roots of American policing. And there I say that police violence against Blacks has been multi-generational. Its roots are racialized and emerged from slavery. The origin of the police can be traced from its origin in the Greek police, meaning city, to the civil force charged with deterring crime, particularly in America, where the birth and growth of the police is directly tied to slavery. More specifically, the origin of police is a power relationship. That relationship, however, is not between a government and its subjects, what we might understand as the term public sphere, but rather power of the public over private, of men over women, children, and the enslaved who were not permitted to be citizens of the police. In 18th century England, there was a construction of the nation as being akin to the home, and the king, the father of the household. This concept is transferred to the American colonies. However, the American Revolution reconfigured the metaphor. The law becomes the father, the rule of law under which all people are equal. The American Revolution, however, did not alter power relationships between man and family, the origin of police and police power. Just as in England, the modern police force began with watches. Unlike in England, however, these were slave patrols and armed militias intended to fight off natives and quell rebellion. Official police forces came in the 19th century, where they fell under local jurisdictions and carried sidearms or firearms. Modern American policing, as we know it, began in 1909 with August Bulmer, a veteran elected chief of police in Berkeley, California, who created an often imitated training model based on war tactics used against Native Americans and other colonized people. Bulmer and progressive era policing, combined with Jim Crow laws, criminalized blackness. Black people were disproportionately targeted, harassed, and arrested. This criminalization continued to worsen throughout the 20th century with the War on Crime campaign that would become the tough on crime mentality that shaped American politics for decades. In recent years, there have been a variety of initiatives to capture the extent of unbridled police violence in the United States, highlighting its racial dimension. Importantly, there's an intersection between political ideology, police killing, and how we think about murder of George Floyd and the response in the summer of 2020. Mr. Floyd, as you know, was arrested on May 25th, 2020 in Minneapolis, Minnesota, after a convenience store employee called 911 to report that he had used counterfeit $20 bills to buy cigarettes. Shortly after, police arrived, ultimately resulting in Derek Chauvin, police officer, kneeling on his neck for 9 minutes and 29 seconds, killing him. In the wake of George Floyd's death, there was an awakening of sorts with respect to race and policing. In June 2020, the majority of both Black and white Americans believe that Black people are treated less fairly when dealing with police and by the entirety of the criminal justice system. According to polls from Pew Research Center, 84% of Black adults believe that Blacks are treated less fairly than white by police. Additionally, 63% of whites reported the same sentiment. Looking officers, and 18 of this poll stated that 84% of Black Americans believe that the criminal justice system was too lenient to police officers who caused injury or death compared to 62% of white Americans. But more importantly, you saw an increase in support for Black communities, less support for policing, more support for the Black Lives Matter movement. But this was mostly attributed to white Democrats, as Black people have fairly consistently held the same views towards race and towards policing over the decades. As one study points out, this change has come entirely among supporters of Democratic candidates. 74% of Biden supporters say it is a lot more difficult to be a Black and white person, while a small majority of Clinton supporters, 57%, said the same thing. The interesting thing, and I'll move on from the numbers, but just at a high level, you saw a significant uptick in the percentage of Republicans who supported the Black Lives Matter movement in the wake of George Floyd's murder, but you saw a precipitously drop in the month after his murder into the fall of 2020. There's also a significant research on the intersection of ideology and policing attitudes. One political ideology greatly influences the way in which a person views law enforcement and law enforcement in the United States more specifically. First, as a general matter, liberals and conservatives view figures of public authority differently. Typically, conservatives have more rigid views about obeying authority. Conservatives are seen to hold a pessimistic view of human nature and feel that individuals need authority to maintain stability, and social order. On the other hand, liberals are more typically under the belief that authority should be questioned for social progress to be successful. Moreover, their view of people holds that individuals are capable of freely coexisting in harmony and should welcome new experiences. Therefore, obedience to liberals is a divisive act in and of itself. But more specifically, with regard to attitudes about policing, when it comes to attitudes of law enforcement, there are important distinctions between Democrats and Republicans. While most of both groups hold a favorable view toward police, Republicans 81%, they are much more likely to feel positively towards police than Democrats, who have a 59% favorability rating vis-a-vis law enforcement. It's important to keep in mind the intersection of political ideology and racial attitudes. In a 2017 Pew poll, it showed that a wide majority of Democrats and Democratic leaners, 81%, now say the country needs to continue making changes to give Black people rights as whites. The share holding this view is up 18 points since 2014, when a small majority, 63% of Democrats said this. Among Republicans and Republican leaders, most, 59%, say the country has already made the needed change to give Black people rights with whites, and 36% say that more needs to be done. In a 2021 Pew poll, just 25% of Republicans and Republican-leaning independents say greater attention to history, to the history of slavery and racism as a good thing. Far more, 46%, view it negatively, while 29% see it neither good nor bad. Democrats and Democratic leaders across racial and ethnic groups express overwhelmingly positive views of increased attention to the top of 78% say it's good for our society. And so you see these significant disparities in racial attitudes. More importantly and significantly, contemporary psychological measures of racial bias overlap considerably with conservative political ideology. So, for example, modern racism scale. So what does all this mean, as we think about the January 6th insurrection? On January 6, 2021, a mob composed of white nationalists, Trump supporters attacked, and you can say there are other folks in this mix, attacked the U.S. Capitol. Thousands of insurrectionists descended on Washington, D.C. for the Stop the Steal rally, which former President Donald Trump promoted through his social media channels and dated Officer Brian Sicknick was killed. Many other officers were attacked and injured. 4 law enforcement officers, Sergeant Equiano Linnell, Officer Michael Pernone, Officer Daniel Hodges, and Officer Harry Dunn, delivered congressional testimony to the House about their experiences on that day. Sergeant Linnell recounted the verbal attacks as well as physical violence he and other officers endured on that day. Rioters called Sergeant Linnell a traitor and disgrace and said he should be executed for defending the Capitol. When rioters recognized and noticed the color of his skin, they said that he was not even American. Officer Pernone, whose wife recalled being dragged into a crowd where his badge was torn from his uniform, ammunition was taken, and he was beaten with fists and metal objects. He was electrocuted continuously with a taser. As some insurrectionists got hold of Officer Pernone, a firearm, they screamed, kill him with his own gun. Officer Hodges' arms were pinned and effectively useless, strapped against his shield on one side and a door frame on the other. An insurrectionist removed his gas mask, leaving Officer Hodges exposed to chemical irritant sprayed by the rioters. Another man then grabbed Officer Hodges' baton and bashed him in the head and face with it. Lastly, Officer Dunn, who was African American, recounted being called the N-word repeatedly. After the insurrection, Officer Dunn spoke to fellow black officers who shared similar stories of racial abuse on January 6th. One insurrectionist told another black officer, put your gun down and we'll show you what kind of N-word you really are. Many of these black officers had never been called the N-word before, including Officer Dunn. The situation and the blatant display of racism made Officer Dunn break down in tears later in that day. So, what can we say about ideology and reaction to the January 6th? The reaction to the insurrection at the U.S. Capitol on January 6th saw different perspectives by Democrats and Republicans. One of the major differences was whether the political groups saw the insurrection as dangerous to democracy within the United States. In a poll conducted by YouGov, 93% of Democrats believe that the insurrection was a threat, while 27% of Republicans thought the insurrection was a threat to political freedom. Another difference was in perceptions of how violent the insurrection was. In another YouGov poll, 58% of Republicans saw the protest as peaceful, and 22% saw them as violent, while Democrats voted almost the exact opposite. And in a Vox poll on who was to blame, 22% of Republicans blamed Trump for the events at the Capitol, while overwhelming 94% of Democrats and 64% of independents blamed Trump for inciting the violence.
Dean Park?
Another YouGov poll. Yes.
Dean Parks? Hi. This is Dean Adamson. We have about 1 minute left. We don't have a really good way of signaling to our virtual attendees when the time is running. So I just want to respectfully let you know that we have about 1 more minute left before we have to wrap up.
I appreciate that. And I have one last line.
Sure.
YouGov poll majority of Republicans, specifically 52% blamed President Biden for the insurrection. And as I close, what does all this mean? How do we think about ideologies post-January 6th and the backing of the blue? Political conservative support for law enforcement seems to be inconsistent. We know, as I've stated, conservatives are more so the Muslim backers who believe that blue lives matter. This is particularly so when law enforcement are policing black communities, and even when law enforcement unjustifiably takes the lives of black people. However, when law enforcement serves as a defender of democracy and a bulwark against white supremacists and national resentment, in part embodied in the rhetoric and policies of Donald Trump, and how those were embraced by his supporters, conservatives largely stopped backing the blue. In September 2021 Pew poll, since March 2021, there has been a 22 percentage point drop in the share of Republicans who think it is very or somewhat important that federal law enforcement agencies find and prosecute those who broke into Capitol and rioted there, and injured police officers. More importantly, as we think about the recognition remembrance ceremony that was held on January 6, 2022, almost no Republican elected officials showed. Only
Slides, or do I have to do it? As they're putting up the slides, bonjour, KK Kinago, Benesing women vision do they make an aquajuing and do to dash. Name good train of my eye and on Gum Chicago, you know, and the Schnabish and Corner Gaywin. So, my name's KK, and I'm here, and I'm happy to be talking about Indian law, but specifically in this context, Indian policing. And so, part of my background, I was the Attorney General for the Lakota tribe for a number of years. And with that, we implemented, so I overseen the Office of the Prosecutor, but also the Police Department, and then also Public Safety Commission. And I was also attorney for the Great Lakes Indian Fish and Wildlife Commission, which is an intertribal of 11 tribes. And they had off-reservation law enforcement for the implementation of treaty rights, Wisconsin, Minnesota, and Michigan. So I've seen the operations of policing both on reservation and off reservation. And so in the wake of the protests calling for reform, I began to ask the question, where does Indian country fit within that, and how the idea of police began as an agent of assimilation. So in the establishment of the Indian police, it was premised upon the desire of the BIA, or the Bureau of Indian Affairs, to implement the peace policy and limit the influence of the military in Indian affairs. So how were they going to do that? The government wanted to destroy modern-day tribal governments, assimilate tribal members, acquire land and tribal resources, and all that was done under the guise of protection of the Indians. How they went about that was handpicking tribal leaders, ended treaty making in 1871, and the allotment and wholesale dispossession of tribal land, implementing the boarding schools, as well as the CFR courts and Indian police. So under the guise of the police policy, to control the agencies passed to Christian denominations, and the churches received the right to proselytize the tribes under the idea of Indian education. So policymakers attempted to eradicate native religion in order to separate the people from their relationship with their lands. So the Indian way of life was condemned as universally worthless and deserving of extinction. So the first time Indian police comes about is in the 1856 Treaty of Fort Pierre with the Sioux, and that treaty went unratified because of the large cost that it would take to uniform and pay the police. What's interesting is that the United States spent more money in 1 year trying to return the Sioux back to the reservation, which was enough to fund 100 years of Indian policing. So the first actual modern day police force was at San Carlos Apache in 1873. So you see a picture of the San Carlos Apache barracks there that the police was housed at. And the first appropriation for Indian policing occurred in May of 1878. By November of 1878, about 1/3 of the Indian agencies had Indian police. By 1880, 2/3 of the agency had Indian police, and by 1890, nearly all the agencies had Indian police forces. So traditionally, law enforcement was governed by the chiefs, the warrior societies, and the clans, based upon the various communities. Here you see a picture of George Sword, who was a traditional Lakota chief, but he was the first chief of the Indian police for the Oglala Nation. And part of his implementation was the Ogichida Society that implemented traditional policing. And so also traditionally, community members had free will. So they had the ability to kind of act as they wanted to, the ability to act in a free manner, but they were supposed to adhere to community norms and kinship principles. So that's important because that's kind of what confined how people operated. So that was in place except for two main circumstances, which is one, if you went to war, you had to follow directions, and then also on the hunt, because in both circumstances people could die. You could either starve if you messed up the hunt, or people would die if you messed up going to battle. So traditional forms of justice was about ensuring harmony and balance within the communities. So depending on the tribe, punishment included ridicule, banishment, whipping, sometimes death, but also adoption in place of that. So if you had a murder, so the idea of ex parte crow dog was the idea when Chief Crow Dog actually killed Chief Spotted Tail, they did a traditional adoption and brought him into the family, and for 4 generations they had to pay forward the obligations to fulfill that role. The idea is imprisonment or jail was not utilized. And so in the early days, disputes were still resolved outside of the courts of Indian offenses. So here's a picture of the Light Horse Police Force in Oklahoma with Chickasaw, Cherokee, Choctaw Creek, and Seminole, which was their traditional police force, and they're pretty legendary. So in 1878, the Appropriations Bill authorizing the first Indian police force provided that it was to be employed, or police was to be employed for the civilization of the Indians. So the establishment of the police under the Bureau of Indian Affairs brought the destruction of the clan and kinship-based society. So the Indian police and the courts were created to control and break up Indian leadership and traditional government. So in 1881, Hiram Price, who was the Commissioner of Indian Affairs, said that the Indian police system was a power independently or entirely independent of the chiefs, and it will weaken and destroy the power of the tribes and the bands. So the authority to establish the courts and the Indian police was exercised under the provisions of law allowing the department or the Interior Department to have supervision over the Indians, or the idea of protection of the Indians. And the policy was to destroy tribal relations as fast as possible and to make sure every endeavor was to bring the Indians under the influence of the law, and they meant Western law. So the Indian Reorganization Act of 1934 was passed to reestablish tribal governing powers, curtail the allotment and other assimilation policies, and to redress those adverse effects of those policies. And so the government was not only concerned with the lack of tribal influence in the courts, but also the courts' blatant disregard for fair procedures and individual rights. So in the implementation of the IRA, they drafted in 1934 the Code of Indian Tribal Offenses, which for the first time allowed the rights for bail, trial by jury, probation, and parole. Also, as you know, the Nasby case, which the Supreme Court just heard a couple weeks ago, was based upon this 1934 code and the CFR code. So the modern Indian police forces have their foundation grounded in the assimilation policies, and modern tribal law enforcement infrastructure supports the perpetuation of those assimilation policies. So even though the Indian Reorganization Act established modern-day tribal governments, repositioned tribal courts to be tribal, it didn't do the same with the police forces. So the question now are, how can Indian police forces break away from assimilation policies and return to traditional forms of justice? And one way is to return to traditional law principles. So in doing that, we have to think about, if we had free will and the idea of achieving harmony. How do we address drugs, crime, violence in our communities today? And should they be exercised loosely or more strictly, like the idea of the war or hunt? And then, what's the line? Is it when your actions affect someone else, create disharmony? So it's thinking about how do we want to implement those principles? And is customary law appropriately situated to deal with modern crimes in Indian country today? So, in looking at some of tribal courts and how they've dealt with those questions, the Nisqually Indian community in Washington State talked about how traditionally when conduct was in violation of societal norms, that a representative of the victim went to the perpetrator's family and asked for satisfaction of payment or somehow to make it right. And if the parties didn't agree, then a leader in the community or a tribal elder would intervene to settle a dispute. So the court said that in a modern day function, the court is functioning in the role of those tribal elders today and is sanctioning the conduct or non-conduct of community members. So what's appropriate and what's not. In Mille Lacs, which is in Minnesota, they looked at the ability for the tribe to implement a banishment ordinance. The same went at Cheyenne River in South Dakota. They implemented a banishment ordinance for anybody selling or manufacturing methamphetamine or heroin. And so the question with the banishment ordinance was the idea of, can the tribe actually banish members for violation of those conduct policies? And the court said the importance of maintaining tribal relations and kinship is so strong, specifically if you're trying to rebuild those relationships and kinship networks, that it's inappropriate to exclude them from the community or those band members. So that's one way to think about banishment in a modern day context. In Colville, which is also in Washington State, they talked about the right to be compelled to testify against oneself. And the court said being part of an Indian community often compels an Indian person who has committed an act against the community to confess, because that's how you achieve healing, to reinstitute harmony. So they said even today criminal suspects confess crimes at higher rates, and that there is no such thing as the right to remain silent. In Navajo Nation, they talked about an individual freedom rejecting coercion. And they said a person cannot give information for his or her own punishment unless there is a knowing and voluntary decision to do so. In light of the Navajo principle rejecting coercion, the court said that others may talk about a Navajo, but that does not mean coercion can be used to make that person admit guilt or the facts leading to a confession of guilt. The court said our Navajo Bill of Rights, as informed by the Navajo value of individual freedom, prohibits coerced confessions. The court went on and said, our Navajo way of thinking, we must communicate clearly and concisely to each other so that we may understand the meaning of our words. The responsibility of the government is even stronger when a fundamental right, such as the right against self-incrimination, is involved. Hasho'ogo is not a man-made law, but a fundamental tenet informing us how to interact with each other based upon kinship principles. So basically that we interact with each other as relatives. And they say modern court procedures all intend to be conducted with Hoshogo, or treat each other as relatives in mind. So they said the right to be compelled against self-incrimination attached not when the defendant first appeared before the court, but when they were placed in police custody. So either the police coerced the defendant or did not. Any degree of coercion is a violation of the Navajo Bill of Rights. So again, thinking about the idea of free will, achieving harmony, and we think about what should modern punishments be. Punishment under the Code of Indian Offenses was foreign, drastic. It included fines, hard labor, withholding rations, imprisonment. And we saw that imprisonment failed to restore harmony within the community. So the question is jail appropriate today? What should modern punishments be? How do we interact with the police community and the tribal community? And in returning to traditional law principles, the idea is community-based policing and having the members part of the community, implemented in the community. One example is at Salt River, or Pima Maricopa Indian Community in Arizona, where they implemented a coffee with a cop, or here a pop with a cop. And it was the idea of connecting officers with community members and having them part of the community, part of the fabric, reestablishing those kinship principles, those connections. And so even at Glyphwick, when we implemented community-based policing, a lot of our officers were from the communities, housed in the communities, to build those relationships to how to assist and help and be a productive member of the community rather than seen as like an obstacle or an outsider. So when we think about returning and where do we go from here, one of the ideas is that as we train our police forces and train our officers, part of that is they need to be trained in traditional law principles. And they need to understand what it is to restore harmony and balance. And part of that training is to get away from those assimilation policies, but implement what it means to be a relative. And also, as we have these conversations of national reform, tribal communities need to be involved, because how it's implemented really comes from the federal government side. So if we have a national policies, national movement, we really got to get on a large scale the Department of Justice, the Bureau of Indian Affairs, to implement principles that perpetuate the restoration of harmony within the communities. Thank you.
Professor Delgado.
Yeah.
Yep. Yep.
Can you hear me?
Absolutely. Is that great?
Okay. Alan Slater, my co-author, and I have written about policing in communities of color several times, in fact, as well as about immigration law in practice, also several times, because of the growing suspicion that the two systems operate in much the same way and serve many of the same ends. We are pleased at the opportunity to offer a few thoughts about one of those systems, immigration, through a lens, critical race theory, that we have found useful in discussing the other one, policing. We take as a point of departure a recent book on the role of the president in formulating U.S. immigration policy. In The President and Immigration Law, Professors Adam Cox and Christina Rodriguez analyze that body of law, immigration, and offer suggestions for improving it. Their analysis proceeds almost entirely in structural and separation of power terms, and notes that the underlying policy purposes of our system of immigration enforcement shift from one period to another, thus making it tempting for presidents to take the initiative. This structural approach, very common among scholars in the field, often gives scant weight to the interests of what might think are many of its main constituents, the immigrants whose lives and well-beings are at stake. The structural perspective also gives only slight attention to critical race theory, a body of scholarship directly relevant to the concerns of immigrants since, one, many of them are minority group members, as are many immigration law scholars, and two, many of the currents that roil the sea of immigration regulation are overtly racial. Most recent books, with a few notable exceptions, likewise rely heavily on conventional analytical tools such as separation of powers, economic efficiency, fidelity to regulatory principles, and cost-benefit analysis. For example, a 2021 online symposium in the Yale Journal on Regulation discusses the Cox-Rodriguez book from many angles, but none of the contributors use the term critical race theory, interest convergence, or white nationalism, even though to any reader versed in critical thought, these concepts would seem to practically jump off the page of any history of U.S. immigration system. To be sure, an occasional legal scholar mentions critical race scholarship when discussing the Muslim ban or the practice of family separation. But these amount to little more than gestures, not deep analysis. If critical race theory does appear in the body of prominent scholarship on immigration, it's very hard to find. It's not in the indexes of the major books, and not discoverable by a reasonably diligent search of the law review literature in this field. The failure to apply critical race theory to immigration law and practice is surprising, considering that at least one principal tool of critical thought lies close to hand. Years ago, Derek Bell, the father of critical race theory, taught that society is likely to tolerate and encourage advances for people of color only when these will also benefit elite whites. Bell put forward his interest convergence hypothesis in connection with Brown versus Board of Education, an education case, of course. Mary Gudziak subsequently confirmed it with original archival research, and others have shown how it explains a number of other civil rights breakthroughs. Our thesis is that significant change is unlikely to arrive in immigration law by pointing out that many of its practices are racist or inhumane, lacking in procedural protections, inefficient, that courts review them under the wrong standard, or this or that branch of government deserves to have the upper hand. Rather, we say, critics must show that it lies in the self-interest of influential majoritarian groups to modify the current system in fundamental fashion. We begin by summarizing Derek Bell's interest convergence hypothesis and its influence on subsequent civil rights scholarship and litigation. Then, we show that immigration policy currently operates to the detriment of 6 separate groups: retirees, the military, major corporations, the U.S. State Department, minorities who reside legitimately in this country, and all people who find cruelty distasteful, offensive, and wrong, particularly when it is carried out in their names. These 6 constituencies would likely benefit from change in the current paradigm and unite in a movement in favor of it for change. How likely is it that such a movement would form and make headway? We conclude by offering a few of the most likely objections to a liberalized immigration policy, even one that promises to advance the interests of elite and non-elite whites alike in 6 groups. These include that immigrants from certain cultures will change our culture if we let too many of them in the door, the so-called replacement theory, put forward by Samuel Huntington and adopted today by a number of white supremacist groups. This observation wielded a great deal of influence during the Trump administration and still does with many of his followers, some of whom believe that even if immigration brings a nation many advantages, we should discourage it because it will change the nature of our society. Our application of critical race theory, particularly interest convergence to the area of immigration, is thus forward-looking rather than historical, substantive rather than procedural. We posit that interest convergence offers a means to achieve a better future. We also believe that it explains the past, and that reviewing certain key chapters in immigration history, such as the Bracero Program, Haitian interception, the Cuban Refugee Resettlement Program, and the Chinese Exclusion Act, from the perspective of interest convergence, will explain an otherwise chaotic seeming story. But that exercise awaits another day, and perhaps another opportunity like this one. The absence of interest convergence analysis in immigration law is noteworthy because Bell's hypothesis has proven remarkably helpful in explaining other currents and events in American history. His hypothesis first appeared in print in connection with Brown versus Board of Education, as you mentioned. In a much-cited 1987 article, Bell addressed a question that had eluded civil rights historians, namely why the Supreme Court handed down this major civil rights breakthrough when it did, namely in 1954. The question was puzzling, inasmuch as the NAACP Legal Defense Fund had been litigating school desegregation cases, mainly in the South, under dangerous circumstances, for decades, losing, or at most winning very narrow victories. Bell was one of the intrepid warriors. Then in 1954, the sky opened, and the Supreme Court granted them everything they had been asking for. Why just then? Bell hypothesized that the Cold War with the Soviet Union supplied much of the answer. The U.S. then was in the midst of a titanic struggle with the forces of a communist, materialistic, devious superpower for the loyalties of the uncommitted Third World, much of which was Black, Asian, or Latin American. Every time the world press headlines, stories of lynchings, mass deportations, or Southern sheriffs brutalizing peaceful civil rights protesters, the Soviets registered gains at our expense. Bell hypothesized that it was pressure emanating from the State Department and ambassadors abroad that persuaded elite figures in Congress and the Department of Justice to intervene on behalf of the Black community. The Supreme Court soon followed suit. The judicial breakthrough conveyed a number of further benefits to the United States. Black and brown servicemen and women had been serving gallantly in the U.S. military in 2 wars against totalitarian forces. Many of them had been returning to this country, having experienced for the first time in their lives an atmosphere, the U.S. military, where a black and brown soldier who performed well could advance and become a sergeant, or even gain a battlefield commission. These returning vets were unlikely to settle back into the former regime of shiny shoes, menial jobs, yes sir, and no sir. For the first time in years, the prospect of racial unrest was loomed. The Supreme Court responded with a heartwarming victory. It also prompted the South, mired in a poor economy, to revolutionize its educational system and infrastructure, providing a further spark for post-war industry. A few years later, legal historian Mary Duziak confirmed what Bell merely had hypothesized. What had been merely a product of Bell's astute observation and speculation now lay confirmed in the pages of an article in a book. Through a series of interviews and Freedom of Information Act requests, Duziak produced a paper trail showing how actors in the Department of State and other high places prevailed on the Justice Department and Supreme Court to produce the breakthrough decision. Subsequent scholarship applied the interest convergence approach to other civil rights questions, including Latino breakthroughs and Barack Obama's presidency. Could it produce yet another? Recent scholarship has shown that immigrants are a low-crime and hard-working group, good for the economy at large. They are also successful in science and industry, accounting for a large share of startup companies, scientific prizes, and Nobel Prize awards. They also bring new music, art, cuisine, and other forms of cultural enrichment benefiting the U.S. population at large. In addition to these diversified benefits, immigrants confer more narrowly targeted gains on specific groups of U.S. citizens. We have time today for only 3, although the article version of this talk includes others.
Okay, like Professor Delgado mentioned, we identify 6 groups whose interests align with immigrants in that they'd be better served by a reformed, more inclusive, and less racist immigration system. The first group that we're going to highlight today is retirees. So many retirees require medical services and nursing home help of many kinds. Without immigrants, particularly from the Philippines and Mexico, those pools would dry up. As of 2018, immigrants made up 21% of the worker pool in the home health care industry. Many retirees also rely on Social Security and Medicare benefits. And the funding for that rests on an increasingly narrow and unstable pyramid of aging workers. But immigrants can help mitigate the strain on the system and save those critical benefits programs. So according to a 2018 Social Security Administration report, some of the main reasons behind the program's financial difficulties are that more U.S. citizens are retiring, they're living longer after retirement, and they're not being replaced quickly enough by subsequent generations of workers. To put that in perspective, in 1960, each person receiving retirement or disability benefits through Social Security was supported by approximately 5.1 workers. But by 2013, that ratio had decreased to 2.8 workers per beneficiary. The report concludes that an increase in immigration can mitigate the strain on the benefits system. As a group, immigrants tend to be relatively young and having more years to work and pay taxes before retirement. They increased the number of workers earlier than they increased the number of beneficiaries. Undocumented, and that's just documented immigrants. Undocumented immigrants boost the Social Security system for another reason. They pay into it through taxes to the tune of billions of dollars each year, but most of them are very unlikely to receive the benefits, so they're actually helping the system stay afloat. The second group we're going to highlight is the U.S. military. The military has long operated as a magnet for minority youth and immigrants. Indeed, immigrants have served the U.S. military since the inception of the country, fighting every major conflict from the American Revolution through to the War on Terror. In the past 100 years, more than 760,000 non-citizens have enlisted and obtained citizenship through military service. And as of 2019, immigrants or their children comprised approximately 13% of U.S. military veterans. Many have critical language and cultural skills that enable military leaders to build relationships critical to strategic goals in wars like Afghanistan and Iraq. And in addition to language and cultural skills, many non-citizens bring critically important technical skills that are integral to today's military operations. Immigrants have helped build a helicopter. They sold the U.S. Navy the first submarine that it bought. Non-citizens also tend to have lower attrition rates than their U.S. citizen counterparts. They stay in the military longer, partly because they have a stronger attachment to serving the United States, which they now consider to be their country. And there have also been paradigms of military virtue. More than 20% of the recipients of the Congressional Medal of Honor have been immigrants. That's our nation's highest award for valor. And so the third thing we're going to touch on today is for major corporations in the economy writ large. So immigrants have often display a strong work ethic, sometimes holding down 2 or even 3 full-time jobs. David Card, a Nobel Prize-winning economist at UC Berkeley, won acclaim for demonstrating that immigrants are generally good for the economy in regions where they settle. And I mentioned before that immigrants make up a substantial portion of the home healthcare industry, but I also want to point out that in a recent year, immigrants made up nearly a third of the workforce in several critical areas of the economy: farming, fishing, forestry, construction, maintenance and grounds cleaning, textile, apparel manufacturing, food manufacturing, and hospitality services. During the ongoing COVID-19 pandemic, many of those workers sacrificed their health and lives to continue providing critical services, even though they were being systematically excluded from unemployment benefits or federal stimulus programs. Furthermore, despite their considerable contribution, states like Arizona and Alabama enacted draconian anti-immigrant statutes that ended up harming large swaths of their economy. Arizona started first with what was essentially a papers, please statute that allowed police officers to stop and demand proof of legal residency from anyone that they suspected of being an undocumented immigrant. Alabama followed suit shortly afterwards. The point of the laws, according to the lawmakers, was to force undocumented immigrants out of the state so citizens could take their jobs, but that didn't happen. Arizona suffered economic downturns compared to its neighbors, and Alabama did as well. In particular, Alabama's agricultural sector was devastated and still hasn't completely recovered. That law harmed the majority group that the law was ostensibly protecting.
Ellen, finally consider a number of possible objections to a greatly liberalized and broadened immigration system. Even a system that delivers expansive benefits to the country at large or to specific segments of the populace, 6 of them, could attract enmity from sectors willing to forego those benefits for reasons that are intangible or cultural in nature. Foremost of these is the belief that large numbers of immigrants are likely to change the dominant culture or its Western system of values and beliefs. This is the so-called replacement theory, first advanced by Samuel Huntington, as I mentioned, and a few years later by marchers in Charlottesville. The replacement theory holds, in brief, that if immigration proceeds unchecked, it will radically change the character of life in the United States to its great detriment. But why should the arrival or birth of substantial numbers of non-whites, or even non-Christians, herald a downturn for American society? No downturn set in following the arrival of large numbers of Italians, Jews, Irish, or Greeks in the early 20th century. Roseros saved the farm economy during the two World War period, while immigrants from Asia built the railroads and supplied doctors, dentists, pharmacists, and nurses when required to fulfill the nation's health needs. All populations need to replace themselves, either by birth or immigration. Any sensible immigration policy would exclude those with infectious diseases or histories of crime. Short of that, a self-confident country with a strong public and private sector with little to fear from immigrants. Fear of disloyalty is the second possible objection, especially during times of war or economic competition. During World War II, an anti-Japanese scare campaign resulted in the internment of large numbers of innocent Japanese, including women and children, in barbed wire compounds reminiscent of concentration camps. And in recent times, a few scientists with Chinese ties have been accused of passing secrets to overseas competitors. But almost all of those scares have turned out to be bogus or overblown. Many immigrant groups, such as the Mexican Americans or Japanese Americans, have indeed earned records for valor in military service exceeding those of Native Americans of Anglo-Saxon vintage. In short, getting the procedure right, something that many immigrant scholars feel is a terrific important idea, while a worthy goal, does not guarantee right results. Right procedure does not guarantee right action or right results. One must pay at least as much attention to substantive values and the myriad respects in which wrong action in immigration, as in any other area, can work serious injustice. This is nowhere truer than in the field of immigration, where a wrong decision may consign a person or group to a permanent life of abject misery. Coloring between the lines cannot be the only goal in any endeavor. Sometimes you have to ask about the picture that will emerge in the drawing and raise questions about the person who created the coloring book. Critical race theory and analysis helps raise these questions and shows how often society may gain a great deal from addressing them. Thank you.
So now we're going to open it for questions. We have about 15 minutes. I see Dean Inton. I'll get in the queue after Dean Inton.
Absolutely.
Thanks. This is for Professor Delgado and Mr. Slater. You make a powerful argument that it is not in the national interest to maintain restrictive immigration policies and to discriminate against immigrants. How do we get from that basic critique to persuading the right folks, whether they are elected officials or significant members of the public, that we should therefore adopt more humane and progressive immigration policies? And I raise this because back in the 50s, when Brown was decided, economists had made powerful arguments that racial discrimination was economically irrational or inefficient, but that wasn't sufficient to get better racial policies. So how do we get from the analysis that you've given us to making the relevant folks understand that it might be in the national interest to go in the direction that you're suggesting?
we show them with figures and arguments that it is in the national interest of elite white groups like them. We name 6 such groups, and we show with figures that each of the 6 would be better off. These are major players in American society. So anyone who wanted to make the case that you're saying they might make, would be bucking that argument. It was persuasive, at least for a short time, introducing Bell versus Brown of Education, and a few other racial breakthroughs from time to time. They of course roll back. I mean, you have to keep the pressure on, but at least they can get people started thinking. People like to think about their own self-interest, and they will. Alan, can you add to that answer?
Sure. So whenever I think about big structural problems and how to approach them, I always come back to this analogy I heard a long time ago. It says, how do you eat an elephant? One bite at a time. So what we've done is kind of lay out 6 general and brief arguments that can be made to major constituency groups, but each of the arguments that we've made could in itself be its own wall. There's a lot of depth to be explored in each of these areas. So I think that if we, obviously just like everything else, like change takes time. So this is more like a roadmap for a focused effort in different areas for activists and other people concerned with the injustice of our current immigration system to make those arguments. I don't have a solution for how we get from where we are now to a more just immigration system, but I do think that if we concentrated our efforts in these major areas that we've highlighted here, that I think that we could probably make some progress.
Our next article may go back through history and show that interest convergence actually works in the immigration field. It works powerfully. During World War time, when the nation needed workers, immigration laws relaxed. We had the Presero program. During peacetime, we retired it. When Henry Ford needed thousands of hardworking immigrants, shirt sleeves, to work in his factories in Cleveland and Chicago and Detroit and places like that, what happened? Well, we relaxed the immigration laws to let in hundreds of thousands of hardworking Italians, Greeks, Irish, Jews, and so on. Today, we need nursing home workers. We need doctors. How many of you have a foreign educated doctor? I do. I won't ask you to raise your hand, but think about it. When we need manpower, person power, people with certain skills that are not available in the United States, where do we look? The rest of the world. Great.
Yes. I read once the first legal immigration law that was passed was in 1924. I don't know if that's true or not. And I did a follow-up on it. And I would like to ask you about the law that they just passed in Alabama about the capital punishment. How do you feel about that with the nitrogen something? And I think they just killed a guy. I think he was last month or this month with that new system that they got, with that new chemical that they're using.
States that were heavily into slavery, they subscribe to the death penalty. They're the last redoubt for death penalty. There's a connection. Alabama was, of course, a slave state. All the South was. But it got used to treating people with force and violence and killing ones that tried to do terrible things like run away He didn't talk bad about the plantation owners. That's how I think about Alabama's death penalty system. You know, it has an equally unlovely attitude towards immigrants, having enacted a law that sought to make life in the state as uncomfortable and difficult as possible for an undocumented immigrant. It punished one who used a social service, sent a kid to school, entered into a contract of any kind, such as a contract to rent an apartment. Today or yesterday, the South voted an anti-CRT, critical race theory, bill, which, if you interpret it the wrong way, means that Gene and I, when we return to Alabama and continue teaching the very class that we're teaching right now, will be criminals. I could go on, but I won't.
Professor Stark, if I could. I was really, really struck by the traditional Indian law principles that you laid out at the beginning of your presentation, and how they serve to promote or are aligned with what I would consider human rights, right? Those that are given to us by virtue of birth. And was wondering if you could speak a bit about sort of how that can continue in the face of, or how the pop and the cop sort of community engagement piece really, if that really serves those traditional law principles, in light of the fact, and this is an assumption, so you have to tell me if my assumption is wrong, in light of the fact that the police department that you featured in your presentation that does that pop and the cop, right, likely involves American or employs American policing practices and consequences that are different than the traditional, you know, those rooted in traditional law practices. I hope I'm making sense.
Right, and I think that's the balance that we need to think about, and when we're talking about change, how to implement that balance, how to have, because really the principles is about, like we said, harmony, respect, really those human right principles that are embedded in, you know, traditional law that says this is how we're supposed to interact with each other, this is how we're supposed to interact with our environment, this is how we're supposed to, you know, so it goes beyond just our connection with our communities, our relatives, but also with our land and our land base. So it even extends beyond ourselves, but also with how we treat the environment. But when we implement that, to think about, I think that's the crux is modern day crimes, because assimilation has occurred, oppression has occurred, trauma has occurred, and has been perpetuated for generations. You know, it's not going to be overnight that you heal that. So how do you reverse the course and implement change for, you know, violence and crime, drugs, and all those things? But I think there's the area of, you know, building the relationships, building those principles, when we're talking about how to respect people, how to treat people with dignity, that need to be implemented. And so, to me, it really goes back to the law enforcement manuals, the procedures, and what's implemented, and what Department of Justice, our Bureau of Indian Affairs, that's telling their police officers to do when they go to FLETC and the Federal Law Enforcement Academy, to say this is how you operate these systems, to really, the structure needs to be redone from a tribal perspective, tribal value perspective, on a broad thing, to reintroduce those principles, which I think will change how policing's done and then how we interact with our communities, but that's the challenge.
Yes, so I have a question for both Mr. Delgado and Jean. You guys are talking about the critical race theory and also the two laws that were passed, one in Arizona and one in Alabama. and the effect that it had upon both states economically. Given that it did have such a bad effect for those states, have they, or do you know if they've changed those laws back again, or have they kept them on the books just the way they are, or amended them in any way?
So, from what I understand, a big portion of the law in Arizona was struck down by the Supreme Court, and Alabama. Both of the laws are still on the books, but they're not as draconian as they started out because they've had to be parts of them have been ruled unconstitutional, and then other parts, as far as I'm aware, have just been the enforcement has not been there with the stringency that it was to begin with. There were stories that when this happened in, I think, 2011, 2012, 2013, in Alabama, there were front page stories all over the state about farmers whose crops were withering on the vines and losing hundreds of thousands of dollars. And it was one of those things where, similar to a lot of the laws that you're seeing passed in places like Texas now, where it's like you're throwing red meat to people who want these draconian enforcement measures, but when push comes to shove and they are actually being affected, then they're not as enthusiastic about it as they were when it was simply a theory and something that they got to yell at people about. So I think that even if they're on the books, the enforcement is not the same.
Are there other questions from the crowd? If not, I have one final one, and this is for Professor Delgado and Mr. Allen. So I understand the need to appeal to majoritarian interests to liberalize the immigration system, but I think some people would object that the very things that appeal to those majoritarian interests, like the fact that income inequality requires immigrants to maybe work 2 or 3 jobs, or the fact that undocumented immigrants pay into Social Security but don't receive it, are themselves unfair. And I'm wondering if activists appeal to majoritarian interests, there's a risk of locking in those unfairnesses.
You're absolutely right. One of the majoritarian interests, when encounters quickly, is the interest in oppressing poor, say, Mexicans or Guatemalans, and paying them so little money that they have to work two or three jobs. You're absolutely right about that. The possible counteract to that is education. Those parents may be exploited. They may be working 80 hours a week, but their kids can go to public school. The kids can take classes from people like Professor Stark or Ellen Slater, who, even though he doesn't know it, was created to be a professor one day. They can learn about Derek Bell and critical race theory in school. They may be taught by a young professor who knows about Marx and Gramsci and the theory of hegemony. And the little kids will learn critical race theory in school. I very much hope. I hope the legislators are listening, and they can be agents of change. That's my hope for the future.
I would also point out, I acknowledge the risk of locking in unfairnesses, but in the course of researching some of this paper, one of the things that we found was that there are several studies that even though immigrants, undocumented immigrants, are currently contributing right now to the tune of billions of dollars to the tax system, providing them with a path to legalization actually adds several billion more dollars to the system. So if we're making these interest convergence arguments, there's also avenues to argue that the current system is still unfair and unjust, and that there are economic and social benefits to provide, to not locking in those unfairnesses. So there are still avenues of attack, so to speak, to make sure that we don't leave people behind when we're trying to advocate for these better systems.
Okay, thank you all. Let's join together and thank our panelists. for their insights. Thank you all. Gregory, Richard, Alan, Keke. We're going to take a 15-minute break, and our next panel will begin at 10:45. I don't know if anyone is paying attention to that clock there, but don't. All right. Thank you.
Professor Delgado and Alan, I don't know if you saw my comment in the chat, and maybe helpful if you take Rob Miller out at the same position in school. I think sociology needs us some research on how you persuade folks opposite sides.
Yes, it was. I think there's a person speaker first.
I'm good.
Hold up that white here and let you know how much time.
You and Richard have talked more.
I don't think so.
I'll be like right, almost right in front of you. So hopefully
Maybe that. Because most was right? Yeah, thank you.
I just
Certainly sounds like our
good to see you.
I look forward to it.
It's, I guess, I don't know. Hold on, let me remind my child I'm not working today so they can leave him.
Richard.
Hey.
Is that an error? We made the correction, let's see. Yes. Designation. I have sent to me. I just got from what I know, it's very. I don't think I know 70. It's they had a fairly straightforward. I was shocked.
I don't
Yeah.
Who is that?
I guess that. I guess it's the lawsuit.
Press release and
The lawsuit. But, you know, oh, and he was close.
Well, their communication doesn't. Yeah, they do.
So
He could have just said, we're moving on.
it's hard to see how
You have some connections.
I know. And I expect great things.
Oh, that's what for. And they have promised to stay.
Oh, that's what Drake was talking
So
about.
everybody has 20 minutes.
When he said that you
Wrote
should
a sentence.
Yeah,
thinking it was a Egypt like that.
No, not at all.
Okay.
Nope, you have 20 minutes.
Okay, so Caleb was there last night.
Yeah, Caleb
Yeah.
is here and
Are you
Ray here, and
practicing
the
law?
other two will be online, is my understanding.
I remember he said
Uh-huh,
there were four
yeah, no
provinces
worries.
are getting
I won't cut you short, I promise.
Me too, because I didn't even
No,
know that.
no.
Yeah, I'm
Great, okay.
Thank you.
sorry.
Hello, gorgeous, how are you?
Sort of is. She had a brand new day, I'm fine. Good, that's all I have. All right, yeah, go ahead.
How's my guy? Did he have spring break yet?
They start, their last week is next week, so they
Oh,
just
they
all
got a little bit. Oh, wow, okay. Okay.
So he's excited.
Yeah.
He could have provided.
He had a countdown of days.
The transition.
I love it. I love it. And then, you know how people say we're silent
Although I'm not
citizens and they don't get a driver's license and stuff like that? Does that have something to do with that?
One of the speakers was going to talk about Instagram. And I think you mentioned that you made some copies earlier and that you were able to. You'll email it to me. Yeah, that's precisely what we're doing. Real late.
10:45.
When you have a little bit more time, because I think there's only 2 panelists on this.
Just two.
I don't feel the need to fill all of this out. And then we'll be looking at it.
It's a good email.
AJT 118 at case.edu.
Case.edu? Alrighty.
And I'll go upstairs and get it.
Thank you. It may take me a second to get over to you.
No
but
rush.
It's no rush. Thank you.
Okay.
You know,
So-
the same talk you gave to the commission would be very welcome. You and Charlotte
Okay, all right.
talked before. Practices in all the years. She might be able to stay.
She will stay.
There is no
For the relation of the.
Afraid I was going to be late, so I just stayed to watch those first one.
Oh, gotcha.
Outside,
Thank you.
and then actually was
I was about to send an email to students.
gonna-
Thank you. You were me.
Eric got me online.
Okay.
Oh, Eric did?
Yeah.
Okay.
Hi, Louis.
Yeah, and the
But Eric-
person to
Can you tell me how was I supposed to find that link on my own?
Well,
I told
it's
him.
supposed to be.
I'm trying to get
on this-
Well, I just. Okay, so it wasn't me. That's what I like. It's been
Yeah.
before I called. I
Is it
found
there
out.
now? Is it there now?
No, it's not. Let me see if I can get it there now.
Dave sent it to me, unless it was you after me.
Because you had several registrants, you had registrants for virtual, they don't have to link, right?
So yeah, I just
No,
sent you
this
the
isn't
link.
So here's
hybrid.
what I when I typed it in.
I understand, but I'm just saying that they wanted to attend.
Yeah, so,
I do that.
I mean, it is me,
Yeah,
it's just
I
everybody, it's
resent it.
Margo, it's Carl, it's everybody.
Well, it's nothing on that. So
Dave is DFW for case
Right.
REC 110.
hang on.
I'm sorry to
In advance. So Mark Chuck registered in advance.
That's a cornbread.
It'll be the link online, right?
Once you know.
I'll be like, what's he going to
Yeah, it's on the case YouTube page, it's not on the case web page.
Have you legislate? Did you hear that, Aaron?
Right. Oh, 1 second.
But it's the answer.
Since this is hybrid, there's no link that is sent out. People just need to come back to the website to watch the program. Exactly, but people have been watching. I've been looking on YouTube.
Today, so even if you say it, I'll say, okay, so okay.
They've been watching this video.
It's like I knew it, I just didn't know how to articulate it.
And that's what's so great about the key.
Exactly.
Like you have all of this. You come and you learn.
Okay, so the people who registered for this, it's specifically said it was an in-person event. There's no information mentioned about it being virtual.
So then when you said that, I was like,
So only the registry,
okay, that's
only
how I
the.
felt. I was like, is he serious? Like, is he thinking that? Why does he register? So I'm like,
You can't, there is no virtual registration at all here. When you register, it's strictly for in-person.
He was definitely supposed to be here. So
No, there's no option for that at all for this particular event. This event was strictly in person.
I got it in there wrong.
Yeah.
I don't understand
Well, people are so accustomed to doing things hybrid.
That's what I just want to
This
put in.
event, I remember when we set it up, it was strictly for in person.
I think it's maybe under Rob.
Oh,
I'm gonna say maybe that's two.
That's 714
Anybody
number.
can go on there and
Right, no registration.
That's the number you need if you're in
Yeah.
your classroom, you need some help. That comes to our desk and our cell phones. So you need that number. You shouldn't put it under my name, though. You should put it under, let me see.
But hey, try it with one B, maybe I missed the first name.
Got so many contacts.
Put yourself in there the right way.
Got you. So
I have a list of all the people who registered for in person for this event, but it only stated that this is for in person.
Search for your name.
Shoot, 'cause that's me and Dave. That's our desk and our cell phone. So that's when you need us in the classroom.
I know, I don't get, I'm sorry, that maybe.
The mic is muted, it is muted.
State, that state.
So,
We gotta stay our kids, because.
did you watch that Philly game?
Yeah, it's a close game. March Madness, man. We're in college basketball.
I
You gotta watch the college.
I know they have so many exciting things, so I was ready to yesterday.
He came in.
That's a good one.
You talking about the Browns? Yeah. Oh, man. Baker.
Oh, I gotta introduce you. Sorry about that.
Yeah, we'd like to know what.
Yeah.
I'm just trying to figure out.
Yeah. If you're in the middle of something, I'll just ask you later. I'll ask you later. I was gonna say that.
It's like a personal privilege.
Yes. I can sign in.
So that's one of those.
So you're aware of that, okay?
That's great.
Yeah. Yeah, definitely.
From law professor. Love it. Okay. All right, we're going to get started. Thank you very much. I'm pleased and privileged to introduce our next slate of panelists, and I am going to just simply do their biographies, and then I will let Professor Green begin our conversation. But first, I want to introduce Richard Jackson. Richard Jackson Sr. is a retired 30-year police officer with 20 of those years in police supervision. And he spent his last 3 years in police reform as a commissioner with the Cleveland Community Police Commission, where he served 2 consecutive terms as chair of the commission. Now, during his time as commissioner, Mr. Jackson has worked with many organizations to write, promote, and campaign for Issue 24. And for any of you who are not familiar with Issue 24, you're going to be learning a lot more about it today and in the future, and its impact not only in our community, but perhaps in other communities with the success that it might enjoy if it is implemented properly. And we're going to be talking about that today. Professor Michael Green, welcome. Professor Green is a member of Texas A&M University School of Law, and his scholarship focuses on workplace disputes and the intersection of race and alternatives to court resolution processes. He previously served on the faculty of Texas Wesleyan University School of Law, where in June 2008, he was appointed to the inaugural position of Associate Dean for Faculty Research and Development. He highlighted the significant accomplishments of the faculty while continuing to nourish and support the development and success of faculty members as scholars and as teachers. Professor Green was a visiting professor at the University of Georgia School of Law in the spring of 2013, where he taught employment discrimination and employment law. Professor Green also was a visiting professor at Florida State University College of Law, where he taught evidence and employment discrimination during the spring of 2008 semester.
His legal practice experience in Illinois and Kentucky focused on representing clients in workplace disputes. He is a frequently requested speaker and expert in his field and has presented at dozens of conferences on matters pertaining to workplace disputes. Professor Green was elected as a fellow to the College of Labor and Employment Lawyers in June of 2014 and elected as a member of the American Law Institute in October of 2006. Just 7 years ago, he received the Paul Stephen Miller Memorial Award at the 10th Annual Colloquium on Scholarship in Employment and Labor Law. And that award is given to a scholar who has demonstrated outstanding academic and public contributions to the field of labor and employment law. Among his many other professional activities, Professor Green is a labor and employment mediator and an arbitrator who serves as a member of the American Arbitration Association's National Labor Arbitration Panel, the Federal Mediation and Conciliation Service Labor Panel, and as a hearing officer for the Dallas Area Rapid Transit Trial Board. He served as the Secretary of the American Bar Association Labor and Employment Law section in 2014. All of this saying that he is the busiest man on the planet, and he also holds an LLM from the University of Wisconsin School of Law, JD Cum Laude, and MS in Human Resources and Industrial Labor Relations from Loyola Chicago, and an MBA from California Lutheran, and a BS in Electrical Engineering from the University of Southern California. Professor, welcome, and thank you for being here, and we'll let you start off this conversation.
Thank you. I was wondering if I have access to show slides. If not, I can just talk on them without showing the slides.
Yes, you do.
Okay.
You will.
All right, thank you. Okay, so hopefully in slides now. The title of my presentation is Black Unions Matter, and Black Police Unions Matter, and what I hope to convey my 20 minutes is the kids dealing with Black police officers, highlighting the number of times that Black police officers have been involved in going up against their police unions as a matter of racial justice, and how those voices can possibly be heard more in the discipline process, whether a police department uses an arbitration system or they use some other type of disciplinary process that will allow Black police officers to be involved either in that process in some mechanism. So this is a paper from a gay couple was asked to talk about police discipline and racial justice to the American Bar Association's Labor and Employment Law section. And I started off by quoting from the song, where 1871, so at that time it's about 50 years now, a little more than 50 years, where he referred to trigger happy policing and panic is spreading. And it makes me want to holler. And as I try to think about ways to address these issues, that's certainly where I started. So from there, I then go to the issue of Black Lives Matter and thinking about evidence of systemic discrimination, because you have to start with that to kind of think about addressing some of the issues at hand. So, hiring discrimination against Black Americans hasn't declined in 25 years. The wages, median income, 60% of white income, unemployment, certainly, and all of these numbers were kind of created before COVID, so COVID is even worse than this, but significant differences for Blacks and unemployment. Incarceration rates are different for Black people, life expectancy different for Black people. And so we had Black Lives Matter, which in many aspects came significantly on the scene when we started with Trayvon Martin, and then Michael Brown and Ferguson, and so many others who have been killed. And so when George Floyd's death was so highlighted, and the killings by police of Black persons became an international matter in May of 2020, there was at least a desire to have some form of reckoning, from a national perspective, even an international perspective, as you saw protests go through not just the United States, but throughout the world. And so with that video that was so transformative, so difficult to watch, to see, the belief was that we would start to really see some transformative racial police reforms. Black Lives Matter certainly played a key role in these daily and international protests. There was a Gallup poll done in July 2020, 2 months after the George Floyd killing, where there seemed to be some resignation that everyone seemed to want some form of police reforms. But yet there have been more incidents, so many more incidents after, even most recently in February of 2022 in Minnesota, involving another young Black man. And so when you think about police reforms, at least one of the things that I try to focus on is transparent and fair processes. And there have been lots of calls for various forms of reforms. Defund the police, remove qualified immunity. Most of the federal reforms, there are various federal bills that are Federal Justice Act, the People's Response Act that are out there, but they're languishing in Congress, and with a filibuster-proof Congress, none of these things have been able to pass. And by the end of last year in May, states had passed at least 243 bills addressing reforms. These address things like chokeholds, no-knock warrants, requiring officers to use excessive force, some intervention by other officers, and those policing reforms are certainly ongoing. Because, of course, my background is in workplace law and labor and employment, I've come at this issue from the aspect of dealing with police officer discipline and asking for more counter voices as a form of protection. My thesis is that Black police officer voices must be heard, and through their unions, and I'm talking about Black police officer unions and associations and identity caucuses and affinity groups that they have formed, not the actual police unions. So if we think about what that would mean to hear Black police officer voices, there certainly have been some scholars who have raised questions that even raise concerns about Black police officer roles. And my intent is not to assert that Black police officers have a clear, monolithic approach to what should be done regarding police discipline. And so certainly scholars like James Foreman, who have highlighted some of these issues, and Devin Carvalho and Saul Richardson have raised some issues regarding, Black police officers in some aspects being part of maybe the problem and maybe not necessarily the solution. But as I looked at that, they're more looking at actual policing issues and really the dilemmas that Black police officers face as they are expected to adhere to the code of blue while also dealing with their own Black identities. For me, the issue is more framed by looking at these caucuses which have broader collective input on issues from a Black police officer perspective. If we look at Minnesota, when George Floyd died, and this is typical that you will see union leaders, primarily white men who are the union leaders who will be asked to respond whenever there's been some incident that's occurred. And certainly in Minnesota, Bob Kroll responded. He said all the officers were fired without cause, and he said their terminations will be likely reversed in arbitration. This led to many municipality and government leaders stating that they basically had, this reflects how arbitration is maybe the problem. I actually don't think that arbitration per se is the problem. Arbitrators basically follow what the parties dictate, and there's lots of provisions in collective bargaining agreements, officers' Bill of Rights, and things that municipalities and governments and politicians have agreed to. But when they have a high-profile decision and the arbitrator has followed essentially the procedures and requirements that those parties have agreed to, but the public is not connected to that and doesn't like the decision, then there's an effort to kind of blame the arbitrators. And this certainly happened with the New York Times editorial opinion, where the editors argued that arbitration should be abolished in police arbitration. So as I look at police reforms and I think about discipline, again, I think we get too wrapped up in demonizing various groups, and I kind of draw upon Derek Bell's interest convergence theory and look for ways in which if we're going to really have a transformative change and not be 50 years from now talking about police issues and another time when somebody's making a song that is highlighting these issues, we have to think about those interest convergence things. And my suggestion is that there is a role for Black police officers in this discipline, and especially through their caucuses and unions. And if there's an opportunity to allow that to take place, this resolves some of the, so instead of maybe blaming arbitration, some of the reforms have focused on that, but they don't have to. What they should focus on is changing some of the procedures and processes, and they can do that. And these unions have a motivation to deal with this because there are some legislatures that are coming in and just eliminating any kind of protections, as happened in DC. Oregon and Connecticut can remove certain of their officers' Bill of Rights protections. There's some that fund the police and remove qualified immunity acts. Maryland passed legislation over governor veto repealing and removing their officers' Bill of Rights. California passed legislation allowing the stripping of police certification once they commit misconduct. Minnesota, though, really focused mostly directly on arbitration and blaming the process of party selection of the arbitrators and preventing parties from selecting arbitrators. Again, I don't think that that's really the issue. In fact, that masks the problem by focusing on who selects arbitrators. But that certainly has been a focus in a number of areas where people have focused on arbitration decisions. And there's some terrible factual scenarios out there where arbitrators have issued awards and reinstated police officers. But if you look at the actual decisions that the arbitrators issue, they basically have reasoned opinions and awards. And, you know, out of full disclosure, I'm also a labor arbitrator. I've also served on a police panel. And so when you look at these decisions, yes, it may seem horrible that a police officer committed these very tragic disciplinary actions, but they end up being reinstated. And part of it is really the problems that the employer, the police department face in implementing their own procedures and following their own procedures. But yet that makes arbitrators really fair game. And you can blame these arbitrators, and that's kind of a way that provides some political shelter by blaming arbitrators rather than dealing with the underlying issues. University of Minnesota professor Stephen Beaver, who's also a labor and police arbitrator in Minnesota, has highlighted some of the things that really are the reasons why these management mistakes occur, and that's what leads to reversal of these decisions. They basically are procedural missteps by management. And yes, you can argue through reasons the parties have written these agreements. They can certainly change them and go to the bargaining table, get rid of some of these Officer Bill of Rights provisions and protections, but it's not the arbitrator that's the one that's created those provisions. And so I argue that it's best to bring in Black police officer rules. So if I think about Black police officer voices and caucus where you can bring in these Black police officers in a more formal way. There's tons of evidence where Black police officer caucuses and organizations have made their voices heard. Because they are a caucus, they're not the actual union, there really is not a clear mechanism for them to have direct and stop these organizations from taking stances and letting their voices be heard, and really in direct conflict with statements from their own police unions. So there's mentioned a couple of these organizations. So there's the National Association of Black Law Enforcement, and I highlight their websites here, but this is an organization that's got a number of police identity caucuses in a lot of states, mostly on the East Coast, where they are a clear advocate for issues of law enforcement, and these things come from their websites because of their focus. And with over 20 chapters and 10,000 members, certainly a very powerful collective voice in making statements about what kind of policing measures and specifically police discipline should take place. So if we think about this, then from the aspect of, and I guess somebody feel free to step in and tell me how much more time I have if you want. I can see.
Yes, you have about 5 more minutes.
Okay, thank you, I appreciate that.
Thank you.
All right, so so if we look at these Black police caucus organizations, and there's also the National Black Police Association. And I do highlight, I started writing on this about 1.5 years ago, 2 years now, and now their actual website's not operating, but they have a Facebook page, and there's also a Dallas National Black Police Association website where they have more information. But essentially looking at the mission statements of these organizations, where they're determined to have a voice, and they have been making their voice heard, as I said, and I think we should draw upon these organizations to have a more formalized voice in these disciplinary processes. Now, Sonia Pruitt, who was the chairperson of the National Black Police Association, now retired police captain, she started the Black Police Experience. And you go to that Facebook page, just a tremendous amount of really excellent information, stories, videos, capturing where Black police officers can play a role and have played a role, and in instances where there's problematic policing that has gone on. And so with that kind of input and under her leadership, that's really a key source for providing voices. Now, there's others who have been key voices as well. Heather Taylor was at the Ethical Society of Police in Missouri. Mr. Montag with the Cleveland Police Black Shield Association. Luther Hall, who was a St. Louis police officer, detective who went undercover during Black Lives Matter protest and was actually attacked and really beaten. Of course, our keynote speaker today, in terms of her experience with Buffalo, Brandon Hankins at Syracuse Police, Ira Carter, Larry Bankston. There's a number of ones, and I want to kind of mention lastly Carmela Means, who is a Black police officer in Chicago, and she's highlighted how she felt it was important as a Black police officer that her voice be heard, and despite her, the FOP president, union president, they're taking a stance that any officers who did anything that suggested any kind of connection with Black Lives Matter would be disciplined, and she took some steps, and in fact, she actually went outside the police union facility, took a picture with her taking a knee, and there was disciplinary action taken against her, but these were all really important ways to address this. The AFL-CIO, the Teamsters and SEIU unions put together a public safety blueprint for change. And this was in response to George Floyd, where they looked at these affiliate unions who are law enforcement unions in these organizations. Now, the FOP is the largest organization, was not a part of this. But they really decided that there needed to be a change starting with unions and that they should require their members to speak up and take action if they see violations. And this is the kind of way where I see there's a role for police officers. So let me end my little story by talking about a tale of two different police taking matters. On the left, you have police officers in the city of Chicago on the south side, where Black Lives Matter activists went to police stations and asked for support of Black Lives Matter. These two police officers took a picture with her, and she posted this. When that happened, the city of Chicago, then Mayor Rahm Emanuel, supported this. They ended up reprimanding these police officers because they said there's a general policy of being involved in political issues. And yet he acknowledged that there was a conflict because they want their police officers to support the community. Yet he did support the reprimand, and one of the spokespersons compared the act with another disciplinary action that had been taken against a white police officer for having a Make America Great Again sticker in the windshield of a police car. Then there's Winston Bowen on the right, who is a Black police officer in Mesquite, Texas, who's built relationships with his community there. They refer to him as Blade, named after the character played by Wesley Snipes, a superhero, Marvel superhero, vampire hunter, who they all love in the neighborhood. And he came here on Memorial Day a couple of years ago, saw some kids boxing, picked up some gloves. This picture went viral. He's now taken this further and started a boxing camp for kids in the community. So if we add Black voices, I think we can resolve this by open meetings, arbitration hearings, disciplinary hearings, Black police and other identity caucuses, maybe even bring in church and other community statements. We diversify arbitrators. All of this can be a negotiation and transparency at the bargaining table. So as I end, I mentioned a final song by Marvin Gaye, where he basically said what's going on. And if we think about this, we don't want to have 50 years from now when we're still arguing about being punished with brutality. So thank you very much.
Professor, if you don't mind, can you put your slide back up with the list of the Black police officers in the Caucasus, the leaders? If I could use that list for a moment. So while he's going through that, I wanted to bring that list up because as yeah, I think it was right after this one, Professor, the one with the list of individual, that one, yes. I am also a member of the Black Shield Police Association, as well as NABLEO, National Black Law Enforcement Officers Association, and as well as NOBLE, National Organization for Black Law Enforcement Executives. The reason why I wanted everybody to look at this is because we're talking about discipline. And if you guys don't mind, I'll probably pace a little bit here, so please stay with me. When we're talking about discipline and we're talking about how it affects African Americans within the police department, Black police officers, there is a huge disparity. It is a great gulf fix in the police world, regardless where you're Cleveland, Buffalo, or wherever. I wanted to show you this list because the name up there, Vincent Montague for Cleveland Police Black Shield Association, he was the president, just our past president of our association. And this is something that you guys probably have seen on Channel 8 News here in Cleveland recently. You probably saw that the police department put out that they fired him. They said that he lied in an investigation, that he lied while they were doing an investigation or doing questioning and what have you, that had something to do with a bribery case or something like that. Of course, they did not want to tell you all of the facts of this. So let's just take him, for instance, and you're looking at that. Basically, they said that they fired him because of untruthfulness. At the same time on Channel 8, you also have a Caucasian commander, not sergeant, a commander, in charge of an entire district, who there's overwhelming evidence that this person was untruthful. Not only was he untruthful in an investigation, but he was untruthful in court. He was untruthful in a deposition. It was proven in court. He's still where he is today. This happened 3 years ago, and it's still ongoing. He has not been removed from his position. He has not been removed from the job. So he's a commander, and you take that, and then you look here, a Black leader, and that's the one they wanted to go after. So I'm bringing this up to show you all the things that you've seen in the 40s, the 50s, the 60s, and the 70s when we're talking about race relations within the United States continue on today within the police department. So as we go through this whole issue of discipline, you'll start to see that what's happening on the street with officers, how they're interacting with people, it's really only a micro cause. It's really just a small fraction of what's actually going on inside of the police department. And so Vincent Montague, his crime for them, his crime was that he spoke out against some obvious racial tensions that he saw within the police department. He gave a Black voice to what was going on, and they put him on a list for it. Now, we know that more than likely he'll get his job back. As a matter of fact, they fired him while he was away in the military, which is a clear USERA violation. If I could just tell you guys a little bit more about this. He gave them notice. He says, here's the United States Navy says that I have to go away on this day. They said, what? Okay, here's what we're gonna do. We're gonna have a hearing for you after you're gone. So after he was already gone in the military, 2 days later, they decided to have a hearing without him there. He had his own attorney. His attorney showed up and said, hey, I object to this. You can't have a hearing without him here. We don't care. We're going to have this hearing. And then 3 weeks later, they come out and they said, we're going to fire you for what we had in that hearing. And that's what they did. And they put it on the news because they didn't want to tell you that they did this hearing without him even being there. They didn't want the whole public to know that. But that's what's going on, and it's clear. So they have gone to such extent with this as we as black people, black officers, begin to speak out more. As we push the envelope, they're pushing back even harder. To even go to that extent where you know that that's a huge violation, but nonetheless, they were willing to do it. It was sad that it was an African-American safety director that actually did this. I have no words for that. That was just sad. But going forward in discipline, I wanted to let you guys know a little bit about my background on the police department. In my 30 years, I spent my first 10 years in the 4th District on the street, and I come across a lot of things. But the one thing I found that was consistent regardless of where you went was how you treat people. I'm recalling the situation where I was in a car accident off duty on Kinsman Avenue, and I had my 1-year-old was in the back seat, and all the cries of your children, and it wasn't a cry for food, it wasn't a cry for diapers, but there was this cry, and I'm thinking, oh my God, did the seat thing break her, sternum or something? And so I lost track of everybody else around me, and someone punched me out of the crowd because, I had shown my badge and, doing the stuff that they had taught us to do in the academy. You get out, you show your badge, all that. There was a guy across the street on a payphone. Back then they had payphones. Some of you probably don't know about that. There was a guy across the street on a payphone. And it turns out I had just arrested him 3 weeks prior. And he came over, because I was woozy, he came over with this big stick and hit everybody and got everybody off of me, took me back to my car, sat me down, and stayed by my car with me while he called the police and wouldn't let anybody come do anything. And he said it was because when I arrested him, I had treated him like a person. I mean, get arrested, that's a situation. It's it's not like you're a bad person. Anybody can get arrested. Anybody in here could be arrested just leaving here on the campus today. That's not a big deal. But it was how you treat people that makes the difference. So as you go forward, and as a police officer, as you go forward, you start to see what they're teaching you in the academy versus what you know as a person. Exactly. And so when we talk about the police organizations, that was one of the tenets in the Black Shield Police Association, is that we become the conscience of policing. We have to be the conscience for our fellow citizens in our communities. And so all of that stuff that they teach you in the academy, we're actually trying to get it out of them. Slowly but surely, we're trying to get it out of them. Here's where the problem lies. Within most police departments throughout the United States, there is a culture, and culture eats policy for breakfast. The culture is that if I want to be a detective, and let's speak about Cleveland specifically, if I want to be a detective, if I want to get promoted, if I want to do this or that, I have to find the person or people within the police department who have the ability to get me there. Not by what I do, but just by them liking me. So those are the people who I'm gonna go out and drink with. Those are the people who I'm gonna hang with. And whatever they're talking about doing on the street, I am going to do the same thing so that I can achieve what I'm here to achieve. Because ultimately, I'm not a psychologist, but ultimately what I've seen in 30 years is that it's about a reward system. Everybody has some type of reward. Most of you gone to law school, if not all of you gone to law school, and you went for some type of reward. Your JD at the end of it, being able to take the bar, hopefully being able to practice after that. There's a reward system that all of us have, and we do these things based upon that. Within the Cleveland Division of Police, the reward system is this. If you're kissing my ring, I will give you what you want, what you need. I need you to go out here and go do that because those people over there are doing that, these people over here are doing this, and you go out and do that. Now, if you do that the way I tell you, don't worry about discipline. When we get ready to go and do this, we will, how do you say this? We will appease the people who are asking for accountability by at least bringing you up on charges. And then we'll say in the hearing that there was no evidence to say that you did anything wrong. Yes, it is that wide open here, which is one of the things that really prompted the writing of issue 24. When I was on the police commission, we wrote a very strong discipline policy. This discipline policy was built upon equality. It was a policy that's based upon equal, not equitable. I'll get to that in a minute, but that's extremely important that we understand that difference. This policy basically stated that regardless of what rank you are, regardless of what your last name is, if you do this, you get this, period. Why that's so important is because the DOJ, when they came in with the consent decree, they had to try and bring the Cleveland Division of Police, their discipline standards up to at least 1995. They were that far behind. We're talking about the police department that is in the age of the Jetsons, but operating like they're in the age of the Flintstones. I hate to be that harsh, but it's just a reality because I had to live it for 30 years. So they said you have to at least have mitigating and aggravating circumstances. You know, you need to at least be able to look at those. They took that and said, all right, we can say this person has mitigating, but that person has aggravating. You can guess who had aggravating, and you can guess who had the mitigating. And that's how it ended. That's how it turned out. I bring that up because there's a case that was settled by this particular safety director recently, where he had two people within a 3-month span before him, both of them for the exact same offense, which was a social media violation. One was a 4-year black female officer who took a photo with some kids where they were, well, not photo, I think it was a TikTok or whatever, where they were doing dancing, and she was wearing a uniform, much like the officer in that photo that the doctor had where the officer was boxing with the guy. Where you would think an officer boxing with somebody who's hitting him, that should be an automatic violation, but you never looked into why or what. So this officer was dancing with a group of small girls who wanted to be police officers, and she was dancing with them. They said she violated the social media policy because she did that in uniform. She was suspended for 20 days. Fast forward, 2 months later, there's a white male officer who is the head of the police union, who has 20 plus years in the police department, and he went on social media and absolutely just went after 2 African-American police sergeants. They said, well, we have mitigating circumstances for him. He wasn't in uniform. Well, he doesn't work in uniform. He's in the union, so they don't work in uniform. All right, well, we believe that he didn't really mean it. So he only gets 1 day suspension. The same violation, same safety director, within a 3-month time period, gives a black female 20 days for building goodwill in the community, and a white male 1 day for being malicious on Facebook. I don't want to get into some of the words they said because it was vicious. And he was talking about these other officers, which probably could have been a little criminal, but they didn't want to look at that at all. And in any case, that was the reason, or that was one of just a few examples as to why we wanted to go with an equal versus equitable. In the equitable format, which they're currently using, they constantly take a position that this is mitigating, that is aggravating. And while we know that we do have these issues in the police departments, here it's taken to the extreme. That was the reason why we need something that is equal across the board. And so when we were putting this together, we were speaking with people like the professor, although not the professor for this one, but we had a law professor from here in employment law. We had numerous human resource professionals, NAACP and others, when we were putting this together as to how to do this. And one of the things in this discipline policy that we thought was unique was that we would be able to have this hearing, but you have to have the Black Shield and the HPOA, which is the Hispanic Police Officers Association, in those hearings. They would have to be there. Currently, they're not allowed to be there. So whatever they do to African American officers, the association's not allowed to be there. So they would have to be there. But what we did that was unique was that after the deputy chief hears the case, and before the deputy chief gives it to the chief or the safety director to make a determination, it has to go through this board. And this board was a member of the Black Shield Police Association, a member of the Hispanic Police Officer Association, the IG, the Inspector General's office, and someone from Human Resources. Because what we found over the years, and the professor, I'm sure he spoke about this, was that a lot of cases were being overturned by arbitration. And it wasn't because of the arbitrator, like he said, he's 100% right. It was because the department just wasn't consistent with what they were doing. And oftentimes they were doing things that were in violation of what the city rules were. That's the reason why we thought we should bring in HR, because then they could get these things corrected before it gets to a penalty. Because once it gets to a penalty, the person's harmed. And once they're harmed, at that point, they're seeking, to get this corrected. So we thought we would do that. Well, lo and behold, even though there's a consent decree in place, the police department did not want to go, specifically the safety director did not want to go to this. Yes, sir. The safety director didn't want to go to that. He didn't want an equal format. He wants to keep everything in an equitable format, and it just wouldn't work. So income issue 24. It was written with this in mind, that the people can have a say, and the safety director will no longer be the final say. The people will be the final say. The people have seen some of these things. They spoke out loud about what took place with Vincent Montague because they saw it. They said, how can he do that, but keep this commander on the job and not even discipline him? So the way it goes now is that you'll have the mayor, then you'll have the police commission, then you'll have the safety director, then you'll have the chief of police. So both the safety director and the chief will have someone above them before the mayor. This takes away a lot of the political issues that were going on, because once a mayor selects a chief of police or a safety director, if you're a mayor, why would you want to fire them and you selected them? It sort of puts a lot of pressure politically. And in my 30 years, I've only seen one mayor that was willing to change chiefs of police. That was Mayor White back in the 90s. He didn't mind changing chiefs of police, but most mayors don't want to do that. This takes that onus off of them, where the commission could make that recommendation if this chief or if this safety director needs to go, and that's where that is. So with that, I want to thank you all for your time, and I'll stick around if you have any questions. Thank you.
Thank you both so much. I'm gonna keep my mask on with the hopes that you can hear me fine. I have a microphone. Let me know if I'm too muffled. Thank you so much, or Professor, I know I can't see, Green, right? Yeah, Professor Green, for your conversation, your presentation, your thoughtful scholarship. It seems to me that the importance and the relevance, though, of Black police associations and how employment protections are necessary to avoid particularly Black police officers from incurring disparate outcomes or promotions and punishment or reprimand, discipline in their police departments. It seems to me that that's distinctly different from the question about whether or not excessive force cases are an appropriate venue for arbitration, to be heard, whether or not arbitration is the appropriate venue to hear those cases. And so I would love for you to talk a little bit about, I want to make sure I understood your presentation right? I would love for you to talk a little bit about how, if you believe that arbitration is the right place for those types of cases, how the approach of looking only at the four corners of the contract, right, might be improved upon in order to bring in societal expectations, right, and constitutional standards in order to avoid seeing so many of the wrong police officers continuing to have badges and guns on our streets.
Sure, and that's certainly an important question. With the amount of time, I didn't want to get into as much of that because, I certainly come at this from a workplace perspective. And when you look at decisions made by arbitrators, and you mentioned the four corners of the agreement, right? The arbitrator, generally their role is to interpret the parties' agreement. And so they're kind of a creature of the agreement. And some of the criticism of arbitrators is that they don't take into account societal factors and maybe the conscience of the community or broader concerns regarding use of force that might involve kind of criminal procedure. And there's certainly a debate about, is that the role of the arbitrator? What my thesis is that the arbitrator is a creature of the parties, and the parties can certainly provide that mechanism for the arbitrator to do it. What the arbitrator can't do, though, is decide to do it on their own. And the reason for that is, and I know a lot of these police reforms are out there about arbitrators and selecting of arbitrators, and these assumptions that arbitrators decide cases around 50% of the time in favor of reinstating police officers is because of some perverse incentive to continue to get business, is really a misnomer to me. Most arbitrators, the really experienced arbitrators, are professionals that their reputations continue to precede them in every case they have. They're not concerned about a particular dispute or even a particular department or union because they do so much work with so many different places that doesn't guide their decisions. But they have an ethical duty. There's the Code of Labor Arbitrators that requires that an arbitrator cannot go against the wishes of the parties. And so if the parties don't want that, or the parties do want you to take on that role, and by the way, I do think they should do that. I think that the arbitration can have a role for that. There are arbitrators out there who would be more than willing to do this. Catherine Fisk in Berkeley along with several other commentators, about a year and a half ago, made several suggested reforms that would include arbitration. Whenever you talk to people who are arbitrators or who have background in arbitration, they're never talking about abolishing arbitration. They're basically talking about the parties providing mechanisms so that the arbitrators can take on that role. An arbitrator could consider some of the factors you're talking about. I think where there's a disconnect, and I'll give you just briefly an example. Rashard Brooks, which just happened in Atlanta, who was killed shortly after George Floyd in a Wendy's drive-through, asleep in a car. Police officer decided, rather than de-escalating, letting him get a ride home or whatever, decided he wanted to test him, and somehow he got a taser, he's running away, and he gets shot in the back. Horrible incident, caused a lot of protests in Atlanta. But you know, not long ago, it wasn't an arbitrator, it was a civil service commission, but an arbitrator probably would have done the same thing. They reversed the decision to terminate this police officer. And it's because the city, you know, maybe for good reasons, and I'm sure the mayor said it was really important that they send a message by terminating that police officer. They didn't follow their own procedures. You have to give, and this is constitutional procedure now, that says notice and opportunity to be heard. They didn't give sufficient notice under their own government code, and they actually essentially gave notice and terminated the officer within basically the same day. And so because they didn't follow those procedures. Now, if I'm the community, I'm upset. I'm worried that these kind of procedural devices get used to reinstate an officer when they committed egregious acts. The parties can certainly allow an arbitrator to factor those things in, but the arbitrator can't do it on their own. So I think there's an opening, if the parties want that, where arbitrators can do this. And if the community is allowed to participate in these arbitration proceedings, from Black police officers and even having community statements, I think arbitration could be a fair process. Because the reality is, if you take arbitration away, all it is going to do is these issues are, as long as police officers have Bill of Rights provisions, all of these protections, it's just going to go into the court system. So, anyway, that was a long answer to your question.
No, it's really helpful. I mean, I guess the thing then that I would love to know is, are you suggesting that the mechanism is something that has to be negotiated between the parties and placed into the contract, or is there a separate mechanism by which, when it's an excessive force case, right, the arbitrator, I'm not an arbitrator, you are, so please help enlighten us.
So, and I do think that the Catherine Fish, and it's not hers, I want to say et al, because there's like 6 other co-authors, but it's on the Berkeley online law review site. And what they suggest, it depends upon your state law too, right? So in Atlanta, the example I just gave of Rashard Brooks, that wasn't an arbitrator, but that was state government code law that was in place, right? So you either will have to change law or change it at the bargaining table, depending upon what you're authorized to do. So it could be either way. But to basically give the arbitrator that kind of authority and guidance and have provisions that might even say, one of the things she suggested is that even if there are procedural violations like that, if the officer has clearly committed misconduct, then you cannot use those kinds of procedural violations to reinstate them. And so that's, again, arbitrators might love to do that right now, but that's not how the parties have negotiated. That's not what these states' codes say. They basically say you have these procedural protections in place. So you either have to have the wherewithal legislatively or the pressure politically so that the union and the departments agree to not have these protections and allow it to be resolved. Because there will be some ultimate decision making, whether it's an arbitrator, a safety director, whoever it is, a civil service commission. And the real point is putting in clear statements of policy that will say, yeah, you might have certain procedures, and you're right, we didn't give you a notice, and within this time, we'll rectify that, but you still get to be terminated. Those are the kind of things that need to start to be in place, because this is a little bit different than a traditional labor arbitration setting when you're talking about lives that have been affected and people have been killed because of it. And so you should provide those kind of provisions up front so that the arbitrators can enforce those provisions.
I'm so sorry.
I'd like to ask Sergeant Jackson. First, I'd like to make a statement and then ask you a question. I'm glad you brought up the Montague case. They got him on a technicality, while white veterans on the police department were guilty of the same technicality under oath and in court, and as you point out, in depositions, while Vincent's right to due process were totally violated through the procedure. My question to you is about the new system. Having been present at the birth, when the issue 24 was written, and we developed this oversight system by the commission to review the chief and the safety director. We never talked about process. We never talked about whether there were going to be substantive rules in place, whether the system of, as you point out, mitigating and aggravating circumstances, which has allowed for the disparity in the outcomes, will still remain and be a part of how the commission approaches disciplinary issues. How do you see that happening?
Great question. Yes, the process, I see it more like this. The CPC, the commission, has already drafted a disciplinary, a new disciplinary guideline or general police order. With them being now at the top, they're no longer asking the safety director or the chief, could you please implement this? They're now telling them to. That process, on the front end of that, that's the process on the front end. On the back end of that is, how do I see it working? The way I see that working is that once they see that there's no longer this opening for the chief or the safety director or any other person who may be a legacy officer relying upon their last name to get them out of things, once they see that that's no longer the case, it changes things on this side with how they operate. Right now, you have a lot of officers that are doing things because there's an expectance on the other end that there won't be any consequence for it. When they start to see that there really is a consequence regardless, and it doesn't matter whether you're the safety director or the chief, a commander or a patrol officer, that all of this will happen to whomever does it. It will change a lot of what's going on over there. Additionally, I also wanted to say that that reward system that I spoke about changes how the officers think about dealing with people on the street when they realize that this person who they're dealing with today could be the person that will get them promoted 5 years from now, 6 years from now, or could be the person that will hold up their promotion. That changes how they deal with them. So that was one of the processes I was looking at.
Sorry, I don't have any thoughts about this at all. I think, Professor Green, are you still there?
I am.
Oh, awesome. Thank you. The screen just looks a little different. I couldn't tell. I'm wondering if you could help me to understand more. So my reading of some of the arbitration decisions, and again, I honestly am saying I am not an arbitrator, so help me. I'm here to learn today. It seems to me that policy or procedural decisions, contract violations are not the only reasons why officers are being reinstated after termination, right? That they have had all of their due process protections, and then the arbitrator is making a subjective sort of decision, if you will, about whether or not the conduct merited termination. I'm thinking there are a few, but the one that will probably resonate most with the folks here in this room is the FTO, the field training officer that was involved in the killing of Tamir Rice, right? He was there. He got all of his protections, his Garrity warnings, right? Time to make a statement, right? Notice a pre-disciplinary hearing and the like, right? And nonetheless, he's still a Cleveland police officer, and I'm not commenting on the appropriateness of that. What I want to know is that how do we identify whether or not that's a procedural defect, right, that an arbitrator is making, or if there's something else at play?
All right, so when I mentioned the procedural aspect, certainly that played a role in the Rashard Brooks case. But when you see a lot of these decisions, right, like I said, that was one of the points of my slides. There are horrible acts by police officers. But yet, when you look at the arbitrator's decision, and you said this, there's some discretion about it, but even the police officer was just talking here a few minutes ago about mitigating and aggravating factors, right? And sometimes when those get addressed, and by the way, the arbitrator is expected to address that if the advocates make those arguments. One of the key issues when sometimes someone gets reinstated and you hear this egregious misconduct they committed, and you say, how could they be reinstated? And I don't know the facts that went into that particular case you mentioned, but a lot of times what can happen is it's disparate treatment. And the officer was giving some examples of that when he was talking about how black officers, when he mentioned the social media, what can happen is you will see like an example where someone was handcuffed and the police officer punched someone and did these horrible things. And then when you get into arbitration, the union will bring in the evidence that some police officers at that same department, in that same unit, basically did much worse things and were not terminated. And so that disparate treatment gets presented to the arbitrator, and the arbitrator has to assess that in the context of what's presented in terms of disparate treatment. But I think when you look at the actual decisions, what happens then is like you'll have a police chief or a department head will go, this is horrible, we can't do anything, it's the arbitrators that are stopping us from doing this. But if you look at most of the decisions that are, you can maybe quarrel a little bit about some of the factors there. By the way, if you told me that I was going to develop a dispute resolution system that is jointly managed by repeat players with pretty equal bargaining power, like a union and a police department, and you told me that on average, the result would be somewhere around 50-50, I would tell you that sounds on its face like a fair system. But what happens is that people will hear these egregious situations and they will think, and the police department heads will say things like, well, this was, arbitrators are preventing us from disciplining police officers. And it is not the arbitrators, it is actually the acts of those departments in terms of not either having clear procedures, providing so many protections, or really how they are not enforcing their discipline in a fair manner when it comes forward. And yes, like I said, if they want to put in provisions that say, you know what, even though we haven't been enforcing these provisions in the past, we are now going to make a change, they certainly can do that. But there's provisions, usually police officer bill of rights provision, how far you can go back and look at things, and how far, how much time you get. And there's the things that those parties have agreed to be considered in the process. So I don't discount, arbitrators are not infallible, right? They're not always gonna be correct. And I'm not saying they are, I'm just saying that what happens is the parties create this process. And by the way, there's a number of these decisions where you will see union advocates, you rarely see union advocates complain about those 50% of the time when they lose. It's really the times when you see departments where they're losing and they're not really looking at the underlying analysis as to what was done wrong. Now you can blame the arbitrator and say, well, they considered these mitigating factors, they shouldn't have considered them or not. That's certainly fair game to assess what the arbitrator did, but you could have that, whether it's, like I said, it doesn't have to be an arbitrator. Somebody's going to be making a decision down the road. If you, again, I go back to Rashard Brooks case. If you go by the New York Times editorial, they suggested abolish arbitrators, make sure that it's some civil servant who's accountable to the public. Well, that's what you had in the Rashard Brooks case. And even after the decision was made and it was clear that they had violated these procedural mechanisms, you had the mayor on one hand saying, because of political unrest, because of the nature of what happened, she would have still done the same thing. That's a civil servant, you can rely on that. But you also had the governor of Georgia also come out with a statement, and he said, yes, police officers deserve procedural due process as well. So would you have left it in that civil servant's hand, or would you leave it in another? There's going to be some ultimate decision maker, and I think it's really incumbent that now that we have this impetus, this power that we hopefully have from this movement that's sprung from not only Black Lives Matter, but what happened to George Floyd, that we need to make inroads where it is clear what, because you do have some obligation to the really good police officers who do take risks and their lives can be at stake, that they know if I do X, I'm gonna be gone. And that they need to know that. And so you do the work up front and make it clear what those procedures are, and then you won't have the ability to wiggle out or have an arbitrator do X or Y because you made it clear what those things are. The problem has been is that you have, political power involved, that politicians don't want to be on one side of the issue of being weak on crime or not supporting civil rights issues, and so they do nothing. And then it just passes down the road with unclear mechanisms and leaving it as a contractual matter for an arbitrator.
Dean Adamson and Professor Hardaway, do we have time for more questions?
Yeah, we're gonna go into the break, so I see two here. Let's just finish what we have.
Okay. Professor Green, you've talked a lot about the mistakes that the police bureaucracy makes in these cases, and I think, Sergeant Jackson, you've said similar things. And I'm wondering what implications that might have, because in the discipline cases, we're talking about people who are represented and have advocates. But I'm wondering about the implications more generally for the way the criminal justice system works. If we see a lot of police department errors in these cases, what sorts of implications should we draw about just, say, the folks who are brought into court on low-level criminal charges?
Well, I'm a workplace scholar, so the criminal implications.
Professor Green, can I just ask that we try to be succinct? We want to have one more question, but completely succinct, and we want to move on. I'm sorry.
Yeah, go ahead and answer the question. You want to ask the other question too, and then when we get it out, and then we have time, I'll address it.
No, go ahead and address it, please, Professor Green.
Oh, sure, okay. So like I say, I'm a workplace professor, so the criminal implications, and that's another issue too, right? You still have potential for criminal violation. Then you're dealing with a prosecutor, they're dealing with different, burdens of persuasion and proof and what they can do. And so if you know that there's police department missteps, you certainly, hopefully, maybe the Department of Justice, depending on who's running the federal government at one time wants to do that and bring the Department of Justice in to kind of oversee those departments. There's certainly other mechanisms to kind of put checks on it, but it does raise questions when they can't do it and to be sufficient in arbitration.
Not in Cuyahoga County.
Hey, this question is for you, Professor Green, and for Officer Jackson. Hey, Michael, it's Dre Cummings here. I hear what you're saying. How do you respond, and I'd love to hear Officer Jackson respond to this too, how do you respond to those that would say that policing is so anti-black, it is so toxic, it is so descended from slave traders, etc., that all of this is just frittering around the edges? We really need to just root out policing as it's established in the United States and figure out a new way of policing, because what we're doing just doesn't work for black people and for brown people.
Well, certainly, I mean, for me, I think the root is at the people who are in the power to make those kind of decisions certainly should consider all different aspects. But for me, when I'm looking at a workplace disciplinary process, and I'm saying that, there's a way that this can be done, the problem has been that you have allowed, and police unions operate differently than most labor unions, where they have this kind of political power and they've been allowed these kind of rights to kind of create these rights. But that doesn't mean that there aren't also sometimes a lot of department missteps and inconsistencies, and as mentioned, maybe to the detriment of black officers, that you need to have protections in place for that. If you totally were to do something new, that's probably outside of my realm of expertise in terms of policing, but I'm not against that either. I think we don't want to be here another 50 years again and say we're still dealing with policing issues and trigger happy policing and have no answers, as Marvin gave us.
If I can address that real quick. I remember a criminal justice class where they had this book they were teaching the young people coming onto the police department, and it had 3 body types, and they said, this is the most dangerous. The endomorphic, the ectomorphic, and the mesomorphic. And they said the mesomorphic is going to be the most dangerous person you're going to encounter. Just so happens that the 3 photos in there to identify each body type, one was a Hispanic male, endomorphic, one was a white male, ectomorphic, and of course there was a black muscular guy in there who was mesomorphic. I hate to bring it to that because that's what you see. I personally believe that issues like issue 24 is a big step in eradicating a lot of those things, because it's more like, let's think about a business. If the customers are telling the store what they want, it's the store's job to make sure the customers get what they're asking for. Here, we're having the people who we serve, the citizens, tell the police, this is how we want you to police. This is how you shall police. And now, we're not asking, we're telling you. And if you don't do it, we'll take care of business.
I'd like to take this opportunity to thank our panelists. Dr. Jackson, Professor Green, thank you so much. This has just been a rich and amazing, thoughtful, and in some ways, some troubling lessons that we're learning here. We're about to have lunch. The box lunches are here. They're in right outside there, so grab your lunch and come on back and have a seat. And Ms. Horn is going to speak with us beginning at 12:30. Is that correct? At 12:30. And so enjoy your lunch. And we'll look forward to the conversation at 12:30.
Actually, he did.
I might bring it down here though. Yeah, I am. I might just take this.
Commission. Team. I don't know this team. And I'm doing.
Actually, people are better than this. Yeah, most of the people are virtual. So this one.
You're a great deal.
Officer Kwiatkowski retired from the police force after he was suspended for choking another officer on the job, a separate incident of punching another officer when he was off the clock, and most recently, Kwiatkowski and 2 other officers were indicted on civil rights charges for holding down a black teenager and shooting him with a BB gun. As for Horn, the city has sent her case to the state retirement system for a review. We contacted them for an update, but we haven't heard back yet. Joanna.
So that news story was, I think, 2014, but the incident happened in 2006. And like she said, you know, that officer, he was indicted with 2 other officers. Those 2 officers got off. And Gregory Kwiatkowski spent 4 months in jail and also sued me for defamation, saying that I lied about him being abusive. $65,000 is what he got a default judgment for because I did not know that I had court that day. And $20,000 he got. And now he's still coming after me now, after all of this, for $80,000. So when we were listening to Richard, I don't know your last name. Richard Jackson. When you were talking about the arbitration, you know, it kind of triggered me because during arbitration they did the very bare bones in representing me. I was fired twice. The first time that I was fired, you know, I really don't get into that one, but the point is it was a injury from the job. So when I got fired, I basically fought them and won. And then when I did, they fought me back and won for a minute. And so when I was off, I just was thinking, you know, no other officer should have to go through this. This is a lot. You know, to be fired twice for not doing anything or doing the right thing. So I said, I need to figure out what to do. And I said, well, if it's a law, people can't break the law. The good officers can tell the bad officers, I'm not going to jail for you. And that is why I wrote Carrio's Law. And Carrio's Law is a proposal for legislation to have a mandatory statute on police bystander intervention. That means we will never have another George Floyd happen. Provide protection from retaliation. We will never have another Carrio Horn happen. Require external investigation and mandated reprimanding for abuse or misconduct, and create a required reportable registry. Because if we have a national registry, an officer can't go from Buffalo, New York to Cleveland, Ohio, or to California. So we need that national registry. So back in 2019, I was in a homeless shelter. I wasn't there because I drank, smoked, did drugs. I never did any of that. I was there because I had PTSD and did not realize that was what it was. I just knew that I was tired of fighting. I was tired of trying. I got a call from Terry Watson. He was the founder of Strategies for Justice, which is a speakers bureau in Pennsylvania, and he also works at Penn State. So he called me and he says, you know, I've been trying to get in contact with you. And I said, I realized that you have for months. And he says, could you come out here and speak? He was having a symposium. And you know, I basically didn't want to tell him that I was homeless at the time. So I basically just said, you know, I don't mind. He said, and you can be paid for it. So I had been speaking, telling people the story for free. So when he said I could be paid for it, I was like, really? And he says, yeah. He says, I can probably get you $2,500. Is that good enough? And I took the phone away from my ear and looked at it. And I said, is it good enough? And that's when I told him, I'm in a homeless shelter right now. And I have no money. So $2,500 would really be great. So that's when I started speaking to him about the law that I had written, but I didn't know how to get it passed, because when you're going through PTSD, you can't think straight. Your thoughts are racing, and that happens a lot. That's why I was sitting there, I was listening, but also trying to make sure that I stayed on task when I told you this story. So he helped write Carrio's law so that it could be presented, so that it could be passed as a law. And there's 6 sections to it. The first one is the duty to intervene when officers pose imminent threat to citizens. Of course, that's what I did, and that's what I was fired over, but like I said, I didn't want it to happen to another officer, so that is why I thought that was important. The second one is accountability for officers neglecting to intervene. Just like in the George Floyd case, we saw why that matters. Protection for officers who do intervene. I didn't want any other officer to be fired like I had been. Accountability for falsifying reports. Boy, did they lie, let me tell you. When the news story came out and it said that I jumped on Gregory Kwiatkowski's back, and then I turned around and I pushed this other officer, it's like, me reading that, I was like, wow, I must have had an S on my chest, because how could I do all of that? And how could somebody believe it, that I can jump on someone's back when we are face to face with the person between us? So I felt like a superhero. I became a superhero, I guess, by writing this law. But anyway, they lied, and Gregory Kwiatkowski was promoted. And that's when it really became an issue for me, because I said, I could be fired and he can be promoted. Well, anyway, section 5 is accountability for officers neglecting to, no, that's section 5 is impacts the policy regarding termination and departmental funding. That is important, because if the department lets it go on, then they should not have the funding. They should not be actually, we do have to change policing as the way it is right now. But that is something that all of the police departments want. They want that money. And the way they're getting the money is by using people as a commodity, which is wrong. And we need to basically stop all of that. Section 6 is restorative justice, which is what helped me get my pension for the retaliation of whistleblowers. Jerry says I'm an intervener. He says, you're different, Carrio. You're an intervener. You have people that will speak up about it, but you actually did something. And this was in 2006 when it wasn't popular. But that law helped me to get my pension. And when the judge decided that, he would overturn the decision to fire me, he quoted the words of Dr. Martin Luther King Jr. He said, the time is always right to do right. The city of Buffalo has recognized the error and has acknowledged the need to undo an unjust from the past. The legal system can, at the very least, be a mechanism to help justice prevail, even if belatedly. While the Eric Gardners and George Floyds of the world never had a chance for a do-over, at least here the correction can be done. It is therefore the decision of the court as follows. The petitioner, original motion to vacate the decision of this court dated July 26, 2010, and the order and judgment thereof dated August 4, 2010 is granted. The findings and recommendations of the hearing officers are hereby annulled. When we talk about these arbitration hearings, this is really important. The termination of the petitioner as a City of Buffalo police officer based upon such findings and recommendation is hereby vacated, and the petitioner's amended motion for a cause of action under the newly enacted city charter provision is likewise granted. The court finds the petitioner will have been physically capable of performing her duties during the time period for which she is seeking relief, and the petitioner is therefore reinstated as a police officer within the city of Buffalo, non-pro-tunc, for the period of July 26, 2008 through August 4th, 2010, which is when I could retire. I am still waiting to get a check, but I am, in quotes, officially retired as a police officer. That'll mean more when I get a check. But I am thankful, always thankful. And then in 2021, the Kathy Hochul, she's our governor. She basically, well, I'll just read it, okay? Horn was fired on arbitration recommendation after an incident in 2006 where she says she stepped in to stop a fellow officer putting a man in a chokehold. It wasn't until 2021 when the New York State Supreme Court Judge Dennis Ward vacated her firing, saying, to her credit, Officer Horn did not merely stand by, but instead sought to intervene despite the penalty she ultimately paid for doing so. New York owes Carrier Horn a debt of gratitude for her service to the Buffalo community and for her bravery in a moment of crisis, Governor Hochul said in a statement on Thursday. I am proud to sign this law, which will correct a longstanding injustice and ensure that Officer Horn is treated with the dignity and respect she deserves. The city of Buffalo was previously ordered to give Horn back pay and pension contributions back to 2010. Still waiting on that check. I was speaking to Geneva Reed. Geneva Reed is Sandra Bland's mom. I actually bought her obituary. I forgot. I left it over there. But she said that she went to her grave just last week. Matter of fact, no, it wasn't even last week. It was a few days ago. And when she went there, she said that there was change on her grave. And when she explained to me that, because I was thinking, why would somebody put change on her grave? She says, because Sandy made a change in this world. And so we were talking about all the work that we still have to do. And I was like, well, we have to make changes. There's things that we still have to do. And I said, well, when I go speak, I said, Sandy can speak through me. Because she had a YouTube channel where she says Sandy Speaks. So I told her I will bring her with me and I will make sure that she can speak through me. Because the system is making money from our bodies through jail, the hospital, also mental health. That is something that is real big now. In Buffalo, we just had someone that was shot by the police within the last week who had a mental health crisis. In the video, it was a video, he was coming at the police officers with a knife. But I said, well, if someone is scared of spiders, you don't put them in a room with spiders. So I'm not sure if the police triggered him. As far as the shooting, I think that it was justified because he was coming at the officers with the knife. But I think that we need to change how policing is, how it's done. And we need to deal with mental illness differently. Because if you're sending police officers to deal with someone who has an issue with police officers, then it's only going to trigger them. And if the only solution is to put them in jail, because now charges are pending against that person who had the mental health crisis, then I think that, as a nation, we need to change the way we have our thinking. So I just want to have a candid conversation. not worrying about this mic or the video or whatever, because I'm sure that we have solutions that we can talk about right now and implement them from this day forward. But before I do that, I'll let you play that video. This is a video for National Call for Carrio's Law. And I do have Carrio's Law bracelets. Now, I'm not selling them, but donations are welcome. Andrea is a local artist. She and Dr. Rami Nashashibi from Chicago made this video.
Little Mahmoud on his way to school. Uzi submachine gun, boy don't you move. Threw off his pack, slipped on the cracks. Hands in the air, bullet in his back. Mama, please, I can't breathe. Get these demons off of me. Got the knee on my neck, I'm on the ledge. Baby, come home, don't feel that dead. Ooh, ooh. Boy, please, dogs off the leash. Maria begging, don't take my Louise. Cold and afraid, kid in her cave. Gripping the sky, praying to be saved. She's crying. I can't breathe. Ooh, the day of water. Hurry, come on. Oh, oh.
Chose these parents. They turned me into an automatic. They got a knee on her neck. I got a foot on her neck. They gotta deal with it death. They gotta cut us some checks. For me on this law, and carry this law. I dare you to draw, my every is raw. Niggas can dream on from me on the beyond. They must have forgotten everything we on. We can't be sorry. I leave around me. See me with dreams while I'm busy from Valley. Want me to suffer and scream for my mommy. They must have forgotten everything I be. I'm a descendant of slavery. I'm a descendant of trauma. I'm a descendant of shamans. That's my mama, 400 years. That's our trauma, millions of tears. That's my mama, 400 years. That's our trauma, feeling the fears. That's my mama, 400 years. That's our trauma, feeling despair. That's my mama, 400 years. That's our trauma, joyous repair. That's our mama. Please, I can't breathe. Can't think secrets off of me. They got their knee on my breast. We're unlatched. Babies come on, don't feel it dead. Please, I can't breathe. Can't these demons off of me. They got their knee on my breast. We're unlatched.
questions? Oh, before we do that, I want to say who helped me. Harvard Law, Dr. Intisar Rabb, and Ronald Sullivan. At Kirkland and Ellis, Neil Eggleston, Sarahi Constantine Padilla, and Cameron Bajwa. Those are the attorneys that helped me to get my pension. So now I need everyone here to take one of those, or all 6 of them, you can take all 6 of them, one of those sections, all 6 of the sections, and get it passed in your city, state. Help me pass it nationally. I can really appreciate that. Any questions? I know I didn't answer everybody's question, right? Go ahead, Ms. Pat. Oh, okay.
Thank you so much, Carol, for joining us here today. I was wondering if you could talk about Derek Chauvin and George Floyd for a moment and what you would have done had you been there today, or if Carriel's law existed in Minnesota, how would you want those brand new officers to have responded to what that officer was doing? And would that be part of their training? Because part of the issue was they claimed, they were brand new on the job that day, or pretty close to it, and they didn't want to interfere with this veteran officer.
Well, the first training you get is home training. The thing about it is we don't know what they're learning at home. So, as far as the police department, I was told that if I see officers fighting, to get my little foot and kick too. I didn't think that was right. I mean, I understood it because that's what my mother said, not in those words, but if I saw my sister or cousins fighting, that we couldn't just leave them there. So I understood, but if we're supposed to be professionals and we had such awesome training, why would I have to get my little foot and kick too? So that never sat right with me. And as I got on the police department, there were a lot of things that were not right. As far as Derek Chauvin and the other officers, they were adults who had training and they should have had common sense. So they should have stopped. I mean, it was 9 minutes and 26 seconds. Like, at what point does common sense kick in? So because it didn't kick in, then they should have been charged and they should have been found guilty like they were. But if I was there, I'm sure that I would have stopped it. And I actually think that, I'm not sure what Minnesota law is. Somebody here from Minnesota, they can tell me. But in New York State, you can come to the aid of a third person. So I'm not sure, it doesn't specify a police officer, or could a citizen come against a police officer. But if I am bound by that law, then the police officer should also be bound by that same law.
What I would like to say, I think we all should give Carol a hand for standing her grounds.
That is my godmom, so she's going to.
So I met Carol during her case. I didn't know her. And so when she got ready to go to court, the hearings and things, they denied the community to come and sit in and on it, but she fought for us to come in and demand it, and it happened. We were able to come in and support her. So, and like she said, her law is, she's not anti-police. It's just for, her law is to support the good police officers and protect them. And a lot of us in Buffalo support Carol. And we believe in what she's doing. So you're always gonna have the naysayers, but majority of the people, they believe in what she's saying. Like she said, she's been traveling around. I've been hanging whenever I can, the senior citizen hanging when she can. But I love to support her, and I believe in what she's doing, and I pray to God she keep the strength to keep doing what she's doing.
And I thank Ms. Pat for always being there. Ms. Pat drives me nuts, everybody, but she keeps me on my toes. And as far as the naysayers, I don't worry about the naysayers. I'm just only worried about who has the same goal and wants to move forward.
So
I think we've had this distinction throughout this conversation about good cops versus bad cops, and there being both of them in this police force. Do you think the culture within the police departments across the nation, and specifically in New York because you're there, does the culture prevent the fostering of good cops to want to come to the police force and stay on the police force, and then when they are there, giving them the ability to intervene like you did? Does the culture foster that type of ability for police officers, good ones, to intervene? Now, I would say.
Well, that is one reason for the law, so that the good officers can weed out the bad officers. Like Ms. Pat said, I am not anti-police. I do believe that there should be some changes in the police department, and I am for defunding the police. And that is not to say, I want the police to go out there with not equipped for a situation where their life may be in danger. What I am saying is that there should be more money in the community. If there is for example, in Buffalo, it's around $141 million for the police department and $4 million for all of the community centers. I don't think that's right, because the community centers are centered in the community, and that's where people should be able to go and get some help. So I think some of that money should be filtered through the community centers. Somebody else had their hand up.
You didn't condemn the Buffalo police for killing the man with the knife. How do you feel about the Rochester police who answered a call for a mental health situation? And I think the deceased's name was Prune, Mr. Prune.
Prude.
Was outside naked, and all they could do was put a bag over his head. And they weren't prosecuted or, as far as I know, disciplined by the Rochester police just down the road. What do you think about that?
Well, in the case that happened about a week ago, I don't know all of the specifics, and he didn't die. So, no, I can't really give an informed opinion. That is pretty much why I didn't condemn them. But from looking at the video, it looked justified from the way that it happened, with the guy coming towards them with the knife. But as far as the background information before the cameras came on, I don't know what that situation was. So I can't speak on that. As far as Daniel Prude in Rochester, I think that was horrible, the way that he was treated. I think it's horrible the way someone who is just driving down the street and gets pulled over for a headlight, Sandra Bland, for instance. I think it's horrible how they are treated. And, I try to get people to understand how one police officer initiated arrest feeds the whole justice system. It's like if I pull you over and stop you, lock you up for whatever reason, then you're gonna have the judges, the lawyers, the staff, the parole, probation, all of these officers are going to be correction officers because the end goal is prison, of course, to fill those. But all of these people are going to feed off of one person going through the justice system. So a lot of things need to be changed. And as far as police officers getting paid to go to court, I think that should just be part of their job. And I think you would see arrests go down a lot if they're not being compensated.
Thank you so much for being here. So I asked the previous panelist about the culture, the toxic culture of policing and the anti-blackness and sort of policing evolving from slave patrols, so that it's always been about controlling and harming black bodies. I'm wondering if you could talk to what it's like for a black police officer to be in that culture, to be in the culture of a sort of anti-black, policing and harming black bodies sort of evolution, and whether you think black police officers can combat it through the inside, through like sort of being a part of a toxic culture and trying to change it.
It feels foreign. It feels like something that I didn't experience growing up. To be somewhere where you're not wanted, but you got there in a justifiable way, and then they want you to sit and watch people be abused, and you not say anything about it. For a long time, I didn't say anything about it because I couldn't. One time I was sitting in the patrol car, and there were some white officers beating on a black man, hitting him in the head with a flashlight because he supposedly had robbed a white woman at an ATM. And as they were beating him, he kept saying, I didn't do it, I know my rights. Well, I didn't know whether he did it or not, but I knew that he shouldn't have been beat like he was being beat because, you know, if you get hit in the head with a flashlight, you can die. So I sat there and I said, if they hit him one more time, I'm gonna stop him. And this was early on in my career. And they hit him one more time, 2 more times, 3 more times, they kept hitting him. And I just froze because I was saying, well, after I stop them, then who do I tell? There's nowhere I could go. So all of that, I mean, there were a lot of things that went on in the police department that were not right, and I couldn't do anything about it. So at the point where I did do something about it, I got fired. So it was all justifiable that I couldn't do anything, or I felt that I couldn't do anything. It was after being fired that I figured out what to do. But the environment, working on the inside, it was kind of impossible to do. And especially when they promote people who do things, who do abuse people. Any more questions? Right here. And if you feel like I'm not answering something correctly, hold my feet to the fire, because I can really get fiery for real.
So I have a question about whether you think that your law that was passed will encourage officers to apply to the police academy who might have been deterred by the culture on the police force. If now having that protection, if they intervene, if you think that will change the makeup of the police force?
Well, you have more officers who are like, more black officers, I should say, that came on in the 80s, who are now retired, who are willing to speak up. But, you know, some of them were not willing to give up their checks before. I mean, I didn't think I was giving up mine, but, you know, I did. So now they're more willing to speak. So you have more people who will speak up for them. So I think that if someone comes on the police department now and they have those issues, they have people they can go to.
First of all, I have to thank you. I don't think I did a sufficient job of thanking you for answering my call, right? You didn't know who I was or what I was asking for, and I'm just really grateful that you decided to join us. I know I said I was grateful, but I don't think I said thank you to you. The other thing, I'm hoping you might put a little, you said we could hold your feet to the fire, so I'm going.
Yes, you can.
I'm wondering if you could put maybe a little bit of a finer point on sort of your support for policing in America, right? So you said you believe in policing. And I do understand the very sophisticated nature with which you said, like, decreasing the resources for police, right, which is a way of defunding, right? Doesn't mean abolishing, but it is a way of defunding and putting the money where it needs to be. But I'm wondering, in light of the experience that you had as a black person, right, as a black woman in a police department, and you know what people like you are experiencing on a regular basis inside of police departments. How is it that we think policing is redeemable? And that really is a question that I would love to hear your thoughts on.
I think that it needs to be changed. As far as being redeemable, I mean, we have to deal with what we have right now, but I think that we definitely need to create policies, laws and policies for change. I don't think that it's going to keep working the way it's working now. I mean, I know it's not. You know, I think that, well, Carrio's law is a start. We can push that nationally. You have some good officers, some great officers, black and white. You have some bad black officers, and they need to go. So like I said, this is like sort of a bare bones, Carrio's law is bare bones. There still needs to be work on that. But I think that it's a start to help the officers get rid of weed out the bad ones. So right now, as far as a hard solution to change the culture, you can't change someone's heart. But what you can do is you can give more psychological exams rather than just one when you first get on the job. There needs to be mental health help. If there's a incident, like I said last week, there was an incident of a person being shot, and then you hear the officer. You can tell that he's disturbed by it, so he needs some help with his trauma, and that's a lot that officers are not getting. Help with their trauma. And you know, you want to be tough, you want to say, oh, I can handle this, I can handle that, but some people can't handle it. And it should be mandatory that they get mental health help after an incident like that. Or whenever they feel like they need it, or if someone else can point it out and say, I think that, you know, officer such and such really needs to see somebody, because sometimes they just don't want to go on their own.
I have two questions. The first question goes to, I'm sure the standards for becoming a police officer are different from those in Ohio, but I'll presume maybe the minimum education standard is a high school diploma, or maybe you could correct me. What is your opinion about increasing the minimum standards to become a police officer, whether it be education, the number of weeks you must complete in the police academy, and ongoing professional standards similar to how we have in law or medicine, that if you don't, you know, complete a certain amount of hours, you lose your license, or something of that nature. And then secondly, can you speak to this militarization culture? And I see it particularly for those who have served in the military, whether in especially in direct combat, that they come back, maybe some of that mental health has not been addressed, and then they perceive the streets as being what they experience in their deployment and treating residents accordingly.
Okay. Well, as far as being a police officer, I think the requirement should be that you, first of all, know how to deal with people. Let's just take the gun away. The gun and all of the tools, the tasers, the gun. And because I didn't rely on my gun when I went out there. I relied on my greatest weapon, which I was always told was my brain. And if I go out there, well, some people will fight me on that one, but I think that if a person is genuinely invested in their community or the community that they work in, that they won't treat people any type of way, and they will be more willing to help. So I don't think it's a level of education. I think that it's a level of maturity that you should have. And I think that, like when I came on, I was 20 years old. I think that was a little too young. I think that it was okay for me, but for some people at 20 years old, I look at the 20-year-olds nowadays, which we were talking about last night. We were like, nah, I don't think I want them to police my area. But the point is, I think that there's a level of maturity, and if your brain is not fully developed till you're 25, then why are you on a police department handling a gun when you're younger? Even though you have some seasoned officers who are out there abusing people, they just need to be weeded out. But like I said, it's a level of maturity, not necessarily education, because you have a lot of educated fools. Mm-hmm. Oh, I don't think that they do act like it's a war zone, especially in any inner city in the USA. It seems like it's a war zone, and in a way it is. I don't agree with that. I think that officers should really rely on being a people person, relating to people, and then maybe you could get through to someone where I can't, so it doesn't mean that I'm a bad person. It just means that me and the other person just doesn't connect. We don't connect. But as far as, all of the weaponry and more money into more weapons, and I don't agree with that. I don't agree with that at all. I do think that you do need certain things, and I don't believe that you need tanks and like pretty much machine guns. I don't think you need all of that. And if you need that, you need to call in the military. You don't need to be doing that anyway on an everyday basis.
Well, would you guys please join me in thanking Ms. Horn for sharing her story? We have a break, a 10-minute break. How many more minutes? We have 8 minutes until the next panel starts, 1:30.
I'll take care of it. Good to see you too. Look forward to our next meeting.
right? Like,
Yeah, it's just,
people with a lived experience, but the reality is that it's emerging for you, and so of course, right? You hit on all cylinders, and all different things become you. You know what I mean? And nothing at all wrong with it. I mean, like your expertise is outside of the norm of what you know.
Yeah, this is about,
Experiential.
you know, and it's similar.
Experiential expertise is what's important.
Yeah, he's here. He's
Yeah, Russell was helping him. No, Russell was helping him come down the ramp.
Yeah. Okay, cool. That's easy enough.
No, it's controlled. It's controlled. Exactly, it is. It's going really well.
I appreciate it. You didn't. I came up to ask you about the sound earlier, and I went to try to tell you thank you, but I just didn't tell you that I was trying to.
No, I didn't know. Yeah, I was going to. Yeah. I got 8 minutes. Don't you talk about me?
Oh, you do.
Oh, that's right. So
There was, another member of the, doing the microphone, so you're trying to coordinate.
Yeah, and then I was going to say.
just like that for this entire time.
We talked about this last night. All right, let me go let folks know we'll be in 3 minutes. You still look good.
No, it's too, that.
That's right. You know, that's right, Miss Pat. That's right.
She was like, here. I was like, I didn't mean I was getting something today. She was like, girl, take that.
It's not going to work?
I was going to say that.
Okay.
We don't want to, I don't want to get sick.
Oh, I see.
It's fine. Just let me know when you're
Sure. We're going to start next time in 2 minutes. We're going to have an improvise.
It's a really science and also a responsibility. And we probably need to be challenging situations.
you're gonna be so scared about all of this is that, you know, the people don't recognize this. 90% of their child, you know, the parents, you see that child missing. And literally, I mean, it's like,
You've been busy. You've been a very busy person. It's an honor. Thank you.
okay, yeah, I think so.
Okay, so we're going to get started. Thank you very much. It is my pleasure to introduce our third panel, the use of force and other and officer demographics. What do we know about race and gender of an officer impacts use of force? And for this conversation, we have a wonderful panel, a huge panel, and they're going to work it. That we're going to have this rich dialogue, wonderful conversation. They're going to offer us their perspectives, insights, research. And we're going to start with Professor Lisa Avalos. Professor Avalos is an associate professor at Louisiana State University, and her teaching and research interests are in the area of criminal law and procedure, with an emphasis on sexual offenses and gender-based violence. She is also teaching in the area of legal ethics. Professor Avalos' publications have appeared in the Brooklyn Law Review, forthcoming in the Nevada Law Journal, the Michigan Journal of Gender and Law, Vanderbilt Journal of Transnational Law, the Journal of Gender, Race, and Justice, and the Fordham International Law Journal. Professor Avalos previously taught at the University of Arkansas School of Law and was a visiting professor at Georgetown University Law Center. Now, prior to entering academia, she worked as an associate at McDermott, Will, and Emery in New York City and at Neal, Gerber, and Eisenberg in Chicago. She earned her JD from New York University School of Law. She also holds a PhD and an MA in sociology from Northwestern University and a BA in psychology from Northwestern. Prior to attending law school, she taught sociology at Grinnell College in Grinnell, Iowa. Thank you for being here. Amy Dunn Johnson is a family court judge serving the 6th Judicial District. Amy Dunn Johnson is a family court judge serving in the 6th Judicial District of Arkansas. She was elected to serve in that role in 2020 and assumed the bench in January of 2021. Her docket includes cases involving divorce, custody, visitation, child support, domestic violence, guardianships, trust in estates, and involuntary commitments. Amy previously served for more than 11 years as executive director, I guess I can take this off for a moment, director of the Arkansas Access to Justice Commission, where she coordinated statewide efforts to ensure civil justice for all Arkansans. She also served as the CEO of the Arkansas Access to Justice Foundation and Arkansas IOTA programs, which engage in resource development and grant-making initiatives to support the objective of increasing access to justice. Her prior time with Arkansas Access to Justice, Amy spent 6 years in private practice in the healthcare regulatory field. In addition to her work in the legal sector, Amy is an advocate for initiatives that promote health and equity. She's a founding member of the Harmony Health Clinic, a free health clinic that serves low-income, uninsured residents of Pulaski County. In 2012, she was one of 10 national recipients of the Robert Wood Johnson Foundation Community Health Leaders Award. Congratulations. Amy also serves on the University of Arkansas Little Rock William H. Bowen School of Law Racial Disparities Projects Steering Committee and Rural Incubator Project Advisory Committee. Co-research and co-presenting with her is her co-researcher and co-presenting with her is Professor Andre Douglas Palm Cummings, who's the Charles Baum Distinguished Professor of Law. He joined UA Little Rock back in 2018, teaching business organizations, Contracts 1 and Contracts 2, and related courses. Now, prior to arriving at Bowen, Professor Cummings was a visiting law professor at the University of Illinois Chicago School of Law, where he taught contracts, hip-hop, and the American Constitution. Why didn't they have a course like that when I was in law school? Well, hip-hop wasn't really invented when I was in law school. It takes a nation of millions. I guess so. What's going on? And he also taught at the, he was a professor of law at West Virginia University College of Law. But before embarking on his academic career, Professor Cummings worked as a judicial law clerk for Chief Judge Joseph W. Hatchett of the United States Court of Appeals for the 11th Circuit and for Justice Christine M. Durham of the Utah Supreme Court. Professor Todd Clark, who is joining us virtually, is a professor of law at St. Thomas University College of Law. Prior to becoming a professor there, he was at North Carolina Central University School of Law, where he taught business associations, contracts, corporate justice, employment discrimination, and hip-hop law and justice. At NCCU, he also served on the ABA compliance team and was the director of the Justice and Practice of Law Certificate Program and the director of New Initiatives. And before that, still, Professor Clark was a lecturer in law at West Virginia University College of Law, where he taught legal writing and appellate advocacy. He earned his BA in political science from Wittenberg University here in Ohio, his MBA from West Virginia University College of Business and Economics, and his JD from the University of Pittsburgh School of Law. Following graduation from law school, he practiced law at the law firm of Steptoe & Johnson. His scholarship includes a book, Corporate Justice, as well as numerous law review articles and other scholarship on social justice, corporate discretion, and sexual harassment. He is currently working on a case book in sports law. Mr. Conrad, Caleb Conrad is an Assistant Attorney General for the state of Arkansas, where his work centers on Section 1983 civil rights litigation and state agency matters before the Arkansas Claims Commission. Prior to his joining the Attorney General's office, Conrad served as a Deputy Prosecuting Attorney for the 11th West Judicial District of Arkansas. Conrad has written several articles on the relationship between adverse childhood experiences and the criminal justice system, progressive prosecution reform, and racial and social justice, having published in the Washburn Law Journal, the St. Thomas Law Review, and the University of Cincinnati Law Review. In September 2021, Little Rock Mayor Frank Scott Jr. appointed Conrad to a 3-year term to serve on the city's Commission on Children, Youth, and Families, where he currently serves as vice chair and seeks to provide policy leadership and advocacy that improves the health, safety, education, and quality of life of children and their families in Arkansas's capital city. And last but not least, we have Professor Christopher Bayless in the back. Professor Bellis is a professor in the Department of Criminal Justice and Forensic Science at Youngstown State University. His teaching includes and incorporates capital punishment, court processes, law, jury behavior, victimology, and criminology. Some of his most recent work includes the politics and policy of juvenile diversion programs, his book, Guns 360, Differing Perspectives and Common Sense Approaches to Firearms in America, and his article, Racial Variations in Work-Related Stress Among Police Officers. So he's got a lot to talk about too. Please join me in welcoming this panel.
Thank you very much for that introduction, Professor. And I have my little timer, so in addition to the official time thing, I should be paying attention myself. I just started it running. Okay, thank you all for having me here today, everyone. My topic is called Flying Under the Radar, the Under-Policing of Crimes Against Women of Color. And so I want to start by saying, you know, we've talked a lot about police brutality so far today. And I want to say that when police are busy strangling George Floyd and shooting Tamir Rice and committing other various acts of violence on patrol against many innocent civilians, there's also another really important job that is going neglected, and that is investigating and preparing cases for prosecution of really serious crimes committed against people, and I want to focus specifically on crimes committed against women of color. So, you know, as you heard, one of my areas of specialization is sexual offenses. We know that only about 3% of all perpetrators of sexual offenses get punished by our judicial system. Homicide, we do a little bit better there. Police solve about 50% of all homicides, but that also means that half of them are going unsolved. Cases are not being built for prosecution, and cases are not being brought, perpetrators are not being held accountable and brought to justice. And so serious crimes against women of color are basically the other side of the coin of police use of force against communities of color. Women of color experience some of these very serious crimes, including sexual assault, domestic violence, and homicide at disproportionately high rates. Women of color, black women in particular, make up 40% of all female homicides in this country. And yet these women are often ignored as victims and treated by law enforcement and prosecutors in ways that are inhumane and can even be despicable. And so the focus on police brutality leads to a neglect of these other really important crimes and results in a tremendous miscarriage of justice and a system-based enabling and endorsing of crimes against women of color. So I want to first talk about a few cases that show and illustrate what I'm talking about, and I'm picking 3 examples. It's so hard to pick examples because there's so many. So I'm just going to limit myself to 3, and then I'm going to talk about a couple of solutions that could be helpful here. So I want to talk by focusing first on a couple of serial murder cases and the case of a serial rapist. And what we see in these cases are 2 clear patterns that emerge. First, that where women of color are concerned, where it's women of color as victims, police often ignore victims and their families. When they complain of crime, they simply don't investigate. They act like it's not a big deal. And on top of that, perpetrators know that police will ignore certain types of victimization, and they act accordingly. And so let's look at the case of Samuel Little first. Samuel Little is a serial murderer who actually passed away. I think it was just recently in 2020. In 2019, the FBI declared Samuel Little to be the most prolific serial killer in United States history. He had a pattern of offending that included traveling across the entire country and raping and murdering women for 35 years, from 1970 until 2005. According to the FBI, Little confessed to having committed, late in life, he got around to confessing. He confessed to having committed 93 murders. At least 50 of those have been verified by law enforcement officers, so they haven't all been. And at least 3 of those murders occurred in Cleveland. But they occurred all over the country because he traveled a lot murdering women.
He was not apprehended until 2014, and he was convicted at that time in relation to 3 of those murders, and then died in prison in 2020. Ultimately, I think he was actually convicted of 8 murders before his death, but again, he's linked to at least 50, and he confessed to 93. So we might ask, how does a man get away with murdering dozens and dozens of women over 35 years? Well, Samuel Little himself told us how he got away with it. He said he did it by staying in the ghetto. So speaking with a female journalist in 2018, Little stated, "I never killed no senators or governors or fancy New York journalists. Nothing like that. If I killed you, it'd be all over the news the next day. I stayed in the ghettos." So his words showed an awareness that police would ignore his crimes if he stuck to vulnerable women of color. And he did. He murdered women only. He murdered primarily women of color, many of whom had other vulnerabilities, including mental health issues, socioeconomic status issues, drug use, and things of that nature, family estrangement, and so forth. Now, law enforcement are also aware that there's a nexus between race, gender, vulnerability, and being a murder victim, and that nexus is no accident. And so former police chief and president of the National Police Foundation, Jim Boerman, commenting on the Little case, said, "One of the unfortunate realities of policing is that departments that are under pressure to solve a variety of murders may pay less attention to victims from a more vulnerable population if they don't have the same organized community pressure to solve those crimes. If a killer wants to do as many murders as possible, they'll start to exploit those gaps in the social fabric and those weaknesses in law enforcement and victims that few people care about." And personally, in my opinion, I would tweak that to say people in positions of power maybe don't care about these victims. Certainly their families, their communities care deeply about these victims. A crime analyst with the FBI about Samuel Little stated, for many years, Samuel Little believed he would not be caught because he thought no one was accounting for his victims. Now, other serial offenders have targeted women of color for the exact same reason, evading detection for many years because they thought their victims would not be looked at with concern because police, people in positions of power, don't care about black women who are victims of crime. So the other murder example I'll give is Anthony Sowell right here in Cleveland. I'm sure all Clevelanders know about him. Anthony Sowell raped and murdered 11 African-American women whose bodies were found in his home in 2011. He murdered these women one after the other over 2 to 3 years in 2008 and 2009 without police noticing what was going on. Despite the fact that he was a registered sex offender, had spent 15 years in prison, they were supposed to be checking up on him. Despite the fact that there were victims who got away from Anthony Sowell and went to the police for help, including one panicked woman who escaped nude by jumping out of a second-story window at his house, flagging down a police car. They ignored family members who went to police and filed missing persons report and said, you know, my niece, she's gone. And one of those women was told, Sandy Drain, went to the police about her missing niece, Gloria Walker, was told, oh, well, she's a drug user. She'll come back when the drugs run out. They also ignored a horrific stench that was coming from Sowell's home and which was noticed by many people in the community, including a sausage factory, which was located right next door to Sowell's home, and which ran extensive checks to make sure that they were not responsible for the stench. So how can a police department be more blind to violence being committed against women of color than to ignore all of these different warning signs that they had here in this situation? And so Little's case was horrific because of the massive number of victims that he accumulated. Sowell's case egregious because he did it in plain view, right at his home, without even burying the bodies, and with police not noticing the evidence right in front of their eyes and their ears and their noses. Just quickly, Daniel Hotzclaw, we see the same dynamic. Hotzclaw was an Oklahoma City police officer who was sentenced to prison finally for 263 years for assaults on 13 African-American women during unnecessary traffic stops. Prosecutors said that for 6 months in 2013-2014, Hotzclaw targeted women he stopped while out on patrol, singling out poor black women victims with minor criminal backgrounds, minor arrest warrants, something like that, thinking that those stories would not be believed. And quoting a prosecutor here, he didn't choose CEOs or soccer moms. He chose women he could count on to not tell what he was doing. He counted on the fact that no one would believe them, no one would care. Like many other serial perpetrators of crimes against women, Hott's Claw became emboldened when he had so much success and wasn't caught, such that one day he stopped a middle-aged African-American woman who had no criminal history, and she actually called the police after being sexually assaulted by him. That initiated an investigation, and they found all of these other victims. And so those are 3 examples of perpetrators targeting women of color because they specifically know police aren't going to care about these crimes, they're not going to investigate them, and so these men can get away with it. I just want to mention a couple other quick factors that I've also seen in some of these cases. I'm happy to talk more about them in the Q&A, because you can imagine I have loads of cases I could talk about. We also see patterns where police will sometimes not follow the ordinary protocols that should be used in investigations, so they'll make exceptions when the victim is a black woman and not do what they're supposed to do. They will show callousness towards victims, not treating them with dignity, not respecting their humanity, and they will turn on victims to protect a defendant who was privileged by race or socioeconomic status or other factors, and turn on the victim instead. So those are some of the patterns we see in terms of this under-enforcement. So bottom line is there's a massive job that police are not doing, and this job is not as easy as pulling out a gun and shooting somebody in the back while they run away. This is a job that takes training, it takes experience, it takes resources, it takes commitment and accountability. So we have a job here that police aren't doing, and they need the tools to do it, and they need to be held accountable for doing that. So solutions. There's one particular solution I want to spend most of my remaining time talking about. And it comes out of an example we see in Illinois that could be adapted to a broader purpose, as I'll talk about. So Illinois, in the last couple years, has passed a law called the Illinois Sexual Assault Incident Procedure Act. And this is a law that's a very special law that could be used as a springboard for further reform. So what is it? This law requires certain procedures to be followed in Illinois in relation to every single report of sexual assault, eliminating the opportunity to ignore crimes based on the race or gender or any other vulnerable characteristic of the victim. The reason that this act was passed was that there was a group of prosecutors and a female attorney general, Lisa Madigan, who at the time really cared about doing something about sexual assault. They were concerned that sexual assault was an extremely serious and yet underreported and underprosecuted crime, and that changes to police procedures were needed in order to improve the law enforcement response to sexual assault. The state was concerned that sexual assault disproportionately impacts women, children, LGBTQ individuals, women of color, and yet rarely results in a conviction. They were also concerned with the trauma involved in sexual assault and officers needing to know how to constructively deal with that trauma so that they could do a more effective job interviewing victims. And so that's where this law came from. And so what does this law require? This law sets out a statewide response to sexual assault that must be followed by law enforcement agencies. They all have to have policies on investigating sexual assault specifically that meet certain standards that are set by the state. And you can find model policies on the Illinois website that can be downloaded by any specific department. Now, they will all have done that by now because there was a deadline for compliance. That deadline has passed, so all departments now have to have these policies in place. They have to provide robust training in sexual assault investigation practices, particularly using a trauma-informed approach so that they can do a better job with victims. And the law also includes detailed provisions on sexual assault evidence collection kits, more colloquially known as rape kits, and how quickly they must be processed. Now, here in Cleveland, everybody knows, I think, about what a big deal rape kits are and how if they sit on shelves, they're completely meaningless. So Illinois has established a tracking system that allows workers and victims to track the progress on each kit from collection to the laboratory to reporting the results to the police and to the victim. So just a few, I'm just going to touch on a few highlights of what this law does. Written reports. There's a requirement that every single report of sexual assault has to be memorialized in a written report. And one provision of the law says no law enforcement agency may refuse to complete a written report as required by this section on any ground. And so one of the issues is jurisdiction. In Illinois, if somebody reports to the wrong jurisdiction, the department cannot say, oh, you know, you need to go down the road to this other police department. They are required to take the report there. They are required to take a written report. They are required to send it to the correct jurisdiction within a certain amount of time, and they have to provide transportation to the victim if needed, as I'll set out in a moment. There are provisions as well in the Act that empower victims with information that equips them to follow up with the police. And all of these things are a way of empowering the victims to actually participate in the process and help make sure that the police are held accountable. So when a victim comes in to report a sexual assault, she has to be notified on the front end, first of the time frame that she has to get a rape kit. Some people might think, I went home and I showered, there's no point in getting a rape kit. Victims have to be told, you actually have 7 days to go to the hospital and get a rape kit done. The sooner you go, the better the evidence will be, but they can do it for up to 7 days. They have to be told that. Victims have to be told they will not be charged for hospital emergency services or for forensic medical services after a sexual assault. They have to be told that the forensic evidence collected in the rape kit will not be used to prosecute the victim for any offense regarding, alcohol, cannabis, or any controlled substance. They have to be told about civil remedies they have in Illinois, the civil no contact order. They have to be provided with information about that, and they have to be provided with a referral to an agency that can help them file for a civil no contact order. They also have to be provided with transportation to a hospital for forensic services or for emergency care. They need to be provided with transportation to the nearest available judge to get a civil no contact order, and they have to be provided with evidence about the sexual assault tracking, the rape kit tracking system, so that they can get their name and their password and they can log into that system and they can follow up and see where their rape kit is. They are also told that they have 10 years from the date of the assault to make a decision about whether or not they want that kit to be tested and whether they want to participate in a prosecution. So why this law matters? This law was specifically designed to ensure that serious crimes committed against marginalized people are taken seriously and investigated thoroughly. And there are a number of provisions I've laid out that make it easy for the victim to know what their rights are and to participate in that process. A corollary to this law, as far as I know, this law is only available right now in Illinois. No other states have passed it as far as I know. This law, though, I think it should be passed in all states, but it can also be adapted to be used with other serious crimes. So going back to Anthony Sowell for a moment, suppose we had a law like this and it covered not just sexual assault, which would be a huge amount of what we need to deal with, but if it also covered disappearing persons, if it also covered homicide, then when Sandy Drain went in, she went to 3 different police stations to report that her niece was missing. None of them would take a report in the Anthony Sowell case. Under a law like this, the first station she went to would be required to take a missing persons report. They would give her a way to follow up. They would be required to thoroughly investigate that missing persons report. So I think that a law like this can actually go a long way to make sure police are focusing on the job that they need to do, that we all need them to do, and that they're equipped with the tools and the resources to do that job. And then I'll just wrap up by saying, in addition to a law like the one Illinois has, many communities are now using a sexual assault response team approach to provide survivors with a coordinated community-wide response to sexual assault. And these teams are comprised of police officers as well as victim advocates, SANE nurses, prosecutors, social workers, and others. And this team approach to sexual assault is a way of holding police accountable for making sure they do their job, because all these other agencies and community members know what that job is and will hold them to task so that you don't have somebody not doing that job. We, again, can use that same kind of approach, and what Mr. Jackson was talking about with the changes here in Cleveland, I think are kind of similar, that the idea here is we need more transparency and accountability with police. It can't just be police supervising themselves, but we need community mechanisms for making sure police are carrying out the duties and responsibilities that we actually need to have them do. So I'll wrap it up there. Thank you very much.
Johnson, and I'm so honored to be here. I'm my distinguished co-panelists, and I'm excited to talk to you about the work that Professor Clark and Professor Cummings and Caleb Conrad and I have been working on that really focus on what we see as a thread that runs through what we are seeing in terms of police violence that particularly targets communities of color. We are very interested in looking at how our criminal justice system is actually at the epicenter of a public health crisis. And so we want to talk, and we're bringing a public health lens to this and examining how we have some self-perpetuating cycles that are happening that intersect with our criminal justice system and with policing in particular. The medical and health community have known for a number of years that when people come in with chronic and daunting health issues, that they can write a prescription and still cannot cure the people who are coming in. And in fact, it is well known among the medical and healthcare community in general that more than 30% of health outcomes actually rely on things that are completely and totally outside of healthcare providers' control. These things are known as social determinants of health. And our work focuses in particular on a subset of those social determinants of health, where we are looking at adverse childhood experiences. Adverse childhood experiences are traumatic events that occur during childhood, that is before the age of 18, and are often, they're the subset, of course, of social determinants of health, which, more broadly is the conditions where people work and live and grow and age. And, these kinds of things can include economic opportunities, education, housing, work conditions, food security, and those kinds of things. But the ACEs, adverse childhood experiences in and of themselves, are generally going to be in 7 to 10 different categories of adversities that may include verbal or emotional abuse, physical abuse, sexual abuse, neglect, living with someone who abuses alcohol or drugs, parental separation or divorce, having a mother who is treated violently. I think the remarks that Professor Avalos made immediately prior to this about gender violence. And that is one of the things when that's happening in a home is one of these adverse childhood experiences for the children who witness that. The incarceration or death of a member of the household, living with someone who was mentally ill or depressed, and then some of these, broader social disadvantage, economic hardship, housing instability, things like that. And the research is very clear that the more adverse childhood experiences a person encounters before the age of 18, the more negative health outcomes that person will experience as an adult. Quite literally, adverse childhood experiences take years off of a person's life. For someone who has 6 or more ACEs, they are likely to die 20 years earlier than someone who experiences no adverse childhood experiences at all. And we're not just talking about experiences that then make people likely to engage in self-destructive behaviors that are going to result in negative outcomes. I mean, clearly the research does support that people who experience childhood trauma are going to be more likely to have substance abuse disorders, are more likely to experience obesity, to do some other things where there may be some behaviors that result that are self-harm. But there are also a number of health outcomes that are just completely unrelated, that, where someone's more likely to develop cancer, 3 or 4 times more likely to develop cancer. And these are very compelling findings that we think are very important from the standpoint of informing how our criminal justice system and how policing in particular are part of that cycle that can reproduce that trauma for families and particularly for communities of color. And just real briefly before we move on to the other share. I'm going to do a quick screen share here, and I hope. Oh, it's been disabled. I don't know. Eric, is somebody able to help me out here with being able to screen share? I didn't realize it was going to be disabled. All right. So what I'm going to share here, this is the questionnaire that it's generally accepted as the adverse childhood experiences screening tool. And it's got some limitations, but there are 10 questions, and I'm going to kind of scroll through these. And I, want to say at the outset, I mean, many people have experienced these kinds of traumas, and these are, if this is something that you've experienced, it may be difficult to think about. And so I just want to warn you on the front end that these are some difficult things to reflect on. But we have, 12.5% or so of people who have 4 or more of these. So these are things that are very common. The original research study that was done on these in the mid-90s was really a, pretty wealthy, largely white, pretty affluent community. And the prevalence of ACEs, even in this community certainly suggested a pretty broad applicability of the findings of this study. So I want to run through just real quick what these ACEs are. And again, these are what happened before your 18th birthday. And I'm not going to read these for you. I'm just going to allow you to take a minute to look at them. As you think about these two, know too that for every ACE that you have, there is what's called a dose response effect. So the more of these you experience, there's a multiplier effect to the negative impact that this experience had on you. The survey does not take into account what's coming to be known in the literature as protective factors. This is just looking at the adverse experiences, but the research is also showing that there are factors that can hedge against the negative impact of these adverse childhood experiences. And I think as we think through policing in particular, there are some recommendations that we hope come out of our research that serve as those sort of ameliorating factors. It struck me the very first time that I saw this survey, how many of these do in fact intersect with the justice system. And even I think in my own docket, even though as a judge I'm not handling criminal justice issues, I'm doing involuntary commitments for people who have serious mental illness. I'm handling domestic orders of protection for victims of gender violence. And I'm seeing a lot of folks who are coming through who have the need for guardianship because their parents are in prison. So these are the 10 primary adverse childhood experiences that have been shown to have a material adverse impact on health outcomes for people as they move into adulthood. And so with that, I'd like to go ahead and turn things on over to my next co-panelist, who's going to talk a little bit more about how we threaded this work through our look at policing and on particularly on racial disparities. I think that it's really important that there is a clear link to racial disparities in health in all of this. And so at this time, I'm going to go ahead and turn it on over. I believe, Caleb, are you up next?
Yes, ma'am. Thank you, Judge Johnson.
But Judge Johnson and Caleb, before you jump in, I do want to say something that was just really quickly, and what you guys will find out about our group, myself, Professor Cummings, Caleb, and Judge Johnson. We will jump in on each other's presentation, but Judge Johnson made a very compelling point about the individuals that experience 6 or more ACEs compared to individuals that have no ACEs. And the research from this Kaiser Permanente study suggested that those individuals lived 20 less years. The thing that I thought was that we thought as a group that was very, very compelling about that is that study was conducted between 1995 and 1997. Approximately 17,000 people were interviewed, and out of that 17,000 that were interviewed, 75% of the people that were participated in that study were white. There were about 5% Latino and 5% African American, and this is the kicker. 75% of the people out of that attended college. So we're not talking about the people in underserved communities. We don't even know. I don't even know what the numbers would look like if we actually did an evaluation of ACEs on underserved communities. It might be more than 20 years. You might be talking about 40 years, right? So I think it's so important to sort of highlight that perspective, because these are the numbers among sort of the haves, not the have-nots. And one of the things you have to keep in mind about the fact when we're talking about the haves, even if they encounter those situations, have resources and access to resources that can step in and provide interventions in order to sort of right the ship, in order to give those individuals additional life expectancy, which we don't see in minority communities that often consist of African Americans or Latinos. So I think that's a really, really important point. And Judge Johnson, I'm sorry for jumping in.
No, I think you guys have 10 minutes left. I think when you look too at the two numbers that most determine someone's life expectancy is their zip code and their credit score, and I think that tells a lot about in particular how disadvantaged some communities are, and really I think how these adverse childhood experiences can concentrate in communities that don't have the resources to hedge against that. So sorry, Caleb, it's your turn now.
Social disadvantage is a category of ACE that seeks to wrap into one group trauma produced by economic hardship, community violence, discrimination, and historical trauma. And two of the leading factors working to increase the likelihood of traumatic experiences for children is poverty and racial discrimination. After all, a child whose home life is defined by consistent hunger, significant violence, and racial oppression experiences never-ending feelings of heightened fear and terror, and this leads to toxic stress. Toxic stress has been found to be one of the answers as to why childhood trauma impacts long-term health. It's unhealthy when our fight or flight sense is a normal, right? It's supposed to keep us safe. Nadine Burke-Harris likens it to seeing a bear on a hike. That stress response may save you in that situation. However, toxic stress happens when you live with the bear. And Black children experience much higher levels of toxic stress in the United States because they are Black. Being Black in America means that you live with the bear. And it's no surprise that a majority of Black children experience an ACE, at least 61%. It's also found that Black children are at least 45% more likely than white children to have experienced one traumatic experience, 29% more likely to have been exposed to two, and 21% more likely to have experienced three or more. Black children are then left to deal with the aftermath of the negative effects of trauma, and this includes their behavioral and health outcomes. This forces us to confront an ugly intersection between poverty and race. And my co-authors and I believe the research shows that Black children experience trauma because it is traumatic to be raised Black in America. And oppression and racial discrimination are not sometimes experiences, they're pervasive. They infiltrate nearly every aspect of a Black child's life, from his home environment to his school's disciplinary system to his nutritional diet and his relationship with caregivers. Black children spend less time learning about the world around them and more time struggling to survive within it. And therein lies the ultimate problem. It must be acknowledged that for decades and for generations, Black children have been forced to grow up in communities where traumatic experiences are often considered normal, and where ACEs are not things to be protected or avoided against, but instead mark a day in the life of Black America. Activist Kayron Valentine likens low-income neighborhoods and inner-city communities to a literal war zone. This is what he writes. For these kids, the war zone encompasses a place they call home. And home is a place where many of them are taught to strive to make it out before it kills them. For these young residents, the response is not post-traumatic because they continue to experience traumatic events every day. Low-income neighborhoods often lack adequate social and municipal services, possess higher crime rates, and are unable to provide opportunities for children to explore, socialize, and grow, not to mention how many families in these communities have been torn apart due to America's fascination with mass incarceration. Urban poverty passes from generation to generation. In his book, Stuck in Place, Patrick Sharkey wrote, he found that 70% of Black Americans living in the nation's poorest neighborhoods today are from families who lived in those same communities in the 1960s. His conclusion is simple. He said, the American ghetto appears to be inherited. We know it's no accident that neighborhoods of concentrated poverty are disproportionately Black. In The Color of Law, Richard Rothstein details that such residential racial segregation is the direct result of a history of deliberate federal, state, and local practices. This state-sanctioned residential racial discrimination dilutes for any protective factors against ACEs in these communities. In our previous work, my co-authors and I have argued that the criminal justice system should constitute an additional adverse childhood experience for Black children in this country. From the hyper-policing of Black people and Black communities to the racist charging decisions of prosecutors and what's called the invisible mass incarceration, which is the broken system of probation and parole. Our current system fosters further needless mass incarceration, continued police violence against unarmed Black people, and a criminal justice system that is not equitable and in fact is overtly traumatic and oppressive. To explain how our paper will build on that premise, I'm going to turn it over to Dre.
So Professor Clark and I are going to share our final few minutes talking about our current project. On behalf of the team, though, I have to say how grateful we are to Aisha Bell Hardaway and Brian Adamson for putting this together, to Merritt and her case law review team for hosting this event. Our work, as described, focuses on childhood trauma and how American policing adds undeniable trauma onto the lives of Black and brown children. But I want to be clear here. It's not just trauma. Police kill Black children. Tamir Rice was 12 when he was killed. Police kill Latinx children. Adam Toledo was 13 when he was killed. So what our project plans to do now is extend our work on childhood trauma to trauma experienced by Black law enforcement officers. We believe, and we will endeavor to look at how traumas impact Black police officers as children and how trauma impacts Black police officers as adults. Because it is our deep belief that Black police officers experience discrimination and trauma as children in exorbitant rates as described by Caleb, but also as they experience policing. Today, our keynote speaker, Carol Horn, described entering the Buffalo police force as foreign and feeling as if she could not change the way that Black Americans were treated by the police as the enemy. And so we will instrumentalize this research by interviewing Black police chiefs and longtime Black police officers who have risen through the ranks to retirement. We will talk to them and interview them about the traumas they experienced as children. We will interview and talk to them about the traumas they experienced as adults and how these traumas impacted their ability to police their communities. Professor Clark's going to take us home by describing how we plan to move our project forward.
So thank you for that introduction and sort of background, Professor Cummings, Caleb, and Judge Johnson. It's always a pleasure when I have an opportunity to work with them and to present with them. And again, we're very thankful of this opportunity to speak. But just to sort of transition in terms of where we're going to take this piece, we're actually thinking about this work in a sort of a series of works. One of the things that Professor Cummings mentioned in terms of doing the interviews with the police officers, we think that's really important to sort of get their own anecdotal observations because that tells a story, right? It gives us a narrative through which we can extrapolate certain things about trauma and the way that it has been observed in the context of law enforcement. But one of the things we also want to do is we want to make a concerted effort to do more data analysis in this area. When we were having this discussion about the data analysis, one of the things we did as a group, we have these wonderful robust sessions, and we were talking about just diving into the data. And one of the things we recognize is that there are a lot of sort of procedural challenges, IRB approval, as well as just in terms of getting people to participate. Judge Johnson had sent us this wonderful article about a researcher that tried to do something very similar to what we did, and this particular researcher ran into a lot of roadblocks, right? And one of the things is that he said he put together this study, and he said, I failed. I failed to put together the study. And so we were like, we had some ideas about why that might be. He talked about them a little bit. We could probably anticipate, as I'm sure you can anticipate, some of the reasons why it failed. One, there was ability to identify participants because of low turnout. So there was a fear that if people didn't participate in a meaningful capacity, that it would be easier for people to identify who the actual participants were in the study. So that created a problem. There was a second problem, which was that in the event that you have this discussion about mental health, and Black officers are experiencing trauma, and the agency isn't doing what it needs to do in order to adequately protect those officers or put them in sort of better situations to deal with those types of issues, that the organization will be stigmatized. So to avoid having the organization stigmatized, the organization doesn't participate to avoid getting data that can be used as a stick against it. The other thing is that there was also individualized fear from the actual participants that might participate in the survey. If their managers or their superiors or if their coworkers found out that they were suffering from mental harm, how would they be evaluated in the workplace? And so there were some fears there. And so one of the things that we want to do is, the reason we want to focus on the interviews is because we want to develop relationships. And in our first piece, we really want to talk about, we are not creating an environment where we're trying to penalize law enforcement or institutions that provide those services. What we want to do is engage in a process to help them develop better processes for policing, as well as for providing a safe space for the people that are providing the policing, because we believe that that will ensure and allow for more responsible policing of minority communities. And so part of it is sort of dispelling this myth that we are trying to attack you, and instead of thinking about this as we are trying to work with you. So our first piece is going to be set up to say, hey, this is not your problem, this is our problem. Let's work together. And we're hopeful that we will be able to establish key relationships with stakeholders that have the ability to allow us to get this data. So we're in the process of going through IRB approval in order to begin to conduct the data analysis that will ultimately be a component of a future article. And so I'll stop there without taking up too much time and to give you guys an opportunity to ask everyone questions. Thank you.
Hello. Well, Mike, can you hear me? I am unique in the sense that I am a professor of criminal justice at Youngstown State University, and we've been talking today about law enforcement and policing, and beginning on Monday, I am going back to Youngstown to train future undergraduate students who are going into law enforcement. So I think it's important to study some of the topics that we've touched on today regarding police training, whether that's appropriate, how much is appropriate. I'm going to talk about a number of things. I'm going to talk about use of force. I'm going to talk about the demographic variables in use of force and some of the research that has been done, which leads to accountability, which are some of the things that we want to focus on, and then potential change, what we can do. So when we think about use of force, one of the things that I was frantically writing is some of the other speakers were talking is about police training. And that's been a big thing in undergraduate school, because in Ohio, you do not need a college degree to be a law enforcement officer. You need 15 weeks, and that is it. At Youngstown State University, where I teach, down the hall from me is the police academy, one of many in Ohio, and they can go 8 hours a day for 15 weeks, pass the applied exam, and be done. And in some professions, you need a lot more than 15 weeks. So that's the training that is required in state of Ohio. Now, having taught future police officers, sometimes that can be a scary thing, because one of the things that was brought up earlier is whether or not those young students are prepared to handle a gun. Are they prepared to use force when they have to? Is their motivation, one of the articles I wrote about in a book chapter was the ethical use of police force. What is the motivation that is driving these very young undergraduate students to want to be a police officer, number one? Why do they want to be a police officer? And I will share a personal story with you. I had a student in my criminology class who I asked, why do you want to be a police officer? And he said, can I be honest with you, Dr. Bellis? He said, I want a gun. And that man is now a police officer, getting into it for the wrong reasons. And I don't want to say that that happens a lot, because there are students that want to get into it for the right reasons. But when you talked about psychological training and needing to really see what is behind some of these young individuals who want to go into law enforcement, so they don't end up in some of the sad cases we've seen in the Youngstown-Warren area, which is where I'm from, obviously. We've had a lot of Department of Justice investigations locally regarding police use of force, and hopefully they're trying to get those resolved. Now, the research shows that use of force is rare. From 2002 to 2011, 44 million U.S. citizens had face-to-face contact with police, but only about 1.2% were considered excessive. So we have use of force, obviously, and then we take it one step further to excessive use of force. So as some of the officers in the room know, the Department of Justice has a continuum on use of force, everything from verbal commands to, unfortunately, drawing your weapon. And then we have excessive use of force, and we look to see what has been considered or not considered reasonable. And that can be subjective or objective, depending on who you ask. One of the research things that I looked at with this, that ties with my other research regarding demographic variables, is research I've done on juries. This also gets to one of the presenters who talked about the race and gender of victims in crimes. So my preliminary research revolved death penalty, as he mentioned before, and that had centered on the issue of race as well, race of the victim. Does race of the victim matter in whether jurors sentence somebody to die? And there was a 1992 study, the very famous Balder study in capital punishment, that said it does. If you are African American and the homicide and all the factors surrounding the homicide are identical, you are 4.3 times more likely to get the death penalty. And that was cited by a number of court cases, in many opinions, as the famous Balder study regarding capital punishment. So that kind of introduced me a lot to different demographic factors and how they impact capital punishment, which is obviously the ultimate punishment. Also, demographics play a factor in how we perceive victims of crime. I know this because I interviewed real jurors in those cases. And depending on the status of the individual on trial and the victim, it matters to jurors. They told me it matters. They told me they are more likely to sentence a person to die if they kill a police officer, as opposed to if they kill an unworthy victim. And by unworthy victim, this is kind of, I think, what you were alluding to before. The status of the victim. We know from studying media and crime that definitely plays a huge role, those demographics, in how we look at crime victims and homicide. I don't know if you remember the Natalie Holloway case several years ago. It was non-stop coverage. What has the social science research showed us with respect to victims? That if you are a young, blonde, attractive female, you will get more media coverage than anyone else. Those cases in which it is a minority victim, and some of the research is going to show it that I'm going to present, not so much. It's not going to be on every, and pretty much that's just a ratings media driven viewership standard. So I went ahead and I looked at some of the research that kind of merges the two. How do jurors look at use of force cases when they do get that far? What do jurors think? So the first study that I want to bring to your attention is one in 2018, and it was mock juror perceptions of police shootings. And the findings, this is by Huff, Alvarez, and Miller, jurors do not fully understand police procedure, admittedly. Jurors are more concerned with whether the defendant is guilty. They revolve their thoughts more around that than any faulty police practices that are brought to their attention. Huff found, and he wanted to study what was called the bandwagon effect. Bandwagon effect is strong public attitudes towards a topic result in more strongly held individual attitudes, hopping on the bandwagon, right? So they were given in this study, now again, I'm a social science person, so obviously these are mock jurors, were given scenarios in which they looked at justifiable and unjustifiable use of force. They defined unjustified as where the police officer was unsure if the victim would use force, and justified if the victim was going to use force. What did the study show? The study showed that a police officer was more likely to be convicted when there was an unjustified shooting of an African American victim. Jurors paid, now this is contrary to what they thought, jurors paid more attention to a case when the victim was African American. So the bottom line of the study was mock jurors, again, expressed bias for African American victims and were more certain of their verdict. Why did the authors think that came about? The bandwagon effect, because this was done right after Black Lives Matter movement came to the forefront and all of the media attention given to these different cases. There was another study done that I wanted to share with you, just done in 2022 by Pika and others. It was called Guns, Gloves, and Tasers. Perceptions of police officers and their use of weapon as a function of race and gender. I won't go through the boring statistics, but what they did was they varied the race and gender of the police officers in these studies, and they presented them to, again, a set of mock jurors. What they found was mock jurors are more likely to vote the officer guilty when he was a white male and used a gun and when the victim was white. That was the highest scenario. The officer was seen as more favorably when he was an African American and did not use a gun. And then they did something else. They also took into account whether the police officer used force when they were either on duty or off duty. That definitely mattered. When the police officer used force when they were off duty was of course seen less favorable. And the weapon used also played a factor. Police officers were found more guilty when they used a gun than when they used anything else. And I think in the study it was a taser or a glove or something like that, because the idea behind it was that the officer had already had bad intentions with that gun, already had plans to kill with that gun. And when it was a taser or something else, that perhaps they were a little bit more able to give benefit of the doubt. The other study that I wanted to share with you was also hot off the press, was by Sturgis, Flick, and others. And they did something that I thought was interesting. They looked at civil jury compensation and judgment of police use of force at the intersection of race and mental health, which I thought ties into the previous topic. Basically, they were interested in studying how civil juries may award compensation to families of victims in use of force cases based on race and mental illness. And so they devised, and again, there are flaws with the methodology in many of these studies. They're mock jurors, they're not real jurors. These are scenarios that they are given. But they did come up with a wrongful death case where the family sought $10 million. These were vignettes, and they just varied certain things. They found that mock jurors were found the defendant not liable if the person that they killed had a mental illness, and specifically in this example, they used schizophrenia. The idea behind that was the stigma that schizophrenia is somehow, obviously they must have been violent, of course he used force. The number one factor that a lot of these variables also looked at as a mediating variable was the way people viewed the police, which is not surprising. So they call that police legitimacy. It had even an impact on the award amount that mock jurors would give. So if they had strong police attitudes, strong favorability, that meant less money for victims. And then the bottom line, it's just when the victim of a use of force case was African American, mock jurors awarded less punitive damages as their attitudes towards police became more favorable, as opposed to when the victim was white. So those are just the more recent studies that regarding jury decision making, and I think it's important because they're community members, right? That's where we get them from, and they are influenced by public perception and the way that we are viewing these. What should we do to change this? I mean, is there any hope? What might the recommendations be? I think there is. One of them, it was brought up about mental health. And I know that in Ohio, I'm part of a CIP training for police officers. I don't know if anybody has heard that. CIP is becoming more and more popular. It's crisis intervention training. Now, one of the recommendations is, when we've been talking about changes in organizational behavior, you have to get the police organization and the chiefs to want to send their officers. I went through the training. I am not a police officer, but I teach them. I wanted to know what CI training was all about, so I spent, now, here's the thing, it's 40 hours. I stayed for the whole 40 hours. What do they do? They do a fairly good job. They teach police officers about mental health resources. Not that they should become mental health professionals, but to be able to link and refer them to when they run into these type of situations. And as an observer in the back of the room, half of my students were there, which made me happy. That was because the Sheriff's Department in Trumbull County is a big proponent of it. There are other departments that say it's worthless. And I talked to many police officers that says, I have no intention, I could care less about education, and I could care less about CIP training. But at least that's one positive thing that we can do from an organizational point of view. And the other, from an individual point of view, is to kind of work with the people that we recruit to become police officers. I will tell you, locally where I live, they are telling me they are hiring, they can't get police officers anymore, at least in Youngstown. They don't pay very well. And they told me that they are willing to take just about anybody who applies. They've turned to me and said, Chris, I am hiring people I would never have hired 10 years ago. I can't get anybody. I can barely fill a class. And that's problematic because we are going to see more of these use of force cases if they're not properly trained. So hopefully, some of these recommendations will be useful. Always room for more. And I hope to study basically more of the jury behavior because I think it's important for accountability, and that's all I have.
Thank you all for your presentation.
You were talking about the stats for when police officers are abusive. The stat when you first started speaking.
Yeah.
Some of those abuses are not reported because sometimes they don't take the reports. So that's the point that I wanted to make.
Absolutely.
And Caleb, I need your notes.
I want to ask a question. Why would you wait until they become a police officer? Why check their mental status? Before, and then if they have a problem before they become a police officer, they won't be taken on the force.
Right. Well, no,
Would that be discrimination if they did that?
potentially it could be. Now, I don't, it's not my, I could get into a lot of trouble if I start, unless I have some concrete evidence to be able to identify these. From a professor's point of view, unless I can identify that somebody is going to be harmful or cause harm, it's usually up to departments that do the screening for it. I don't know what every single police academy does, but, if I don't see a sign, I can't go out and say, I know that you can't let this person into the police academy because I think he's going to be a danger. I better have something more. The university's going to come back on me because mom and dad called and want to know exactly why I am preventing their son or daughter from an education. I'm not saying you can't do it. I mean, if there is a mental health issue with any student on campus, there are procedures we have to follow, absolutely. But sometimes, you just got to pay particular attention to a few students and see if they really do warrant something further.
I think it's a good question. You also get into another ball of health, sort of another challenge. Like if you have a mental health disability or issue that's covered by the Americans with Disabilities Act, then you add a whole nother layer to that. And I think most of the testing that police departments probably will conduct to determine whether or not somebody is a mental health risk or has a propensity to engage in violence, it's really speculative at that point. So I think that might be another challenge about making a determinative decision about whether or not someone can or cannot do the job at that level. So I don't think you're wrong. I think it is a good idea to think about that on the front end, but I definitely think it's a careful sort of balancing that you would have to conduct in order to make that type of decision.
It seems to me that pairing that with some sort of support or intervention or identifying folks that may need some additional mental health support in order to be able to be effective. And particularly because right now a lot of police departments are going to include some sort of if somewhat cursory psychological evaluation as part of the application process to become a police officer. But if that can be paired with, some sort of structure that provides some supports to police officers who may have, in their previous life experienced challenges that could impact on their job performance, I think having those supports in place would be an important thing to be able to compare with that. So we're not just excluding people, but we're identifying people with more intensive support.
If I could just ask a question. So a couple of things. The first, I think I heard somebody say the American ghetto there's a quote, the American ghetto appears to be inherited. I would probably say the American government is used as the next iteration of concentration camps by the government. But right, because I think that the notion that it's intended to be passed down as an inheritance, right, is obviously not exactly what's happening here. The other thing that I would love for somebody to speak to, and this is Cummings et al., is, I certainly understand how the need to make sure that negative racial employment experiences, right, are documented and understood for Black officers. I'm a little bit less comfortable with the notion that focusing on childhood trauma only for Black officers doesn't somehow feed into notions of white superiority, if you will, right? That say that there's something wrong with Black officers and therefore we're seeing those outcomes on the street. And I would love for you to speak into sort of your decision making to limit your research in this way, and if you've considered that notion.
I'm happy to take that first, and the team can jump in. Aisha, it generates from the fact that at least I and our team have been so deeply embedded in looking at childhood trauma as it impacts Black and brown youth, and the fact that when Professor Clark identified that this study was conducted in San Diego with 17,000, mostly white, mostly college-educated individuals, that had that study been conducted in Black and brown communities, the statistics would probably be much worse. It would probably be a much more stringent or a much more significant life expectancy drop than what it already is. And so what we started thinking about was with Black and brown children that suffer these traumas that choose to become police. And our thinking there was, and this comes from a John McWhorter quote and something that we talked about in one of our articles, which is that John McWhorter said, he's a conservative Black writer, and he said that he never understood the OJ verdict until he started traveling around the country talking to Black people, and said almost every Black person that I met has a story about being abused by the police. And that one of our friends and co-authors, Donald Tibbs, talks about being 13 and having a revolver put to his head as a child by a white police officer. And that sort of led us into thinking that if so many African American and Latinx youth have traumas with police, why do they choose to become police? And our thinking is, my thinking at least, is that they want to be part of correcting a corrupt system, part of getting into a system that's corrupt. And yet, in getting into a corrupt system, a foreign system, as Carol talked about earlier today, then they receive additional traumas of being discriminated against and hated. We have a Black police chief, first ever in Little Rock, and there have been campaigns, false campaigns against him of sexual misconduct and all sorts of other things. And so our thinking on that front is just sort of identifying and extrapolating whether or not, I think one of our conclusions might be, we haven't done the study yet, but we think that one of our conclusions might be that this sort of hopeful thought of getting into policing to affect change is impossible, which gets into my questions earlier of what do we do when the system's toxic and rotten and anti-Black. So that was our thinking, or at least my thinking, in focusing on the traumatic experiences that Black police chiefs and Black retired officers may have faced as children with the police, what their intents were to become police officers, and whether they feel like these traumas enabled them to make the kinds of differences they wanted to get into when becoming police. And so that's where that's where my focus was in sort of moving and evolving the project forward. But I'm really curious to hear if my thinking is what Judge and Professor and Caleb are thinking.
I'll jump in. Aisha, I think that's a wonderful question. And I'll tell you this is that I definitely appreciate your concerns, because I think that all of us would share those concerns, because I'm always sort of mindful of sort of perpetuating a notion that sort of whiteness is inherently better than Blackness, and I'm very careful about that. I will say this: when in the nature of our discussions, I would say that the primary emphasis is on sort of Black police officers or minority police officers, but that in the context of the study and the evaluation that we would do, I didn't look at that as though we would only that we would only survey African American or minority officers. And I think that my colleagues would probably agree that the survey would be submitted to all the officers, because I think it's important to look at both minority and non-minority officers so that you can get sort of really good comparisons in order to sort of extrapolate the data that we would need to extrapolate in the ideas and the connections that we're able to see. So I would say that we would look at all groups, but that the reason that we are conducting the survey is because of a sensitivity to the issues that specifically impact minority officers. And really, when we began this discussion, it kind of grew out of, Professor Cummings was doing a lot of work after the Black Lives Matter movement. He wrote, I don't know, probably like 10 articles in the past year or two just about that sort of that movement, and sort of the genesis of all of our discussion grew out of that. So we were very laser focused on African Americans, Black officers, and so if we have kind of presented this ideology that we're only looking at Black officers, I think that we might have maybe overstepped a bit in terms of stating that, but we are going to survey all groups because that's important for us to get good data so that we can really look at the population that we were most concerned about. And I'm going to be quite honest with you, I think that we all have some sort of hypothesis, but part of this is like we believe that we're going to learn as this goes on. I mean, I think that the researcher will tell you that, like, he couldn't even get the data, so we didn't even get a chance to engage in that learning experience. And so those are some of the things that we're really excited about the project, and we think that there could be a lot of value in it.
Thank you so much. I could have this conversation with all of you really for the rest of the day, but my bosses are telling me that we are over time.
And so we might have to get you would love our little powwow telephone calls because we go at it.
Let's do it. Please invite me in. I'm ready.
We're going to hold you to that.
I'm serious. Okay. We have our next set of panel presentations starting at 3 p.m. And so take your little water break.
Thank this panel again.
Oh, thank you.
Just Tara, but not Craig or Sean. No, not yet. On the screen. Not Craig.
I appreciate it. Thank you.
You know what? I don't think so.
Yes, thank you. Yeah. So he already is way above and beyond the level.
Oh, how'd that go? I just never. I can't keep going.
Okay, Craig is here. We just need Sean.
So there's 3 of you left to go, and you have right. Don't be thinking that all of you have 10 minutes.
Okay. Oh, good. Yeah. Okay.
I was shaking. So I need to not about time.
Actually, the FBI a couple years ago.
Professor, are you introducing the next panel? Okay, perfect.
In order to help, to help identify.
I was shocked. I know. You're like, where am I? What's happening right now?
Oh. He said, all right. Yeah, here we go. Anthony Salwell, SOW. How many guys did he do? You know, that's really good. Yeah, I would love to pick it up. Question, I don't know, but there's lots of them. There's, yeah, there's a whole,
That'll be good.
there's
You guys take a picture. We'll take a picture at the end. Okay.
Cool.
Thank you for Shar, I'm gonna take a picture at the end.
Okay.
Okay? Take your time.
Are you the chief of police right now?
No, I'm with
Yeah,
the
we're
Center
gonna
for
do
Police
this
and
last
Equity.
presentation.
what is-
Leon is gonna present.
You go police.
Saying I'll ask you to switch off. No, that's Sean Lawrence. He's That's okay, I'm Charmin.
Wherever you want, you can stand. Where I'm about to stand to do the introductions, or you can sit at the shrines. That's to be able to see.
Kill people throughout the country.
And Merritt is gonna give you your,
And you know what, I'm gonna reference some of this stuff. Is it okay if I send the links to you?
what do you wanna do?
Yeah, you can send it to me, I'll go post it on our site. Yeah, it's under the materials.
And I was going to create it, but I just didn't.
It's okay, you don't have to. You're fine, baby.
Do you need to show anything now?
Do you wanna pull anything up? Not at all. Okay, and you're gonna stand where you are? Well, listen, it's okay, cause Merritt is here, so she'll give you 10, 5, and 2.
Somebody went out and this is north, that whole
Oh, I should find out. Hey, Craig, do you wanna go second or third? Craig?
We have to unmute and talk to Craig. Yeah, go ahead.
I just wanna ask you.
Okay, you can talk now.
Hey, Professor Futterman, do you wanna go second or third?
Wherever you want to put it.
Okay. Okay. Sergeant Leon's gonna go first. Hello. Chief, do you wanna go first do you wanna go second or third?
So we're just we got a test lot for the positions.
Yeah.
And so we're just gonna sit there and probably present together because we're in the same place and space.
Yeah, no, I understand. No, it's absolutely fine. I just wanna know in the order of presenters, if you wanna go second or third today.
Yeah, we can go second, that's fine.
Okay, good. So Professor Futterman, you'll bring us home? I think you're up to the challenge. I know you are.
I think all the other things is we just need access to show the PowerPoint. So
You got our challenge.
Yep, I will make sure that you have access.
Something we can look it over. Can't forget about you.
Oh, thank you, sweetie. Well, appreciate it. Did you do anything I ever heard this stuff?
You can mute us. I can tell.
For our panelists that are here in person, can we, please don't leave too fast at the end. I would love for us to be able to take a group photo, if at all possible. Okay, I tried to look to see. Okay, I'm gonna roll. Can we also, I don't know if you heard, Eric, but the chief wants his access.
He's all set.
Okay, awesome. Thank you. Alrighty, thank you. We're bringing it on home, y'all. Thank y'all for staying, holding tight. Sergeant Charmin Leon has lived and worked in urban communities most of her life. She served as an assistant director of team mentoring programs, a home detention officer, served as a home detention officer for juvenile court, and a public assistance worker and system advocate for male victims of domestic violence. She joined the Cleveland Police Division of Police in February of 2008, working patrol in the 4th District, and was promoted to sergeant and investigated allegations of officer misconduct in the Office of Professional Standards. She also served as officer in charge of personnel and backgrounds and established and led the public safety recruitment team for police, fire, and EMS until her departure from the division in September of 2020. Sergeant Leone now works at the Center for Policing Equity, a research and action think tank that promotes police transparency and accountability through research, partnerships, and public discourse. Our next set of presenters will be Sean F. Barnes. Chief Barnes is the chief of police for Madison Police Department in Wisconsin. Prior to his appointment as chief in February of 2021, Chief Barnes served as director of training and professional development in Chicago, Illinois, and he was the former deputy chief of police in Salisbury, North Carolina. He was previously a captain with the Greensboro Police Department, where he began his career as patrol officer in November of 2000. He has vast experience in police leadership, serving as the commander of 4 police divisions. He also served in the armed forces as a United States Marine. Dr. Barnes attended Elizabeth City State University, where he received a BA in history and pre-law, and the University of Cincinnati, where he received a master's degree in criminal justice. He earned his PhD in leadership studies from North Carolina Agricultural and Technical State University, where his dissertation focused on racial disparities in traffic stops and the role of police leadership in community engagement efforts. With him, we have a native of Dallas, Texas. Tarek McGuire began a career in public service with the Arlington, Texas Police Department in 2003. During his tenure, he served in multiple positions before being appointed to deputy police chief in 2018. As a nationally recognized public speaker and public author, Chief McGuire has been a leading authority on community police relations, evidence-based policing, police reform, and improving public policy. In 2020, he was appointed to the Council on Police Reform and Race by the National Police Foundation out of Washington, D.C., and serves as chairperson for the International Association of Chiefs of Police Juvenile Justice and Child Protection Committee. During his career, Chief McGuire has been at the forefront of developing innovative strategies, leading national change in community police relations, affecting lives globally. In 2016, Chief McGuire served as Law Enforcement Fellow at the IACP, contributing research and technical assistance to the U.S. Police Departments on 21st Century Policing in Washington, D.C. And last but certainly not least, we are so grateful to have with us Craig B. Futterman. Professor Futterman is a clinical professor of law at the University of Chicago Law School and a resident dean in the college. He founded and has served as the director of Civil Rights and Police Accountability Project of the Mandel Legal Aid Clinic since 2000. He was elected to a Simon Visiting Professorship in the School of Law at the University of Manchester, UK in 2018-2019. Before his appointment to the law faculty, Professor Futterman was a lecturer in law and director of public interest programs at Stanford Law School. He previously joined Futterman and Howard, a boutique law firm concentrating in complex federal litigation. There, Professor Futterman specialized in civil rights and constitutional matters with a special focus on racial discrimination, education, and police brutality. Before that, he served as a trial attorney in the juvenile division of the Cook County Public Defender's Office. Professor Futterman received his JD from Stanford Law School in 1991 and graduated with the highest distinction from Northwestern University with a Bachelor's of Arts in Sociology and Economics. Please join me in welcoming our esteemed panelists for our final panel of the day.
Thank you, Professor Hardaway, and Case Law School, thank you for having me. I'm going to start my timer, and I'm so glad I did this. I timed the 20 minutes, my notes, because I could go on for days about all of the wonderful information that's been shared today, so I knew better. And I'd like to welcome my co-panelists, especially from my hometown of Chicago. All right, born and raised Chicago, Illinois, so thank you. Again, as was stated, I'm Charmin Leone, and I'm currently a commissioner with the Cleveland Police Commission. I was, as mentioned, also I was formerly with the Cleveland Division of Police, and I'm now with the Center for Policing Equity, a research and action think tank that partners with law enforcement agencies across the country with the ultimate goal of reducing disparities in policing outcomes in Black and brown communities. So my title is Exploring Solutions. And when I hear exploring, it sounds like another conversation. Like, we don't have to have more conversations. If we had listened to Black and brown communities and just believed them, we would have been here 50 years ago, 100 years ago. But we need the science, we need the research to prove that Black folks know what they're talking about. And it's not just, victim mentality and folks who are lazy and don't want to pull themselves up by their bootstraps, and if they live better and got married and had kids within, that kind of thing. It just, the death by 1,000 cuts over and over and over again is just a bit much. So it has to look different, but the good thing and what keeps me buoyed is that we have moved beyond the conversations at this point. There's a lot of people doing the work. I love coming to conferences because then I remember I'm not alone in this work. With the Center for Policing Equity now, I know I'm not alone in this work, and I also know that an agency, it is possible for an agency to be a learning institution, a thriving organization, one that supports its people along with them doing difficult work. I know it's possible. So this has to look different, as everyone has said today. Policing has to look different. The Police Commission just completed a work regarding 100 years of reform here in Cleveland. It further highlighted the stops and starts of overhauling American policing. One of the biggest developments for our community in the last 7 years was the passage of Issue 24. Sergeant Jackson talked about that earlier, which gives greater oversight powers and makes the commission a permanent fixture. Since my days in the Office of Professional Standards, I have been a proponent of civilian oversight. A lot of my former colleagues questioned and didn't agree with this type of structure, which baffles me when the very authority we are given is given and should be governed by the citizenry. We only have our powers at the consent of the citizenry. It should be extremely telling when police officers say they don't want the citizens to oversee the work that they do, when the citizens are the ones that give us our authority, but we know what that's about. There is no national certification board for police, so municipalities are left to determine structures of policing for themselves. There are cons and pros to this. The cons being no nationwide standard, with hiring, with training, with organizational structures. We talked about that earlier. And in today's environment, however, the pros may very well be that those who have the appetite and the ability to weather the backlash that always comes on the heels for the calls for reform are able to, along with their communities and local governments, determine a path forward for themselves. It's even more of a pro when reform efforts on the federal level seem to always eventually lose steam because of renewed fear-mongering, we call it propaganda, to push back against reform. Many officers and the unions that represent them take reform as a threat to our authority, our claimed expertise, and more than anything, livelihoods. During my time as an officer, the calls for Back the Blue and Blue Lives Matter was in full swing. An officer asked if I was going to attend the rally 2 blocks away from our office downtown, to which I replied that I absolutely never would. That it broke my heart that we would participate in something that was created as a direct result of our communities asking that we acknowledge the harm over-policing does to the lives and families of our communities, and we were effectively sticking our thumb in their eyes and demanding that they see us instead. They see us every day. They actually know us a lot better than a lot of civilians who joined them in those marches. I was introduced to CPE while a certified instructor with the Cleveland Division of Police. I was one of the first instructors for procedural justice, implicit bias, and legitimacy. There, I saw the clip of Dr. Philip Atiba Goff speaking about the science of bias, right-sizing the conversation from officers being inherently racist to the science of how our brains function in situations which are inherent in the profession of policing, being tired, being stressed, having to make time-bound decisions. It resonated with me because I worked with and came to know amazing men and women on the job and knew most did not have nefarious intentions against Black and brown communities when they applied for the job or when they came to work every day. So I really began following the work of CPE and advocating for the changes that would offset those risk factors that are inherent in policing. And one of the teachings in the procedural justice, implicit bias, and legitimacy, it talks about the triangle of stress for officers. You have the department, you have the street, and you have home, your family. Most officers' stress and trauma comes from the department. It does not come from the street. Most of us, can work the street in our sleep, not really, won't be awake, but we can do that all day long. It's the department. And so there's been a lot of conversation here today about addressing those toxic departments and the situational risk factors that are inherent in there that increase the likelihood of officers behaving in biased manners. I will send an email out after today with all the links to this, but if you'd like, take a look at Dr. Phil's TED Talk. The Center for Policing Equity was co-founded by Dr. Philip Atiba Goff, who's a psychologist and on race and policing, and retired captain from the Denver Police Department, Dr. Tracy Kazee, one of my sheroes. And she was also the first Deputy Commissioner of Equity and Inclusion with NYPD. So, but when I worked and tried to work with the Cleveland Division of Police in my many different roles, and at the end, as the officer in charge of recruitment for police, fire, and EMS, I became frustrated with the seemingly inability of decision makers to address these issues that would lead to better policing by addressing the internal factors. Someone talked about, the psychological background. We have that. It was trash. Everybody knew it was trash. We start working to get a new psych service. People feel like certain contracts are their right to their livelihood. So their livelihood is more important than the well-being of the community, so we have to fight through that. Cleveland has an ordinance on the books that talks about officers, all public safety, being reviewed every 2 years. They don't apply it. They don't apply it in practice. So that is there, and we're not utilizing the tools available to us in that regard. So when I did apply for Center for Policing Equity and was hired, they had just completed the creation of a new project called CompStat for Justice. Currently, it's our most comprehensive service offering to police departments. It's a partnership that lasts 3 to 5 years where we analyze their data, and then, along with a number of other qualitative analysis, we contextualize that data to pinpoint the most burdensome policing efforts that do not map onto public safety, but instead just serve to undermine law enforcement's legitimacy and trust in our communities. Other approaches to reimagining policing that's taking place across the states now, the cessation of low-level stops to burdensome policing. We talked about how disparate those are. Co-response models where mental health workers either accompany or replace police in responding to these types of calls. One is called Cahoots in Eugene, Oregon, where out of 24,000 calls for service, only a little over 300 required police presence. And that's real important. We talk about smart policing. Let's be smart about what we're doing. The first folks to talk about defunding the police were the police. We're like, get us out of these areas we don't need to be in. Stop having us, provide services we should not be providing. When someone talked about CIT and said there were officers that said, I don't care nothing about that, I'm not trying to do that, that's not what, yeah, right. So for those, stop it. Stop allowing our legislature to be lazy and not fund the supportive services that are necessary. Everybody's having a hard time recruiting now. Of course, people who are threatened by their livelihoods are saying it's because of the defund the police and backlash. Stop it? No, because they haven't been defunded. Cops are getting more money than ever, so we know that is not true. It's like it's false, right? But if we get out of those spaces we don't have any business being in, you might not need as many police as you think you do. And that's what people don't want to talk about, because this job is a right to some folks, right? Violence interrupters is another approach to reimagining policing, because we know violent crimes in communities are often committed by a small percentage of residents, and focusing on those most at risk and providing them supportive services are the approaches some communities are taking. There's also another article done about how many billions of dollars are saved when we divert folks from lives of crime and address it in a smart way using real data and science. As our areas are different with different histories, racial compositions, etc., there is no one model of public safety that fits every jurisdiction. So depending upon the leadership in these areas and whether or not their citizens are calling for a change in the way they approach public safety, they are able to reimagine what policing should look like for themselves. Center for Policing Equity also participated in work in Ithaca, New York, where they just instituted an additional department that addresses quality of life issues. A lot of burdensome policing lives in low-level offenses, where we as police throw a wide net, and many people caught in that net, in which the communities I've lived and worked in have been Black and brown people. Now, Ithaca is a city of 32,000 people with about 6% Black and brown communities. I'll also provide that link because it talks about now what the police department will respond to and what their community safety department will respond to. And as we always know, you have to, for some things it's case-by-case basis or what have you, but really taking police out of those spaces that can be better served by other support services. And I was ashamed to learn about the work going on down in Dayton, Ohio, because it's down the street. But they didn't, they took it upon themselves. The commission, the council there took it upon themselves to create police reform working groups. They imposed time-bound limitations on themselves to review and decide on those recommendations. They have a population of 140,000 people with about 38% Black and brown communities there. So I'm gonna send you the link, check it out. It is really, really amazing. I'm like, just so, go Dayton. So yeah, they did that thing. And they all worked together and did this for their community and held themselves accountable to being successful and reaching their goals. And so, yeah, that's pretty cool. So in summary, there is work being done. There is work being done. It's often bespoke on local and state levels because on the federal level, it wanes in the winds of our politics. As we know, overhauls were recently left out of the omnibus spending bill. And that's why many Black Americans remain doubtful on real police reform. So I always say, because this is an emotional labor, it is exhausting work. And oftentimes those who are most affected by the disparate outcomes are asked to show up, volunteer. This is no volunteer. Stop asking people to volunteer to do this kind of work. With the passage of issue 24, now Charter Amendment 1115, there's a stipend given. But again, the stipends ultimately, and I'm glad Judge Oliver made that acknowledgement, is still almost asking for volunteer. That is cruel and unusual punishment. And we know it's unfortunate. We are addicted to punishment in this country. We are addicted to incarceration. It's 1 in 5 in the world are incarcerated here in America. If that made us safe, we'd be safe. Pick an area and do your work. I have to compartmentalize to keep my sanity and remain effective. It's easy to get distracted and pulled into too many directions because it's all connected. But when I do too many things, I don't do any one thing well. We are constantly developing the appetite of chiefs to break from their past and embrace and employ proactive measures toward the future. It's not work for the faint of heart. When I feel weary, I think of those that came before me, where this work was a threat to their very life. And I get over myself. I think about people, another Shiro of mine, Sherilyn Eiffel, that has been at this longer than I and has been up close and personal to volumes more injustice than I ever have. And I get over myself. I think about the world that I had the audacity to bring children into, and I get over myself. So I thank you all. I thank you for the work you do. And I thank you for reminding me again that we are not alone in this work. And the work is being done. 400 years, when you look at it like that, it sounds like a long time. But if you look at it from the Kerner Commission, I think there was one commission over that, really, it's really not that. We are making strides. We are making strides, and the work is being done. And I wouldn't want to do it with better people than you. Thank you so much.
Good afternoon, everyone. I hope that you can hear me. Can everyone hear me? I guess I can't see the audience, so I'll just kind of just start and talk. First of all, I'll introduce myself, and then Chief Barnes will introduce himself. Very honored to be here today. Very honored to accept this invitation and speak with you all virtually. My name is Tarek McGuire. I'm the Deputy Police Chief in Arlington, Texas. Just a little bit about Arlington. Arlington is between Dallas and Fort Worth, a city with a population of about 400,000 people. And so before I start today, and Chief Barnes introduces himself, just a little bit about my professional background. Not only am I approaching my 20th year in policing, but also had some great opportunities over the years. I had an opportunity in 2016 to be a law enforcement fellow at the International Association of Chiefs of Police, where I worked with the Department of Justice, the Obama White House administration, to really work on police reform around the country. And they gave me a different perspective. Prior to that, I knew policing as it was in Arlington, Texas. But I got an opportunity to go around the United States, offer technical assistance, and to really look at police departments and see how they mirrored as it relates to the task force on 21st century policing and the 6 pillars that were identified. I will tell you that I am a consultant for the Department of Justice Civil Rights Division, and I also am a person that achieved a doctorate degree really looking at pattern and practice reform as it relates to reforming policing and how do we seek solutions to what the issues are. But I think it's very important that I share with you why I got into policing. As I previously stated, I'm approaching my 20th year in law enforcement. I am a part of the executive staff of our police leadership team in Arlington. But I grew up on the south side of Dallas. I grew up in a 2-parent household where I'm in church all the time, very, very
very stern father that made sure I had a clear pathway for life. But there were 2 police officers in my church who I interacted with all the time and who served as role models subsequent to my parents. And I saw how they served our community. I saw how they protected our community, the values that they had. And ultimately, when I had an opportunity, I began to work at the Arlington Police Department in 2003. So I stand here today to not only just share my academic reflections, but also to share my reflections on policing through my lived experiences. And so there are challenges that we face, but I do think that we're making progress. And as it was previously stated, you know, for me, this is not a sprint. This is not something that you check the box on, right? At the end of the day, I have sons that are growing up, and I want them to inherit a society that was better than the one that I grew up in, the same way my parents were diligent for me. So hopefully, over this next few minutes, we'll be able to share some slides and collective points. Some points may have already been made, but just share our perspective as police chiefs who are currently serving in the profession. And I'll let Chief Barnes introduce himself.
Thank you, Tarek. Good afternoon, everyone. My name is Dr. Sean Barnes, and I am so happy to be here at Case Western Reserve School of Law. My original path in life, I thought I was going to be a lawyer from a very young age, not because I like to talk or argue, but because I like to read. I grew up in housing projects in a small town in North Carolina. My grandmother was a domestic, and every summer she would bring home a new set of Encyclopedia Britannicas from the person that she worked with, and she would give those to me, and I would read them cover to cover. So I went to college, and I got a degree in history, pre-law, from Elizabeth City State University, a historically black college and university in northeastern North Carolina. Alex Haley is one of our esteemed alums. And I would like to tell you that I studied history because I thought that I could change the world, but it came easy to me, and I knew I could spend more time on the yard. Some of you know what that means. But nevertheless, I was a high school history teacher who found policing just kind of vicariously looking for that next step in my life. But I want to share with you that there's good news. And the good news is there are a group of law enforcement executives, mid-level and upper-level executives. We're called National Institute of Justice LEADS Scholar. And LEADS is an acronym. It means Law Enforcement Advancing Through Data and Science. And we're a part of that group, Tarek and I. There are many others throughout the country that are a part of that group. And what we do is we try to use data and science, qualitative and quantitative data, in order to inform police reform practices. So there is good news. I too am a Department of Justice consultant with US DOJ Civil Rights. We're working on a few cases now that you may have heard of, but we can't speak of. But just know that there is good work being done. My research, my original research, deals in the area of racial disparities in traffic stops. And the reason I chose that is because as a black man in America, I have been the victim of racial profiling. But as a police chief or as a police captain at the time, I had to question what my role was in this problem. And I think if we had more police leaders willing to question, how do I contribute to this? And how can I use data and science to inform decisions? I think we'd be in a much better place. So I have research in also in officer safety and wellness, qualitative study. And my first original research was in the area of technology, looking at something called predictive policing and the impact predictive policing would have on communities. I am currently the chief of police in Madison, Wisconsin, which is the capital city, and I'm very proud to be there. We have a number of, I don't want to say reforms, because that may not be what I really want to say, but we have a number of initiatives that we're focusing on that are community-led, that are evidence-based, and I think, that you will see the Madison Police Department as a national model for exceptional policing. Now, I know Tarek comes from Arlington, and he wants to brag on Arlington, but let me say that through my leadership and through symposiums like the one we are attending right now at Case Western Reserve University School of Law, I do believe that the Madison Police Department will be that example that the previous speaker spoke of. All right.
So we have about 9 to 10 slides that we want to go over rather quickly. And the Sergeant just talked a little bit about this, but we really want to evaluate the impact of federal inventions as it relates to critical incidents in the 20th and the 21st century, and understand the impact that federal legislation had on American policing. And then I think what is most pivotal that Chief Marshall will talk about is the lessons learned from Selma, Alabama. You know, we always talk about bridging the gap in policing. And we've seen historical periods that have defined changes within our country. But I also want to tie that into this project that we're leading nationally right now that we will launch in Washington, D.C. this summer, the 54th Mile Policing Project. And so if you just bear with us for a few moments, we'd like to go through several slides and just talk about historically where we think key moments have been in policing throughout the United States and where we are at today. So Sergeant just talked about this a few minutes ago. 1968, the Kerner Commission, right? We knew that in 1967 there was national rioting as a result of impoverished communities. We saw a lot of national excessive police use of force, particularly in major cities. And then ultimately, we know that the impact was in disenfranchised communities, again, where people lack social resources and reform. And so that executive order was signed by President Lyndon Johnson, right, that established a National Advisory Commission on Civil Disorders to evaluate policing and other social issues during that time period. Then in 1994, President Bill Clinton signed the Violent Crime Control Act, which gave the Department of Justice authority to go in and investigate alleged police misconduct. And I bring that to the point because a lot of times in which we know people attribute this Violent Crime Control Act to what we have saw in mass incarceration. We know that Violent Crime Control Act also spoke about 3 strikes rule, right? That people were really arrested on their 3rd strike and given longer prison sentences that were also inequitable. But it brought a pivotal point. So identifying 1991, we know that America saw one of the most horrific national televised incidents as related to use of force when we saw Rodney King that was beaten by the LAPD. And so subsequent to that, again, a good point from this legislation outside of what we know that were bad points of legislation was that it gave the Department of Justice the authority through Section 14141 to begin to enact federal consent decrees as it relates to law enforcement. And then, as I stated previously, in 2016, which started in 2015, President Obama signed Executive Order 13688, right, which established a national task force that was called the Task Force on 21st Century Policing. Again, we see a pivotal issue in our country where we saw civil unrest as related to an African American being shot, not actually shot, but there was an African American that was actually shot and killed in Ferguson, Missouri. Now, there are some interesting factors that came out of the Department of Justice investigation in Ferguson. Outside of what happened with Michael Brown, we also saw that there were inequities, racial inequities, as related to fines and how the city of Ferguson, again, treated Black and brown communities. But a good thing that came out of that was the 6 pillars on 21st century policing. And I won't go through all of them, but more specifically, Pillar 1 and Pillar 6 has a profound impact on policing. Pillar 1 focuses on building trust and legitimacy between law enforcement and communities. And then Pillar 6 that focuses on officer safety and wellness. And why are those important? Because if police do not have the trust of the community, then I believe that it reduces the likelihood of officer safety. And so we know that when police do the right thing, when they treat people with equity and fairness, that the outcomes are more favorable for community health. Then most recently, the George Floyd Justice and Policing Act, which was not passed, it really proposed comprehensive legislation surrounding police accountability and trying to address not only the overall culture of policing, but also empower communities to address systemic issues centered around racism and bias. It focused on trying to establish a national standard for police departments. I think the sergeant talked about this a few moments earlier. You know, I've traveled all around the country, and again, I would like to think that police departments operate in the same way. But the most important reasoning why it is important for there to be collective efficacy in trying to address these issues is that police departments police the way, or should police the way that their communities desire. We are the United States of America. We do not have a national police force. Police forces are catered to communities in the areas that they serve, and that's what we should reflect. And so the last thing that I will just say on this slide is that it focused on the reprogram funding to invest in transforming community-based policing programs. And while the conversation around defunding policing can really be argumentative or be very subjective, in my experience when I've traveled throughout the United States, what I've heard from communities are that really police are important to them. They want police around, but they want to be policed in the fashion that is constitutionally sound. But ultimately, people also are looking for their local governments to reinvest in communities where there have been challenges for years to bring up those equitable environments to create fairness and what we would like to see through economic progress. So I'll transition this conversation to Chief Barnes to really kind of center the focus on what we're trying to do right now and to talk about can policing be transformational.
Absolutely. I think policing can be transformative, but we all need to understand one very serious fact is that reform, change, leadership is necessary, but it's also dangerous. And there are a lot of things that can happen along the way, and you have to be resolute in doing that. It's important to realize that there are about 18,000 police departments in the U.S. The average size of a police department is about 5 to 25 officers. In Arlington, they have about 700 police officers, and in Madison, we have about 500. We're notwithstanding. Most of the police departments are very, very small. So when we talk about collaborative reform and the role of law on policing, you have to remember that. Because if you're asking for a reform that they cannot afford, that they don't understand, you have to get at that very small micro level of policing to see that. I personally had not heard of Ferguson, Missouri, excuse me, until Michael Brown. I had heard of Sanford, Florida either, even though that did not have to do with policing. I had not heard of these areas, but we know where they are now because anything can happen at any time. Collaborative solutions are certainly needed. Too many times, police departments have become the one thing that everyone focuses on. But we know that the criminal justice system, or as Herbert Packer called it, the criminal justice non-system, is based on cops, courts, and corrections. And all three need to be reformed at the same time if we are indeed to see the type of reforms that we're talking about here today. If you want to see a solution, then everyone has to come to the table. Many police agencies have adopted national standards, but communities still experience excessive use of force and lack community transformation. I will tell you that the culture in police departments is very strong and resistant to change. Let me repeat that. Cultures in police departments are very strong and will resist change. And when you have police chiefs, when you have community members that want to do things the right way, they will come under attack. It is imperative that you as lawyers or future lawyers or those who are involved in the law support those leaders who are trying to do the right thing, because you can learn just as much from a success as you can from a failure. Bridging the relationship between police and communities is important now more than ever. We'll talk more about that. So, why do we say bridging? Tark had an opportunity to go to Selma, Alabama, and he had an opportunity to take his two small children across the Edmund Pettus Bridge. And while there, he began to understand and research about what exactly happened on that bridge. And I think it's one of those things in history that most of us know about, but we haven't had an opportunity to simply learn about. We know some of the more famous names, but do you know the name of Jimmy Lee Jackson, who was shot unarmed by an Alabama state trooper who was simply following orders at that particular time? Now, events today are nationally televised, which affects the consciousness of America. We can probably all remember where we were on 9/11 and what we were thinking. Consequently, we can probably remember where we were when we saw the George Floyd incident. But we didn't see or didn't understand what happened on that bridge with Jimmy Lee Jackson, a 26-year-old deacon who was shot trying to protect his family, his mother, his wife, and his small child. National legislation and federal support is needed to help enact use of force changes within our country. We need attorneys to push forward for federal legislation. And if you can't do that, then what you do is you say, if you want federal grant dollars, whether it's community development, whether it's something that has to do with transportation, if you want federal dollars, your police department must be enacting these particular reforms. Tarek spoke earlier about the President's 21st Century Task Force on Police. My only criticism of that report, and I was a part of Pillar 6, Officer Safety and Wellness, my only criticism is, why was that report not attached to grant funding? It is now. We received a grant in Madison to hire 6 officers specifically for Pillar 1, trust and legitimacy. Those officers cannot be used for enforcement. We can't use them for traffic. We can't use those officers for anything other than building trust and legitimacy. And so my thought with those officers is to do something around adverse childhood experiences. Oftentimes, police are the first persons to see outside of family a child that experiences, witnesses, or is a victim of a trauma. It's our responsibility to connect that child with services. So I intend to use my officers for Pillar 1 to help bridge that gap, to decrease the ACE score of children in Madison. After the death of George Floyd, which we talked about, myself, Tarek, and another one of our police leaders, Dr. Obed Madney, who's now in Las Vegas, but originally from Sacramento, we traveled to Selma, Alabama. We actually spent the day at Brown AME Chapel. We met with Pastor Leota Strong. We got an opportunity to look through archives and stand at the diocese where so many great civil rights leaders stood and reflect on where we really are with this issue of police-community relations. We know that at that time they were trying to raise the consciousness of America by walking 54 miles from Selma to Montgomery. And the following day, Tarek, myself, and Obed started walking. And it took us about 3 days, but we walked from Selma to Montgomery. And along that area, along that travel, we began our journey of self-discovery. We are 3 black men who live in America. Please don't think that because we wear a uniform and a badge, we don't live in the same America that we grew up in. And so we had an opportunity to see people who stopped by to talk to us while we were walking, white, black, male, female, police officers, truckers, who offered support, who offered guidance, who told us continue to tell your story, continue to fight for us, because we need more people in law enforcement like us. And so along the way, we began to take photos and cell phone videos and camera footage and things of that nature. And what came out of it was an opportunity to create a small, short documentary that we're going to premiere this summer at the National Police Memorial Fund Museum. Because experiences like that, they have to be shared. And we're, it's no cost to it. We're not trying to sell anything. But it's just an example of the work that's being done. And every time I see the film, it helps me out a lot. And so we're developing a curriculum that will be focused on the lessons that we learn and lessons that are learned from Selma about communication and building a pathway forward to improve communities. This is really, I think, the first curriculum of its kind to share the experiences of African Americans on an incident in this country. That's curriculums around the Holocaust Museum that police departments can go through, which helps them out tremendously. But this will be the first, I think, to demonstrate a lesson, a historical lesson, and then a current perspective about that. Tariq, did you want to say anything about the law before we take questions?
No, I think, you know, I can tell you this. You know, in the city of Arlington, we had 30 days of protest after George Floyd. And we have a very supportive community in the city of Arlington, and we work to try to improve the entire community on a daily basis. But going to Selma and walking 2.5 days, 20 miles a day was very transformational for us. And 3 things came out of that experience when we reflected on it. Number one is I see you. You know, when you talk about, as the sergeant just talked about earlier, Blue Lives Matter, I think that we as a country have defined ourselves through hashtags and self-expression that way. But people were saying 3 things to us. I see you, right? We want you to acknowledge what has happened. We as a community, we as a nation must acknowledge what the issue is. The second thing is I hear you. I hear you really means that we must follow with some type of action. We used to talk about building trust in communities. Now we think that people, and we know that people want accountability and transparency before you can even talk about building trust. And the last thing is we're in this together. You know, we know what the problem is, but I'm in a state and age now as it relates to my law enforcement career where I'm focused on solutions to create a better society again for my children. And so we hope that this is going to be nationally put out. We hope to see federal support behind the film through the BJA and other entities. And we hope that you will support it. And again, we're honored and look forward to answering questions after the next presentation.
Professor Futterman?
Professor Harwood. It's a late fall afternoon. I'm about to quit work for the day when my phone rings. And it's someone from within law enforcement in Chicago who's calling, asking me for some help. They tell me about a police shooting. 2 officers had driven up on a 17-year-old boy who had a small knife in his hand. Within seconds of jumping from the car, one of the officers shoots the boy as he shies away from the officer toward a construction fence in an abandoned industrial area in the city. The officer pauses as the boy falls to the ground, then adjusts his aim, and he empties his magazine into the boy's body as the boy lay on the street writhing in pain. 16 shots. They tell me it looks like an execution. He shot that boy like he was a dog on the street. End of this video. They're worried, and they're calling me because they're worried that the shooting was already being covered up at this point like so many others. And they please help me do something to keep this from getting bigger. We gotta put a stop to this mess. The boy's name was Juan McDonald. That call, folks, led to a series of events that created conditions for the greatest opportunity for transformational change in my lifetime. Good afternoon. I guess there's no, on Zoom land, I guess there's no response, but good afternoon, y'all.
Good afternoon.
All right. What's the good at the end of the day on Friday? Thank you for bearing with me. Well, y'all, just a couple of weeks ago, I got another call. And this time I was about to leave the country with my wife for a much needed vacation. And this call was from Brian Adams. He told me about this amazing symposium on a matter that's so central to who I am, what I do, and he asked me if there's any way I could learn about it. And if it was anyone other than Brian, there'd be no way I didn't think about it. I never even think about trying to do something such a short turnaround just after I returned to the country. But it was Brian Anderson, so I had to find some way to be here, albeit virtually. I consider it an honor to be with y'all, and thank you for your kind introduction, Professor Harwood. I know y'all know this, but the city of Cleveland and Case Western Reserve Law School is blessed to have someone like Brian Adamson there. He is someone who I consider to be a mentor, teacher of teachers, and someone who's tirelessly fought against injustice wherever he is. So I promised today that I promised Brian that I simply wouldn't talk about problems. And in return, he put me on this panel called Solutions. But I don't want to overpromise and underdeliver. But I promise Brian and I promise y'all here that I'll offer at least one solution that confronts the reality of racist and violent policing. To get police to stop harassing, beating, and killing so many Black folks, so that we're not playing Marvin Gaye and having this conversation again 50 years later. So to help me to do so, let me first take you back to that confidential call just a few years back. That call about the police execution of Paul McDonald came to me in the context of a couple of things. First, it came in the context of decades of utter police impunity in Chicago, documented history of torture of Black men in police interrogation rooms, decades of racism, brutality, false arrest, denial. Second, the call came in the context of a civil rights clinic that I directed at the UC Law School that focuses on race and police accountability, the clinic that Professor Harder told me all about. And for the past 22 years or so, my law students and I have been working alongside individuals and families in Chicago who've been most impacted by police abuse. Now that call, however, it wasn't the first thing that I heard about the shooting of Paul McDonald. Indeed, I remember reading a blotter in the press just a couple weeks earlier, shortly after Paul had been killed, and it presented a really different story from what that caller told me. And it read like hundreds of others, and I'll quote to you from it. Quote, squad car responded to a call someone was trying to break into a car in an industrial area. Officers found the boy with a knife in the street. He ignores their commands to drop the knife. He lunged at the officer with a knife, putting the officer in fear for his life. The officer shot him once in self-defense. End quote. Sound familiar? Stories like these appeared several times a month in Chicago media, and the basic elements were pretty much the same. Black person shot by the police on the scene say the shooting is justified, then the authorities rely on 3 words to deflect any further inquiry. Y'all know those words. It's under investigation. The internal investigation operates as a critical part of the city's machinery of denial, reifying the official narrative. They proceed quietly outside of public view, often take a couple years or more, designed to lead to a common result. And indeed, in the 7 years leading up to Laquan's killing, Chicago police officers killed more than 400 people. Let me say it again, killed on an average of more than 1 person a week. More than 75% of the people killed by police in Chicago are Black. None of those killings were ever found to be unjustified. So back to that phone call. I had lots and lots of questions for the caller, and while I never saw them leave at this point, they want me through it frame by frame over the phone. And my students and I began to investigate. We began to go out to the scene, try to investigate what happened. We partnered with a longtime collaborator, a writer by the name of Jamie Calvin. Again, we go to the scene, we walk through what the confidential informant told me, we take photos, we map out events, we hire a private investigator to work with us, and we interview a number of witnesses to the killing. Everything the source told me checks out. Completely different reality from the narrative that the police department shared with the public. And now this is back in December 2014, now post-Ferguson, after Ferguson. And while at this time there's national attention to police killing of Black people, no one at this point is talking about Paul McDonald. He was awarded the state. There are a few people beyond some family members, a few family members and us, who are raising questions about the high school student's death. We're next able to get a copy of Laquan's autopsy from another confidential source. And contrary to that official narrative, single shot in self-defense, we learned that Laquan was shot 16 times. Just again, like the source told. Each shot where each gunshot would enter the boy's body and share our findings with the public, and again, call for the release of the truth, the release of the video. Major media begin to take some notice of what we're doing now. But their notice only went so far because it wasn't major media, but Brandon Smith, who was this young independent journalist inspired by the Black Lives Matter movement, who had the courage to actually hire us, and then attorney Matt Topic, hire us, should use loosely, pro bono, for free, to take the city to court, to sue the city to release this video. Shame the devil, tell the truth. 13 months, city stood fast behind its official story. Just another justified shooting by a police officer of self-defense. Until we won that court that required the city to actually release this video to the people. this point, y'all, I'm sure remember that Chicago becomes a leading national story. Protests engulfed Chicago's magnificent mile on Black Friday, big shopping day of the year. Young black folks used to that video of a police officer firing those 16 shots into the body of a 17-year-old boy as he lay bleeding in the street, contributed to a national awakening to the reality of police abuse in black and brown communities and the code of silence that protects it. We didn't simply expose the horrific execution of a black child at the hands of a police officer, but what we helped to expose was the routine machinery through which the police department hid and justified systemic violence against black people. The whole world at this point is taking notice. After we forced the police department to release that video, guess what? The local prosecutor has no choice but to file criminal charges against Officer Jason Van Dyke. Charges were filed the exact same day the video becomes public. Another way of saying this or looking at this is that the state's attorney, that's what we call prosecutors in Chicago, the state's attorney never charged Jason Van Dyke for any of those 16 shots captured by the video until the day before said video would be released. So we later filed a successful petition to appoint a special prosecutor independent of the local state's attorney to prosecute Vaughn's murder and the cover-up. And as y'all know, this results in the murder conviction of Jason Van Dyke, the Chicago police officer who fired those 16 shots into Vaughn's body. This was the very first time ever in Chicago that an on-duty Chicago police officer had ever been held criminally accountable for killing a black person. About 7 years ago, I convened a small group of Chicago civil rights and leading civil rights advocates. And we met with Tom Correct, who at the time, Tom headed the Civil Rights Division, to discuss our petition for DOJ intervention in Chicago. And Tom was joined by one of our former students who was then serving as one of President Obama's chief advisors. Chicago Police Department at this time killing and abusing at least as many black people with the same or greater degree of impunity as they were at the time that we forced the public release of the video of the police murder of Juan McDonald. But despite many of the well-meaning folk of the White House, DOJ, they just kind of shrugged. And they apologetically told us, my former student as well, that they simply couldn't afford to tackle something as big as Chicago. Even President Obama didn't have the will to try to take on the Herculean task of addressing police abuse in his adopted hometown, until he was forced to do so about 7 years later. And over those 7 years, because those 7 years mattered, those 7 years really, really mattered. Over those 7 years until we wanted the release of that video, more than 350 people were killed by Chicago police. Thousands of black people were beaten. Many more were wrongly arrested and prosecuted. So in late 2015, as the entire world was transfixed on Chicago and this execution of the 17-year-old boy, we petitioned the DOJ again. We got to come to Chicago. And this time, the DOJ has no choice but to finally respond to our newfound promise. They then launched the largest civil rights investigation in the history of the DOJ. And in December 2016, the very tail end of the Obama presidency, the DOJ issues its investigative findings that document what black folks in Chicago's community have viscerally known for decades: Chicago Police Department's systemic abuse of black and brown folks. It also announces that it had entered a written agreement with the mayor to negotiate a binding consent decree that would result in federal oversight of the police department. But, however, after documenting CPD's pattern of practice of brutality and discrimination, DOJ did something equally historic. With Trump concessions in, federal oversight of the CPD down. So once again, it took the people in the community to step up. And this time, so it's Black Lives Matter Chicago, the Urban League, the NAACP, Latinx neighborhood organizations, women's advocacy groups, and others who've been most impacted by police abuse across the political spectrum. And we do what Trump and his Justice Department refused to do, and that's enforce the Constitution of the United States of America. And together we bring a community-based legal challenge to the police department's unchecked pattern and practice of brutality in black, brown, and poor communities. We seek what's called a permanent injunction, the appointment of an independent monitor, the federal judicial oversight of the Chicago Police Department, an injunction enforceable by the people who've been most impacted by police abuse, kind of injunctions that both chiefs, McGuire and Barnes are working on present in other states. The problem, though, is that the U.S. Supreme Court in 1983, in a case that's called Lyons v. City of Los Angeles, robbed people who have been most impacted by systemic police abuse the right to sue police departments for change. While folks may sue the police for money, the Supreme Court stripped victims of police misconduct who've already even asked the court to order the police department to stop violating their rights, much less ask the court to order the police to actually change what they're doing. And as our Chicago experience had long proved, the police department would rather pay hundreds of millions of dollars to police misconduct victims than actually be forced to change what they do. And indeed, Chicago's paid in excess of $500 million as a result of police abuse in the last 10 years alone. Lyons' case was about a young black man's attempt in LA to stop the LAPD from putting black folks in chokeholds, often killing them, and after the LAPD actually choked this young man, Adolph Lyons, choked him unconscious, broke his larynx, all for the serious crime of driving to burn down Tower. Black men stopped by LAPD 20 times more likely to be choked than a white man. The Supreme Court bill said, tough luck, Mr. Lyons. You can sue LAPD for money, not for change. In the nearly 40 years since Lyons came down, federal courts have repeatedly dismissed lawsuits by people, ordinary people, people who have experienced seeking change, people trying to sue police for injunctive relief. So as a result, back to Chicago, the mayor and CPD knew, shoot, they could continue to fight court order change in Chicago. And they did. That was until we persuade actually the state, the Illinois State Attorney General to join our fight, created another national precedent. This is one of the first times in U.S. history that a state attorney general ever brought a federal civil rights case seeking to enjoin a pattern of civil rights violations by local law enforcement. You see, unlike people in the community harmed by these practices, the government, as both chiefs were just talking about, under that statute, 42 U.S.C. 14141, the 1994 statute, the government generally has the power to sue the police department for court order change, but typically these lawsuits have been brought by the federal. So the state agency's intervention in Chicago did prove to be the straw that broke, needed to break the mayor's resistance to a decree. But also brought a new set of challenges. Because instead of joining our community letter, the AG files our own lawsuit. Good news is the addition of the Illinois Attorney General brings the city to the table. Bad news is case was excluded from the table. Community. We're not allowed to be in the room where it happens. Instead of the community leading effort, the consent decree negotiations devolved and become a two-party negotiation between the mayor and the agent, political incentives. Notwithstanding Donald Trump, notwithstanding the police union's efforts, and there were some strong efforts by the FOP, the Fraternal Order of Police, to fight court oversight in Chicago, backed by the Trump administration. So not just 180 can be changed, not just advocating the responsibility, but actively opposing any federal oversight of the police department in Chicago. Notwithstanding that, aging the city negotiates a consent decree that incorporates at least some of the stuff that people have been fighting for. In early 2019, just a few years ago, after an extended public hearing, the U.S. federal judge actually approves the decree. We won a consent decree in Chicago. But what's more, and this is historic, because we won the power to enforce the decree in court. And when I say we, I'm talking about that same coalition who brought that community-based lawsuit. We won the power to enforce the CPD consent decree in court, direct line of independent monitor, federal judge for what could be the next decade or more. This is the first time that community enforcement has ever been written into government consent decree with the police in the United States. However, and I'll try to get to the point. Decree falls short in a number of foundational ways. Why? Because it excludes the people most affected from bargaining. And while the decree granted the community coalition these enforcement powers that I just raved about, it denied the community coalition party status along with the right to the kind of discovery that would enable folks to serve as effective guardians and monitors of the decree. So that means the community remains on the outside looking in, while the CPD continues to resist change. No surprise. Chicago's experience with consent decrees, federal consent decrees, far from unique, because no doubt DOJ decrees have led to some meaningful reforms in police departments around the nation. Their ability to actually change what's happening on the ground has been severely limited from a common fundamental law present in every one of these decrees, exclusion of the community. DOJ-driven processes meant people who've been most impacted by police policies and practices, people most knowledgeable about the problems on the ground, lack the legal power to actually meaningfully participate in these cases. And indeed, I'm not aware of a single instance in which a community organization, much less an actual victim of this misconduct, has been allowed to actually intervene as a party in a civil rights pattern and practice that is brought by the DOJ. Community orgs and actual victims of police misconduct have been consistently excluded from occupying any empowered seat at the table during the legal process. Like us, they don't get to be new Americans. And like us in Chicago, the folks most impacted by police practices are denied the power to access the information they need to serve as effective monitors, denied discovery rights in the system, and the very system in terms of how it best succeeds in resisting change is by the ability to control information, by secrecy, by denial, by lying, by denying people on the ground the very information that folks need to call on. And so the results are pretty unsurprising. By excluding folks who know the most about the nature and cause of the disease and denying the power to do something about it, we get remedies that fall short. Remedies that may attack the symptoms, but often fail to address the underlying causes of police impunity in Black and brown communities. So let me end with my promise of not now obvious solution. Just as it gave the U.S. Attorney General in 1994, Congress must enact new civil rights legislation, a new civil rights law that expressly gives people injured by police policies and practices the legal standing, the legal power to actually seek injunctive and declaratory relief to end those unconstitutional practices. The power to stop this mess. And folks, it's our job to make this happen. If there is one thing that I've learned in my 22 years in the clinic, it's that things don't change by themselves. They change only when we make them change. Thank you for giving me this time.
First, let me thank all of the speakers for a really good session, and let me thank my friends and colleagues, Brian Adams and Aisha Hardaway, for putting together such a wonderful program. I have a specific question for Professor Futterman, and it goes to your last suggestion about having Congress pass legislation that would give members of the community the ability to seek injunctive relief. Putting aside the political challenges of getting such legislation enacted, what are the prospects that the Supreme Court would uphold such a provision in the wake of its restrictive approach to standing in the TransUnion case a few years ago, which said that Congress is limited in the extent to which it can create causes of action?
I could only hear part of that, but a couple things that I heard is one, the question goes to, will the Supreme Court fix this? Heck no, we know how. Now this Supreme Court is not going to overturn lines. In terms of Congress's ability, in terms of its power and its constitutional power to enact something like this, it's the exact same power that Congress had and did indeed exercise back as Chief McGuire and Chief Barnes were speaking back in 1994 and giving the federal government, the Attorney General, the power to bring these kinds of suits. So I have, and there's a short question: is there any question about the constitutionality and ability, putting aside politics, and that's a big thing to put aside, that Congress has the power to do, but there's no doubt that Congress has the power to do this. And the reality is, because I've also lived a life, and so many folks who've come before me and taught me and showed me this about just every time when someone says can't be done, or at least you see it's down on the cell, nothing's happening with that, can't be done, won't be done. People who came before me and in my lifetime have built a legacy on every time somebody said you can't do this. And so I'm not about can't. And this is what we need to do. And what we need to do is the right thing, the moral thing to do. And that's to give people who've been very most impacted by these policies and practices. It's just like oversight for police. The power to actually do something, not just to sue police departments for money and to sue police departments for lots and lots of money, but actually the power to have a hand and a real and powerful hand in doing what's necessary and forcing the kind of changes that are necessary, being at the table.
I don't know if there was another question, but Professor Futterman, I'd love to talk with you a little bit about this. So to the extent that Congress isn't going to pass new legislation, regardless of what the Supreme Court would do with it, I wrote a piece a couple years ago about creating a seat at the table for litigation, such as much like what you're talking about. And it talks about how I believe the circuit courts across the country have gotten the adequately represented standard wrong as it relates only to, guess who? Impacted communities trying to intervene into 14141 or what's now 12601, right, litigation. And there is precedent, right, in the immigration context and in the environmental context, right, where individuals are able to say, the federal government does not adequately represent my interests, and because of that, I must be a party to this litigation. We know that courts have allowed police unions to intervene in 14141 actions in a handful of times across the country, but not once ever have. And so I know part of what you're thinking about with the injunctive relief is also, the purse and the change, if you will. But I just wanted to, number one, bring that to your attention because I think in response to my esteemed colleague Dean Hinton's question, right, there might be an opportunity to have some circuit success, right, with the right case. Now, what happens if it's appealed to the Supreme Court? Who knows? But by that time, hopefully the litigation is done and the people have been at the table. The other thing I wanted to just ask you about sort of your on-the-ground impression of how things are going in Chicago now, right? So 1980s, 1990s, we see the atrocities under the leadership of John Burge, right, and his torture. And I remember a colleague of ours at a conference saying, we just couldn't believe, it was so horrendous. No one believed, right, that could have been happening. And I said, no one believed. You mean people in power didn't believe, right? Black people always know what was happening to our family members, our loved ones, and to our bodies, right? So and then fast forward and we have Laquan McDonald, and it takes you in your clinic getting, right, this secret telephone call to have you start to pick away and pull at this thread to reveal to the nation what actually happened to that young man. And I'm just wondering, now that's been, 8 years, my math is bad, right? That's 8 years ago. I'm wondering if you get the sense that on the streets in Chicago, whether or not folks are still reverting back to the we just can't believe as it relates to what's happening in community, because we know that the Chicago Police Department is still the Chicago Police Department. And so I'm just wondering if folks are seeing them for who they are, or are we still back at a place of we just can't believe it?
Well, like with all progress, there's a transformational moment or potentially a transformational moment, and one step forward and then often 2 steps back. on the heels of President Obama is President Trump. On the heels of nationwide protests, probably the greatest social change movement in this nation ever, following the murder of George Floyd in Minneapolis. If you look now, what was the present conversation in politics about passing criminal reform law? That had a lot of appetite. The pushback is all about the violence. What I can, and back to, we can't take our eyes off the sparrow on the old Martin Luther King quote about the arc of the moral universe. But in terms of stuff that, I mean, a really quick thumbnail in terms of what's changed, what hasn't. Good news so far. I mean, the best news is that, so I shared that at the time when Jason Van Dyke killed Laquan McDonald, police in Chicago were averaging killing someone, more than one person a week. Still killing far too many people, but it's about a quarter of what they were killing for. Use of reported force is also down about a third from what it was. So the actual scrutiny, the actual opening up to the police to public scrutiny is mattering, and it's changing behavior. One thing that hasn't changed, and one thing that hasn't changed at all, is who are the victims and survivors of police abuse. To this day, and on at least a 10-to-1 ratio, who's being beaten by the police, who's being subject to force, Black folks. Hasn't changed. And in terms of the lessons that one would hope that we would learn, particularly in Chicago, from the release of the video and hoping back the release of the video of the ownership of Laquan McDonald. I won't share the story, but y'all can take a look at a horrific police raid that became public last December of a Black social worker in Chicago, in which she was naked when 12 armed officers came in at gunpoint, held her naked, wrong home, wrong bad raid. And then just as Laquan McDonald knew political administration, hid the video, lied, and continued not to tell the truth about what happened again in this raid for us. So the state of trust in police still remains in Chicago, particularly in Black communities, at pretty much an all-time low. And as a result, also police have been, and as violence has went up with COVID, police have been feckless when it comes to being able to solve violent crime and investigate. Without that trust, it's a near impossibility. Lastly, community still remains on the outside looking in, and what's obvious from the stuff that I've said is that, sadly, so while there's been some progress, it's been really slow progress, and what we've seen more than anything else is still a police department in denial, and a police department that is actively resisting change, led by the virulently racist police union, who are big fans of the modern code.
This is more of a comment or a solution. It's not that they did not know what was going on. They knew what was going on, but the powers that be, that's why it's called his story. It was his story. But now that we have started doing pushback, not just Black people, but people of all nationalities and colors and everything, they came out and marched and taken a knee. Oh my God, who took a knee and was quiet about, like, taking a knee was so offensive, but what Derek Chauvin did, taking a knee on George Floyd's neck, they feel like that's a comparison. There's no comparison, and it's no longer can they gaslight us and make us think that it's our imagination.
Well, I want to thank everybody for spending the day. This has really, really fed my soul. I know it is a heavy haul to be in one place all day long, and so I don't count it lightly that you guys chose to be with us today. I want to just thank Eric Seiler for his amazing help and work. to our last set of panelists. Boy, do I appreciate the fact, Professor Futterman, that you answered Dean Adamans' telephone call. Sergeant Leon, my sister friend, you know I'm always grateful to you. And Chiefs, I know it was, you all were my first email for this conference. You were my very, very first email for this conference. And so I appreciate the fact that you hung in there with me to make the, to make an appearance here today. Thank you both for everything that you're doing, and I look forward to watching the film. And with that, we will wrap. I'm sorry. He's standing right here.
I just wanted to thank the panelists for wonderful, wonderful insights and information and very moving and powerful education, letting us know about the things that need to be righted, the powerful inspirational stories and history and experiences that you allowed us to feel and experience with you, which is just so powerful. Thank you, Ms. Horn, for being here. Thank Law Review for this gathering, my friends, my colleagues here, especially Professor Hardaway, and especially Mr. Futterman, Professor Futterman. Beautiful to see you, and all the rest. Thank you very much. And with that, we conclude. Thank you so much.
We're going to take a picture outside, if you will. We have a